Welcome. I now declare open this hearing of the Senate Legal and Constitutional Affairs Legislation Committee for the supplementary budget estimates. The Senate has referred to the committee the particulars of proposed expenditure for the 2024-25 for portfolios of Home Affairs and Attorney Generals and other related documents. These are supplementary budget estimates, proceedings and the outcome to be heard during today's estimates are from the Attorney General's portfolio. The committee has set Thursday the 19th of December 2024 as a date by which answers to questions on notice are to be returned. The committee has also decided that written questions on notice should be provided to the Secretariat by 5 p.m. Thursday 14th of November 2024. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to the committee, and such action may be treated by the Senate as a contempt. It is also contempt to give false or misleading evidence to a committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you need assistance, the Secretariat has copies of the rules. The Senate, by resolution in 1999, endorsed the following test of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy, shall be given reasonable opportunity to refer questions asked to the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I particularly draw the attention of witnesses to an order of the Senate of the 13th of May 2009, specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirement of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest that could result from the disclosure of the information or the document. I remind all senators that as we continue to our work implementing the Set the Standard report, as chair, I will ensure the proceedings are conducted in an orderly, respectful and courteous way. Officers called upon for the first time to answer a question should state their full name and the position for the Hansard record, and witnesses should speak clearly into the microphones. Mobile phones should now be switched off or turned to silent mode. I welcome the Senator, the Honourable Murray Watt, representing the Attorney General. I also call officers from the Attorney General's Department in relation to cross-portfolio, corporate and general matters. Minister, would you like to make an opening statement?
No, thanks, Chair.
And Ms Jones, would you like to make an opening statement before we go to questions?
Thanks, Chair. No, I won't make an opening statement.
Well, great. We'll get started straight away then, shall we? Senator Cash, you have
Thank you very much, Chair, and good morning, Secretary and Minister. Chair, a query. I have some questions in relation to money laundering. I just couldn't get guidance yesterday. Are they better asked in Integrity International or National Security and Criminal Justice?
That would be National Security.
National Security, thank you. So I will just put them there. Thank you very much. Secretary, and I'll just table for the committee's benefit, just so it's on the Hansard properly, the letter from Coalition Senators to you and your response, and thank you very much for your response. Just in terms of the request for information, one of the issues that we had raised and asked to provide was a list of all ministerial submissions created between the 1st of May 2023 and the 24th of May 2024. Were you able to identify those submissions?
Senator, I'll ask Cameron Gifford, our Chief Operating Officer, to come to the table
Thank you very
to assist
much
in answering those questions.
Good morning, Senator. Cameron Gifford, Chief Operating Officer. Yes, we have been able to identify those submissions.
Thank you. Can I just confirm it wasn't produced in the list that we received from the Secretary in response to our letter?
Yes, Senator, that is correct.
We've asked repeatedly now for that information. We asked in February, we asked in May of this year. The only response we've received to date is a reference to an unrelated FOI request. So can I just confirm, you have produced the list?
Yes, Senator, there is a list of the ministerial submissions within the scope of the Coalition
Right.
Senator's request.
But you have not produced the list to the committee despite the request from the Coalition Senators?
That is accurate, Senator.
Okay. Secretary, can I ask why the department's refusing to provide that list, given that we've requested it on several occasions now? You've clearly identified and produced the list, but there's no response to it. Or should I ask, are you able to table it now? That might actually get over the further line of questioning.
Senator, we aren't able to table it now.
You are or aren't?
We are not able
to
table it now. Thank you for the chance to clarify. You have asked on several occasions for that list. On each occasion when you have asked for the list of ministerial submissions, we have indicated that we were progressing that request via the Freedom of Information request, which is very much for the same list of ministerial submissions.
Yes.
In the most recent correspondence in response to the letter received from Coalition Senators last week, we indicated there had been a change to the relevant Freedom of Information request, whereby we have issued a practical refusal notice to the applicant for that request on the basis that we assess it to be an unreasonable and substantial diversion of resources to produce that list. And that is the update that we can provide the Senators today.
Okay. So is this the Freedom of Information Committee?
No, Senator.
No, it's not. What is this committee, Mr Gifford?
It's the Senate Legal and Constitutional Affairs Committee,
Right.
Senator.
And have you received a request from Coalition Senators to provide certain information to this committee on several occasions now?
Yes, we have.
Right. And you've produced that list?
No, we have not.
You said you had produced the list.
Oh, sorry. We have compiled the list for the purposes of the
So
Freedom.
you have the information that Coalition Senators, via the Senate estimates process, at both the February Senate estimates, the May budget estimates and now the November estimates have requested. You are in possession of that information, is that correct?
That is correct, Senator.
Right, but you've refused to provide it to the committee, is that correct?
Yes, Senator. It is not in a form that is able to be provided to the Senate. As we were advancing the Freedom of Information request, the compiled list has a range of material which cannot be produced in its current form. As you would appreciate, the list of ministerial submission titles goes to information provided to the Attorney-General. As the First Law Officer, he is quite often receiving legal advice, legal policy advice, cabinet confidence material, casework material from the department. Those exemptions would need to be applied, those redactions would need to be applied to that material. That was the basis on which we advised the applicant of a practical refusal, and it's also the basis on which we think it's an unreasonable diversion of resources to continue to progress that request.
Right, again, I'm a little confused. Is this the Freedom of Information Committee?
No, Senator. But
so why do you keep referring, Mr Gifford, with all due respect, to the response you are providing to a completely unrelated issue? That is a request from someone not on this committee. Mm-hmm. This is the Senate Estimates Committee. Mm-hmm. The Senate Estimates Committee is what you are currently appearing before. You are now saying it's an unreasonable diversion of resources. Why did you not say that at the May budget estimates? Why did you not say that at the February estimates? Why have you now waited until now to say that? And I'm going to dispute that in any event and take you through another committee that's already provided that information to the Coalition Senators that have requested it. Put aside the Freedom of Information request. This is a Senate committee. You have advised, you have produced the list. Had you produced the list in February of this year when we requested it?
Sorry, could you repeat that last part?
Did you produce the list in February of this year when senators on the coalition side requested
Do you
it?
mean did we produce it to the Senate?
Yes. No. Did you produce the list within the department?
We had started to compile the list in response to the Freedom of Information request, which was received.
Again, with all due respect, I'm
Sorry,
quite
Senator,
frankly
I'm
not
just trying
interested
to,
in the... You seem to be treating us as if we are making a Freedom of Information request. With all due respect, Mr Gifford. Secretary, have you had any contact with Mr Gifford in relation to this request?
I have, Senator, yes.
Right. What instructions have you given to Mr Gifford in relation to the Senate committee, not the Freedom of Information request?
We discussed the fact that compiling such a list would be extraordinarily onerous, would require teams from across the department to be engaged in having to assess the submissions and have declined to provide on that basis.
And yet the list has been produced.
Senator, the point I was trying to make earlier before you asked a follow-up question was it is not in a form that is able to be produced without further exemptions or redactions being applied to it, noting the type of information that is within the list of submission titles.
And again, Secretary, do you understand your obligations to the Senate committee?
I do, Senator, yes.
And have you considered your obligations to the Senate committee in requesting this information?
Well, can I just... I'm not sure that your letter was a request from the committee as a whole. It was a request from Liberal senators on the committee.
Coalition senators. Coalition
senators. So I think you need to be a little bit careful to imply that that's a request from the committee as a whole.
Well, that's fine. Coalition senators then. Coalition senators are entitled to ask for information.
Sure.
Senator Watt.
But you were characterising the request as being a request from the committee, and that's not accurate.
Through the committee then. Secretary, have you discussed this with any other departmental secretaries?
Specifically around lists of submissions, I don't believe so, but I was interested that you said that a list had been provided to another committee.
Yes, the Department of Home Affairs.
Was that provided?
The same information has been published by the Department of Home Affairs in relation to
I understood that
their
was
minister
related to a FOI request.
Well, again, we seem to be confusing an FOI request with the Senate committee. The coalition senators on this committee have requested certain information that you have said on the basis of a response to an FOI request, you are treating us as if we have made an FOI request. We have not. We have made, on 3 separate occasions now, a request for merely a list of ministerial submissions created between, it's a 12-month period, the 1st of May 2023 and the 24th of May 2024. And are you confirming you will not provide that to the coalition senators on this committee?
We don't have it ready in a form, but as I said, in terms of going through that to be able to assess it.
Secretary, have you even tried to get it ready in that format?
You're not going to want to hear this, but in the context of responding to the FOI request, we did make attempts to start working through that list, and it was extraordinarily onerous.
So I just find it ironic, given obviously Home Affairs, and I would have thought they're a pretty busy portfolio, have been able to produce such information, given also in particular that this Attorney-General likes to tell people in several speeches and also prior to the election about his commitment to transparency. And we go through this at every single estimates hearing in terms of me quoting from particular speeches that the Attorney-General has given and then finding out that we are unable, despite those speeches and his alleged commitment to transparency, able to actually seek the information. Can I ask, have you had any discussions with the Attorney-General or his office in relation to either the FOI request or the coalition senator's request?
Senator, I haven't discussed it with the Attorney-General.
His office?
I may have discussed generally the issue in the past with the office, but
okay. Could you go back and go through your records and find out on what days you spoke to either the Attorney-General, confirm that you did or didn't, and or his office, and the nature of those discussions in relation to this request, please?
Senator, I can confirm I haven't discussed it with the Attorney-General.
Or his office.
But with his office...
Thank you. Mr Gifford.
I can look to do that. I don't know that I would have a specific record of a conversation on a particular day, but I'm happy to take that on notice.
Thank you. Mr Gifford, have you had any discussions with the Attorney-General or the Attorney-General's office in relation to this request by coalition senators on this estimates committee, either in relation to our February request, our May request or our November request?
Senator, I can confirm I have not had a conversation with the Attorney-General in any regard in relation to this request. I have had a conversation with the Attorney-General's office in the ordinary course of events to advise about the receipt of the incoming letter from coalition senators and the department's proposed response.
Okay, and what were you directed by the Attorney-General's office not to produce the list, or that you should not produce the list? Not
at all, Senator. I was advising the Attorney-General's office that the request is unable to be fulfilled in its current form because we are still, at that point in time, when we're talking about the February estimates, we were still progressing the Freedom of Information request. Subsequent to that, we've indicated that the list of submissions is not in a form able to be provided to the senators.
And again, that disappoints me, because at the end of the day, this is a Senate committee, and as I've stated, it would appear that the Department of Home Affairs and that Secretary is able to undertake the work and produce that list. The fact that there is an FOI request is quite frankly irrelevant to the Senate process and to the Estimates Committee. Is your decision not to produce the list because you want to shield the Attorney-General from scrutiny?
No, Senator. As we've indicated, it is a voluminous and complex request. It is a substantive and unreasonable diversion of resources for us to continue to progress that request. That is the sole basis on which we are unable to provide the information to the
Secretary,
Senate.
how many people do you have working in the department?
I will get the number for you. I have it here. Well, actually, I think I've got it in the letter.
Departmental headcount, Senator, is 2,168.
2,168, and despite having the fact that you have said earlier that you have compiled the list, so can we just ascertain that the list is there?
A base list is available.
Yep, so a base list is available. How long has that base list been available for?
When I was trying to answer your question earlier, Senator, and made reference to the Freedom of Information request, that was to give you the indication that we started to progress the compilation of the list upon receipt of the Freedom of Information request, which I believe was in October of 2023.
October of 2023. Have you done any work in relation to the Coalition Senator's request of either February, May or November? Or is it merely work done in relation to the FOI request?
Senator, if I can draw your attention to where the question has been asked by coalition senators in previous correspondence, we have replied to that by indicating that we were advancing that request by reference to the Freedom of Information request. So by progressing the Freedom of Information request, we're indicating that should that Freedom of Information request be completed, that the information would be provided on our disclosure log through the usual practices and therefore accessible to the senators.
That is very kind of you to treat coalition senators on this committee as if we're making an FOI request. It is completely irrelevant to the request by coalition senators whether or not an FOI request has or has not been made. You have given evidence that you have had the base list now for more than a year. Is that correct?
I'd have to check the
October
specific dates, but we
2023 was the
commenced
date that you
compilation of the
provided.
list upon receipt of the Freedom of Information request.
And you are now refusing to produce the information to coalition senators on this Senate committee on the basis that it would be voluminous and an unreasonable diversion of resources. Is that correct?
Yes, Senator.
Right. Even though you've already done the base work.
Senator, as I've indicated, while the base work to compile the list has been undertaken, the list is not in a form to be able to be provided to the senators without further exemptions, reductions being applied to make sure that we don't provide cabinet in confidence material, private information, legal in confidence material as well.
I understand all of
I'll
that.
have to rotate the call after this question.
Yep, I understand all of that, but again, you've already done the work. There's 2,168 people on headcount working in the department. I am quite disappointed, Secretary, and I will personally consider this obstructing the work of coalition senators. And as someone just said to me, Sir Humphrey Appleby would be proud of the responses that we've got.
Chair, I think that's pretty out of line, and I think it might also be worth Senator Cash looking at the extensive answers that the department has presented to the range of questions that she asked ahead of this hearing.
Yep.
I don't think any suggestion of the department being obstructive is fair, given the work they've gone to.
Well, the
to
work
answer
hasn't
the
been
remainder of
done,
the
Senator
questions.
Watt, and that's the whole point.
No, I've seen the answers to the remainder of your questions, and I'm sure that took a lot of time.
In relation
Thanks,
to this
Senators. Thank you,
particular
Senator
request,
Cash.
February,
Senator Cash,
May
thank
and
you.
November,
Senator Cash,
it has not
thank
been
you.
done.
Senator Cash, when I call your name 3 times, you should stop speaking. That's how this is going to work
Thank you,
today.
Chair.
Senator Lambie, I'm going to hand the call to you. And if you need direction on where questions go, this is probably a good time to ask as well. But you have the call.
Thank you, Chair. I have some Royal Commission questions, which has to do with your office. So the Veterans Royal Commission?
So that is generally in the Integrity and International Group, which is scheduled later today.
Right.
That's where our Royal Commission's
Okay.
responsibilities lie.
Okay, well, I can only take directions from the committee. The committee told me to be here this morning, so which is not making our lives easier as crossbench if we're not getting the right timings.
Yep.
So you want me back to use those Royal Commission ones then, during that period of time?
Yeah, so Senator Lambie, the Royal Commission's branch is in Integrity International Group, which is scheduled at 2:30 this afternoon. I'm not sure if there's any part of your question that relates to cross-portfolio that you can put now. And then
No,
we can,
that's fine, Chair. I'll just come back.
Okay, all right. Well, apologies about that, Senator Lambie. I'm not sure. We might think about a better process to make sure you get the right information next time, but we will let you know when that group is up.
Okay, and what about if I have some questions on the, just so I can double check on this, also if I have questions on the class action that was brought upon in 2013 in reference to the livestock, with the Indonesia problem that we had with the Labor Party back then, and there was a class action, and I just want to know where I can ask those questions, because apparently farmers are telling me that payments haven't been made. Where do I ask those questions? In what part?
So that, I think you're referring to the Brett Cattle matter.
Yeah.
And the department's responsibilities arise in 2 areas, both the Office of Legal Services Coordination, which supports the Department of Finance and Commonwealth, who are the lead on that matter. But AGS is also providing support to Commonwealth for that matter. So the Office of Legal Services Coordination is in the Integrity and International Group. It's on this afternoon.
Okay, I will come back to that. Thank you. Thanks, Chair. Sorry about that.
No, that's fine. Thanks for that assistance, Secretary. I'll hand the call then to Senator Ghosh, and then we'll come back around to the rotation. Thank you.
Thank you, Chair. Thank you, Secretary, and for the officials here today. So just to follow on from the questioning from my colleague, Senator Cash, if I was to ask for instance, a list of submissions or briefs from the term of the previous Attorney-General or the previous 2 or 3 Attorneys-General, would your answer be essentially the same as what you've given to Senator Cash?
Yes, Senator. The issue is the work involved in having to go through every single submission and assess whether it raises the types of issues that Mr Gifford referred to, and in addition to those that he mentioned, I'd also add national security classification issues as well, would apply equally. Going through the list of the many thousands of submissions that the department has prepared for various Attorneys General over the years would be incredibly onerous.
Thank you. Now, the department has established 2 new agencies in this term of government in the Administrative Review Tribunal and the National Anti-Corruption Commission. In broad brushstrokes, are you able to describe what the work that's involved from a departmental perspective is in setting up new bodies like this?
Thank you, Senator. Yes, probably it's one of the more significant undertakings that you would do in terms of supporting the establishment of a new entity at the Commonwealth level. The two entities that you've referred to, the National Anti-Corruption Commission and the Administrative Review Tribunal, were very different activities or projects. The National Anti-Corruption Commission required the creation of a new entity. Granted, there was the Law Enforcement Integrity Agency that already existed that was folded into the National Anti-Corruption Commission, but the work involved is multifaceted. There's the policy work to establish the principles for the new agency. There's the legislative drafting and the passage of legislation through the Parliament. There's a work associated with standing up a new entity, working across government with the Department of Finance, Prime Minister and Cabinet, setting up the actual entity itself, and that includes accommodation, staffing, IT, and then bringing on board the statutory office holders for the new entities. So the National Anti-Corruption Commission work was done over a fairly limited period of time in terms of from the decision of government to proceed to the actual commencement of the entity, and involved a huge amount of cooperation between the department, the then Law Enforcement Integrity Agency, and other colleagues across government, as well as the members of the new entity. With the Administrative Review Tribunal, there was an existing entity. There was an extraordinary amount of work done with stakeholders. There was an advisory committee led by the former High Court Justice, the Honourable Patrick Keane, that engaged very broadly across all relevant stakeholders, including courts, departments, stakeholder groups representing people who appear before the tribunals, to ensure that we understood all the key challenges and that we could develop the policy to support the legislation for the new tribunal. There was a lot of work to do to ensure it was on a solid funding basis going forward. There was an opportunity to be able to look at issues like new IT or enhancing the IT. The previous AAT had, I don't know if I've got this number right, but I think over 30 separate IT systems, because it was the amalgamation of various other tribunals. So pulling that together to enable the tribunal to have a fit-for-purpose IT system was a critical part of the process. And then the very large engagement across government. Obviously, every department and agency has decisions that are reviewable in the Administrative Review Tribunal. Our task force, which was led by a First Assistant Secretary here, Sarah Samios, I think did a superb job working across government, engaging with all departments and agencies to ensure that we understood issues from their perspective. We worked extremely closely with the Administrative Appeals Tribunal, including President Kiru and the Registrar, Michael Hawkins. It was an outstanding level of collaboration between the department and the AAT. And additionally, there's a very significant number of appointments that had to be made for the new tribunal. So the process of establishing a new entity, the policy, the consultation, the development of the legislation, the appointments processes, and then working across government was a very significant undertaking across the course of the last 18 months or so.
Thank you, Secretary. I'd like to ask some questions about the Respect at Work report that was undertaken by Kate Jenkins.
Depending on the nature of the question, that would normally arise in the Integrity and International Group, where our Human Rights branch is, but it may depend on the specific of the question.
It relates to the implementation of the recommendations, so if that's better asked in the integrity section, I can do that. The other question I had related to the implementation of the positive duty on employers to prevent sexual harassment. Is that also best asked in a later section?
That would be correct, Senator, yes.
Are you able to outline the Attorney-General's equitable briefing policy and provide an update as to how the implementation of that policy is going?
Senator, we are in a position to provide information on that. Again, that's something in the Integrity and International Group when the Office of Legal Services Coordination appear later today, but we certainly have information that we can provide in relation to that.
Okay, thank you. I'll reserve those questions for later.
Thanks, Senator.
Yeah.
Thanks.
Okay. Well, I can come back to you, Senator Ghosh. Senator Cash, you have the call.
Thank you very much. I also just want to ask some questions in relation to the ART, which Senator Ghosh has raised. Secretary, I do have some in the next section, but this particular line of question goes to, in particular, corporate and general, and it's in relation to the appointment of Claire Thompson as the ART Deputy President. Secretary...
Senator Cash, can I just as senators have done previous to your question, we would seek some advice about whether that's relevant in cross-portfolio. I would have thought appointments are relevant.
No, this is, as I said, corporate and general. It goes to the Administrative Review Tribunal, it goes to the Justices and Communities Group, which has policy responsibility, and the appointment processes, which are also obviously handled...
Justice and Communities Group is up next.
No, I know, but this one in particular it's across a number of portfolios because of the nature of the appointment, Veterans Affairs, Defence, Migration, NDIA, amongst others, and the integrity of the appointment process in relation to this particular person.
I would have thought appointments are relevant in the actual section.
So the appointment process was handled within the Justice and Communities Group by the Administrative Review Task Force. So that's where that was done.
Oh, if it was done, okay, and we're coming to that section next. Okay, I'll ask that first up then in the next question. Can I just ask though, was the appointment process signed off by the Attorney-General?
Well, the process or the outcomes of the process? Or?
Both.
Yeah.
So the process itself and then the outcome of the process?
That would be correct. The Attorney-General provided approval in terms of the way the process was managed, and of course any appointments that were made by the Attorney-General to Cabinet.
To the Cabinet. So, Secretary, so Chair, in that situation, Senator Ghosh did just raise the issue, and these are follow-on questions from the evidence that the Secretary gave in relation to this particular appointment.
No. It's a very creative attempt to get the questions a little bit earlier on, but the quickest way to get to those questions is for us to finish cross-portfolio. Well,
again, I will. I dispute the ruling, given that you allowed Senator Ghosh to ask questions in relation to the Administrative Review Tribunal. As I said, this goes in particular to corporate and general. It goes across a number of portfolios because of the nature of the decisions that this particular Deputy President has been appointed to review. It goes to the integrity of the appointment process for a role that affects, as I said, all of these portfolios, because it has a stake in the role being performed professionally, impartially, but in particular, apolitically.
Senator Cash, not to debate the point, but those questions are of a different nature to what Senator Ghosh was asking. We will be able to ask many questions about appointments. Government senators have similar questions about appointments, but we will have those officials available in the next section. and we can get there as soon as possible.
Well, can I please then go on at this point in time to another line of questioning, and it's in relation to Secretary, when did the Significant Legal Issues Committee last consider the government's decision to issue visas to Palestinians leaving the Hamas-controlled territory of Gaza?
So, Senator, questions relating to the Significant Legal Issues Committee fall under Integrity and International Group. That committee is supported by the Office of Legal Services Coordination.
Just in terms of the cross-portfolio aspect, though, it's going to have direct crossover to Home Affairs.
I took cross-portfolio as being our portfolio, but that's the interpretation I've always taken for it. But maybe
it's not whether a certain agency has been consulted or worked with.
So we will have
questions
people here
relating
who are able to answer those questions.
Yeah.
we will, Senator.
In Integrity and International?
Yes.
Okay. I will pop that to that side.
Senator Cash.
Just, can I now have a look at then the government's legislation in terms of religious discrimination?
I feel like I'm going to sound repetitive here, but that is also Integrity and International Group.
International, okay. That's okay. We're going to move through cross-portfolio quicker than we thought and get on to the next group. That's going to be great. Hold on for one moment, just while I check. Class actions, Chair.
That will be another outcome. Yeah.
I think most likely it's Integrity and International Group. But I might need a little bit more information to make sure that I'm accurate there.
The nature
Would you mind?
Yeah.
National Security and Justices, would that be correct?
I'm sorry, Senator, I just missed that.
National Security and Justices and Communities, or Justices and Communities?
You mean for the class actions question?
Yeah.
Well, it's possible it's there, or it's possible it's Integrity and International. It just would depend exactly on the nature of the question.
But it's not in cross-portfolio, so perhaps you could ask it in Justice and Communities and then see how you go.
So then I have one more section then in cross-portfolio, and the good news is we can then move, if others don't, to the next line of questioning in Justices and Communities. And it's just in relation to, it's an issue that's now been raised consistently with me in terms of the legislation that is tabled in the Parliament by this particular attorney, and it's stakeholder after stakeholder after stakeholder across the board in terms of the different pieces of legislation. How many bills have been introduced in the Attorney-General's portfolio in this term of Parliament?
I don't have that number with me at the moment, Senator. I can take it on notice, and well, Mr Gifford actually is coming to the table. He may be able to answer that for you.
Thank you, Senator. I'll confirm, but I believe the number of bills introduced in this term of Parliament by the Attorney-General is 46.
Sorry, did you say 46?
46.
46, okay. Secretary, at any point in the last 2 years, have you had cause for concern about the legislation being rushed or pushed out the door into the Parliament before it's ready, without adequately taking feedback into account from stakeholders?
I've not had any particular concern about that, Senator. Having been involved in working on legislation for well over close to 25 years now, I've done a lot of big, small and medium-sized bills, done a lot of consultation with them. I think some stakeholders would always like more consultation. Some stakeholders are more interested in just ensuring that the legislation is progressed and given the opportunity to be assessed in Parliament. So I haven't had anything in particular to be concerned about over recent years, if that's the question, Senator.
Okay. I just want to have a look at some of the bills that just have been presented, and in particular in relation to the drafting of those bills, their introduction into the Parliament, and then feedback from stakeholders, but also then amendments that have had to be brought to the Parliament as a result of them being put into the Parliament. So, for example, if you look at one of the bills which has been raised with me, is the Crimes Amendment strengthening the criminal justice response to sexual violence bill. So you're familiar, obviously, with that bill.
Yes, Senator.
Yep. Okay. So in relation to that bill, there were a number of concerns raised by Professor Jeremy Gans about the drafting of provisions around sexual experience evidence, and they were quite concerning, the issues that he raised. And in particular, because his evidence was then adopted and endorsed by another stakeholder, Liberty Victoria, it is something that was explored, and Senator Scarr knows this well, throughout the committee process. And it was about items 23 and 26 of the bill, and I just want to read you what he said. Some federal crimes require the prosecutors prove that someone other than the defendant engaged in a sexual activity with an alleged victim. If items 23 and 26 are enacted, the prosecution will be completely barred from proving that all, and those prosecutions will therefore fail unless the other person is charged and the charge is considered in the same proceeding. So that was the evidence that he had given, which I said was endorsed by Liberty Victoria. He then provided a number of examples for offences of causing a child to engage in sexual intercourse in the presence of the defendant, causing a child to engage in sexual activity with another person, and offences with a sexual element involving complicity. In other words, as you know, the defendant aided, abetted, counselled, procured, committed by proxy or engaged in a common purpose or agreed that another person will commit the offence. And this is what he said.
Senator Cash, I'm just going to ask you to bring your question to a cross-portfolio matter. I'm
going through the drafting of particular pieces of legislation.
Well, you're
and it
asking
seems to be
about
a
the
pattern
policy
of behaviour in relation to what's being presented to the Parliament, raised with me time and time again by stakeholders, the legislation that is tabled or the materials that back them up are misleading or contain errors which then need to be corrected.
Yeah. So, well, Senator Cash, I think your questions relate to the policy.
This is not in relation to policy. I'm going to go through a number of
that's why I'm asking you to point out what
bills.
Yes. It's a very long preamble to a question that I'm asking you whether it is relevant to cross-portfolio. You should make that clear.
It's the general drafting of legislation.
Well,
Senator Cash, I might be misunderstanding this, but what you seem to be describing is an Attorney General who does desire to pass lots of legislation and pass lots of reform and consults with stakeholders and makes amendments in response to what stakeholders...
Well, it's actually the exact opposite. It's not consulting with stakeholders in the first instance, or improperly consulting with stakeholders because of the fact that they are sworn to secrecy, only shown parts of legislation or not shown it at all. Tabling legislation which stakeholders then see, often for the first time, with serious flaws in it that then need to be amended.
Senator Cash, I'm asking you to put a question to the officials.
General that is raised time again.
Thank you. Senator Cash, what I'm asking you to do is put a question to the officials. You have lots of opportunities in the chamber to make speeches about this, but if you have a question in relation to cross-portfolio, you should put that now.
Well,
if there's questions in relation to the policy, that will definitely be able to be addressed later on in the program.
How did we get to the point were legislation prepared in the Attorney-General's Department would, if enacted, cause prosecutions for child sex offences to fail?
Well, that's not true.
Senator, I'm not familiar with the specifics of the issue that was raised during that process.
And that's what I was trying to describe to you, but obviously I've been told that I'm not able to do that.
No,
so the
that's
committee's
not-
made
that's
certain
not correct.
recommendations, and one of the recommendations is that this must be amended. It is blindingly obvious, though, to anyone who looked at the legislation in the first instance that there was a serious deficiency with it, and yet the legislation was tabled in the Parliament by the Attorney-General. So my question again to you is, how do we get to the point where legislation prepared in the Attorney-General's Department would, if enacted, cause prosecutions for child sex offences to fail?
So, Senator, I just would make the general observation that quite literally of the hundreds of bills that I've been involved in over my career, many of them are introduced, go to committee, are subject to scrutiny, subject to stakeholder feedback, and that obviously is a critical process in identifying any issues. And that is something that's happened in relation to most legislation that I've been involved in one way or the other.
This is incredibly serious, though. What would have happened then if the Parliament had simply passed the legislation without scrutiny through the committee process?
But we you mean what would have happened if we were a Parliament that didn't involve committees, which we do?
No, you actually don't, Senator Watt. You involve a very, very limited committee process. They're normally truncated. You're given 1 day to actually explore in detail the serious legal ramifications
But all of that is
of
decided
bills
at Selection
that
of
are
Bills
put
Committee. Your people can
forward
raise an issue with that
by
if they've got an issue
the
with that.
Attorney-General. So my question again is, how did we get to a point where legislation prepared by the Attorney-General's Department would, if enacted, cause prosecutions for child sex offences to fail? Was this not raised with you by the Attorney-General or his office when they reviewed the legislation? And if the answer is no, that's fine. If the Attorney-General didn't raise this with you, that is fine.
Senator, I'd need to check with the people that were involved in the development of that legislation. It wasn't raised with me specifically.
No, and that's fine. Yeah. Could you check when the Attorney-General's office received the draft legislation and also when they reviewed the legislation and then when gave the department the go-ahead that it could actually be tabled?
We'll take that on notice, Senator.
Are you aware of the committee's feedback in relation to this particular piece of legislation?
Not in detail, no, Senator.
The amendment will be made, but again, it does concern me that legislation has been prepared in the Attorney-General's Department that has a fundamental flaw. That means, on the face of it, child prosecutions or prosecutions for child sex offences would actually fail. Can I just ask, will you actually review what the committee said? You'll be making the amendments to the legislation, I'm assuming. You'll be drafting them?
Senator Cash, I think we're getting into a level of detail about a particular bill that, to be fair to Ms Jones, it would be appropriate to have the relevant officials
I'm just asking for the process now. I'm just asking about the process.
You've been asking a number of questions about a particular provision in a bill. I'm sure Ms Jones has officials who've been deeply involved in this and could give,
and
more
I'm just asking about
answers.
the process now going forward in terms of who will draft the amendments.
Well, that is exactly
cross-portfolio
that is
questions,
exactly
Senator
the
Cash,
question.
and you know
Well, it's a process. I'm just asking who will draft the amendments.
Well, I would think the relevant officials who've been involved in that
Well,
piece
then
of
the
legislation, who are
Secretary can say
probably
that.
here to come up later on today, can answer that question.
The Secretary can say that then. If that's the answer, that's the answer. That's all I'm asking.
No, but that's not the point, Senator
Who will
Cash.
draft the relevant amendments?
No, Senator Cash, the point is that you are asking questions that are not relevant to cross-portfolio, which we've
So who
spent
drafts
quite a bit of time on
amendments
this
to the
morning.
legislation that's seriously flawed is not a question
No,
that I can now ask.
What I'm asking you to do is to put questions in relation to the bill and the policy around it and any process of the legislative process to the relevant officials I'm sure that they will be able to answer that question for you. What I'm asking you to do is to stick to the program that's been agreed to by coalition senators so that we can move throughout the day. And also so that we can get to Justice and Communities Group, where it sounds like you have a number of questions.
Well, again, on that basis, I will finish my questions here so we can move to the Justice and Communities Group when other senators are ready.
Okay, we probably need to do a few checking on other questions as well. Yeah. Senator Shoebridge, you want to check where yours land,
yes,
if they're in here or not, and then we're making good time. But
yes, we'll start here. If they're not here, then just find out where.
Yeah, that's how we've been doing it this morning.
Thanks. Nice to see you, Secretary.
Thank you, Senator.
The first is the process for the appointment of an eminent person to the NAC to try and clean up the mess that is the Robo-debt referral. Is that dealt with here?
Policy responsibility in relation to the National Anti-Corruption Commission falls within the Integrity and International Group, though I note that decision-making regarding the appointment of an eminent person is a matter for the NAC itself.
And I have, you weren't in the room, but I have given Senator Cash a direction around questions around appointments should be asked in the relevant sections. So, yeah.
All right.
Yeah.
But the questions of the Attorney General's role in vetting or reviewing recommendations, where is that best dealt with?
Vetting or reviewing recommendations
for the appointment of an eminent person. What if any role the department and or the attorney has in the appointment?
So that would be in the Integrity and International Group.
Integrity International. The issues about the Standing Council of Attorney Generals agenda. It may well be that it's issue by issue. One of the issues I want to explore is OPCAT falling off the agenda.
That's the Integrity and International Group?
That's all. That's Integrity, but in the same spot?
Yes.
And then consultation, if any, between AGs and Home Affairs on issues of national security regarding privacy reforms.
That will be in the Integrity and International Group, which is where the privacy reform team sits.
Because this is about, I just want to be clear, what if any consultation happened with Home Affairs on issues of national security? That looks like cross-portfolio to me on the face of it.
Cross-portfolio doesn't mean two different portfolios.
I know. It means across the whole portfolio. Yeah. I get that. This portfolio.
Yes.
But that is also integrity.
Yes, so it's in that group, and I will have officers who can assist with those questions.
Right. Well, I look forward to integrity.
Thank you very much, Senator Shoebridge. And Senator Ghosh, you've received direction on your questions. We're going to ask them a bit later.
Yes.
Yeah. Okay. Lovely. With that, I think that's all the questions we have then for cross-portfolio, corporate and general matters.
Sorry, I have one other question. The recent survey that was done of staff of the Attorney General's Department, the Public Sector Survey.
Yes.
I had some questions of Home Affairs about their survey results yesterday.
Yep.
When did you get the survey results?
I think we all get them at...
Yep.
I think we all get them all at the same time, but I'll get the Chief Operating Officer to confirm.
Good morning, Senator. We all, each public service department and agency received the results at the same time, and I believe it's the first week in August.
Yep. Now, a summary has been published, but the actual full set of results I wasn't able to find. It could have been my failure to navigate the AG's website.
No, the highlights report is the published report that we provide on our website.
All right, but the actual detailed report, which contains the granular data, where's that?
That is provided to the department and is used by our senior executive service in terms of analysing the results and engaging further with staff, but it is not published on our website.
Why is it not published?
The highlights report has been the report that gives the trends for the department, and that's been the report that we've consistently provided on our website.
Yeah, that's a description, but not an explanation.
I think that's consistent with the practice of all departments to publish that highlights report.
Again, that's a description but not an explanation. Mm-hmm. If the only explanation is it's consistent with what we did in the past, if that's the beginning and the end of the explanation, then I'll understand your explanation. Is that the explanation?
Yes.
Can you provide a copy, if possible today, to this committee of the full report?
I'll take that on notice, Senator.
All right. And if not, can you explain why?
Take that on notice.
Thank you.
Thanks. Thanks, Senator Shoebridge. Senator Pocock, you're seeking the call. You don't need a nameplate. We know who you are. And just, Senator Pocock, while you take your seat, we have kept a pretty strict approach to cross-portfolio questions, but if your questions relate to another part of the department, they'll give you some advice about when you can come back.
Thank you very much, Chair. I appreciate this, and we have sought advice and are told that this is the right section, but we'll see how we go.
Thanks.
I have some questions about FOIs following the decision in Attorney General versus Patrick. And as I do, I'd like to acknowledge former Senator Rex Patrick for his tireless work in this space as a transparency warrior. Please can you tell me what administrative changes across government have been made following that decision to ensure ministerial documents subject to FOI don't go missing on a change of minister or government?
Senator, in terms of FOI practice in the department, it's under the responsibility of Mr Gifford as Chief Operating Officer. In terms of policy issues associated with FOI, it's in the Integrity and International Group that where our engagement on those issues are, including with PM&C and other agencies on those broader whole of government issues.
Thank you. That's great to know. I'm interested. What's changed in your department since this landmark decision that you actually have to hang on to ministerial documents?
Thank you, Senator. Good morning, Cameron Gifford, Chief Operating Officer. As the Secretary has indicated, in terms of the split of responsibilities, I have responsibility for the casework unit, which supports FOI applications and the application of the FOI Act. As a result of the decision of the full Federal Court, that matter has now been referred back to the Information Commissioner for a further review. We'll await to see what further guidance comes from that once that decision is made by the Information Commissioner. So it's a little bit premature at this stage for us to give an indication of about what changes, if any, will take place as a result of that matter.
Well, I'd hope some changes happen given the judgment. So what I'm hearing is it's sort of a wait and see to see what the Information Commissioner comes up with. Is there a timeline on that, given we're heading into an election period?
I think that question, Senator, is best directed to the Office of the Information Commissioner, because I think, as well as making the subsequent decision in terms of the review that is before the Information Commissioner, it is very likely we would anticipate some further guidance being provided by the Information Commissioner, but I can't commit to that on behalf of the Information Commissioner, and they would have greater detail in terms of any proposed timing of that guidance.
Sure. Senator, they're scheduled to appear later this afternoon.
Yeah, thank you. I'll return. Are you working with the OIC on this? What's the sort of consultation and collaboration like?
That is the responsibility of the team that are in the Integrity and International Group. But we work very closely with the OIC, both supporting it as a statutory agency within the portfolio, but also in terms of our responsibility for the FOI Act and the Privacy Act, and working closely with the OAIC on policy issues relevant to those two pieces of legislation.
Thank you. Minister, in the original jurisdiction judgment at paragraph 126, Justice Charlesworth declared the non-transfer or shredding of ministerial documents on change of government is unlawful. Can you commit that there will be procedures in place should there be a change in government or change in ministers, that these documents will not be shredded and will be appropriately transferred to this department, the new minister's office, or to the archives?
Well, as Mr Gifford has said, now that we have the Federal Court's decision, it's being considered by the Information Commissioner for review. So we'll obviously work with the Information Commissioner to implement that decision, but I'm sure I can commit that the government is not going to be breaking the law. Yeah, but it's probably a little early for me to say exactly what we're going to do in response to that decision. That's exactly what's being considered at the moment.
Thank you very much. Thank you, Chair.
Thanks, Senator Pocock. That's all the questions we have for cross-portfolio, general and corporate matters. I forgot what the third one was. Thank you very much to those officials. I now call officers from the Justice and Communities Group of the Attorney General's Department, who I assume are not too far away, so we can probably get straight into questions, of which we have many, it sounds like. And Senator Cash, I'll start with you once the officials get settled.
I'm actually going to table some documents, so I might get those documents tabled. You should know.
I'll look them up now. Thank you.
Do you want?
Over to you, Senator Cash.
Yeah, I'm just going to get tabled some documents that are tweets in relation to Claire Thompson. So I just want to ask about the appointment of a Deputy President of the ART, Ms Claire Thompson, SC. Secretary, I don't know if you'll be answering, maybe it's Ms Harvey. When was Ms Thompson appointed and what jurisdictional areas does she look after?
I might just ask, sorry, Tamsin Harvey, Deputy Secretary, Justice and Communities Group. I don't have the date of her appointment in front of me, but Ms Samios may well.
That's fine, we can... Yep, the tweets.
Senator Sarah Samios, First Assistant Secretary, Administrative Review Task Force. I don't have that specific date on me, but I do believe the appointment commenced in July.
Oh, the appointment commenced in July. So, and what was she appointed as?
As a Deputy President.
As a Deputy President. And in terms of the role of Deputy President, can I ask what she'll be responsible for?
So Deputy Presidents would hear matters across the jurisdiction of the Tribunal.
So basically, if I'm intelligence and security, migration, the NDIS, protection, taxation, business, veterans entitlements and workers' compensation, as well as matters in the general jurisdictional area. Is that what the across the board means?
So that effectively describes what Deputy Presidents could hear in terms of the specific matters she would hear. That would be a matter for, in terms of the constitution of the Tribunal in particular cases.
Understood. Okay. Just in terms of the documents that I've tabled, they relate to public comment made by now Deputy President Claire Thompson, and I just want to go through them. In relation to the first one, you can see on the top is Proud Old Soldier, the 19th of April 2021. And the response by Ms Thompson on the 19th of April 2021, could you just tell me if you have it in front of you?
I think it's that one. I think we're getting them now.
Okay.
And you can see her response, and you're a rude, I don't want to read the word out. It is one of the most repulsive words, I think, in the English language. It begins with a C and has 4 letters, and I'm assuming that people will be able to work out what that is. So, Secretary, do you see that?
Yes.
Yes, you do. Okay. If we could turn the page, you will see there is a series of tweets again on the 15th of December 2021. On the 15th of December 2021, Ms Thompson responds, since we have a FWIT, but she refers to it in full, as a PM, and then she hashtags Scotty does nothing, Scotty the F-wit, but in full. She uses the F word in full. And Scotty from Photo Ops. Do you see that one?
I do, Senator, yes.
Okay. On the next page, as you can see, there is a tweet from a particular journalist on the 1st of November 2021. And down the bottom, or near the end of the page, Ms Thompson's response on the 1st of November 2021, calling Morrison a liar is not a slur, it is truth. If you turn the page again, there is a tweet on the 10th of the 1st, 2022. There is a response by Claire Thompson on the 10th of the 1st, 2022. I think you can give this one to hashtag Scotty the failure. He makes Maxwell Spart look highly competent. Do you see that one?
Yes, Senator.
Okay, on the next page, as you can see, there is a tweet. There is a response by Claire Thompson on the 17th of November 2021. At Liberal Oz deserves every bit of the punishment you got in March, crap policy, lashings of religious zealots and aged sitting members. You reaped what you sowed. Do you see that one?
Yes, Senator.
Okay, if we could go to the next one, please. The next page. There is a tweet on the 20th of September 2021. The tweet is from a particular person. It says, what is your main concern if the unthinkable happens and Scott Morrison actually wins another term in office? Claire Thompson responds on the 21st of the 9th, 2021, Peter Dutton. Do you see that?
Yes, Senator.
On the next page, there is a tweet. Claire Thompson responds. It's in relation to Brendan Murphy. Claire Thompson responds on the 30th of June 2021. Didn't the @Liberal Oz nominate him for Australian of the Year? Shallow, self-interest reigns, but all we know it's not him. It's useless old hashtag Scotty from marketing, hashtag Scotty the gaslighter, hashtag Scotty does nothing. On the next page, you'll see that there is a tweet, in this instance from Simon Birmingham on the 13th of May 2021. Claire Thompson responds on the 13th of May 2021. Fact, you're a bunch of misogynistic toe rags who've been dragged kicking and screaming on gender issues and still don't get why Andrew Laming needs to go. On the next page, there is another one that Claire Thompson tweeted on the 15th of December 2021. Reason number 7,501 to vote at Albo MP 4 p.m. Do you see that one?
Yes, Senator.
Okay. If we could go to the next document, please. There is a series of tweets, the first one commencing on the 13th of February 2021 by Claire Thompson. It says concert. You see that one?
Yes.
There is another tweet on the 11th of the 2nd, 2021. Claire Thompson responds on the 12th of the 2nd, 2021. Can you see that? You're a complete... She uses a four-letter word beginning with C and ending with T, but she spells it in full. Again, I think that is the most repulsive word in the English language. Can I ask you to turn the next page? You will see there is a series of tweets. On the 27th of the 12th, 2020, you will see that Claire Thompson replies, yep, you really are a, unfortunately again, spelt out in full. It's a word beginning with C and ending in T. Again, I think that is just the most vile word in the English language. They're the ones that I'm tabling. I have also now been forwarded an archive of tweets from Ms Thompson. In the first instance, can I ask, do you believe that any of those tweets are appropriate?
Senator, I'm conscious, obviously, there are screenshots here of various tweets, and I have no sort of verification of them.
I'm happy to provide for you. It is a separate document in terms of, it's my document number 29, which is, just for the record, it is a post from St Mark's College in Adelaide, which specifically identifies this Twitter handle and links it to Ms Thompson, who is identified by her name and role as senior counsel and her position as a leader in the WA legal profession and among women lawyers. It's independent, external, it's unambiguous, and was available publicly as at 5 p.m. yesterday. And the profile is linked also to the archives that I've been provided that are publicly accessible, these archives. I'll just make sure you've got that document as well so you can see.
Senator Cash, on that document, you didn't mention the part of the St Mark's College website that identifies Ms Thompson as a former Liberal candidate for the Senate in Western Australia in 1996.
Yes, she is. Yes, she is.
Is she a factional opponent of yours or something?
No, not at all. I don't think she's a member of the Liberal Party anymore. I'm actually just horrified.
Is there a reason you haven't pointed out that she was a Senate candidate for your very own party in your very own
So on what
state?
basis is that in any way relevant to my line of questioning, in particular the fact that the tweets that she has tweeted are quite vile and in some cases openly partisan?
Well, they are openly partisan, and it's
and we're going to get to that part in relation to the appointment process.
That a former Liberal candidate for the Senate in Western Australia, not that long ago, seems to have formed a very strong view about Mr Morrison and the Liberal Party.
Are you defending these tweets, Minister Watt?
I mean, she has used language that I wouldn't use.
It is disgusting language, and we'll get to whether or not this was discovered throughout the appointment process, whether or not it was brought to Cabinet's attention, whether or not it is in breach of the code of conduct, this type of behaviour.
From what I can see, they were all tweets that were issued by Ms Thompson, if indeed they were, but before her appointment, and after what the St Mark's College website tells us was Ms Thompson, having for several years been actively involved in politics, standing as a Liberal candidate for the Senate in Western Australia in 1996.
And again, Minister Watt, I've tabled the document. I'm not disputing that. I'm not disputing that. You
didn't table the bit about her being a former Liberal candidate.
I'm not disputing that. I am referring to
so you want to make
vile.
You want to make an attack on someone being partisan.
These vile.
Isn't it partisan to be a Liberal candidate?
Senator
She is your appointment.
I've heard your colleagues say worse things.
And so Secretary, did you undertake a social media search of all the candidates before they were appointed?
Senator, there are a range of checks that we undertake in relation to any statutory, judicial or tribunal appointment, and I can ask Ms Samios to talk to the process in relation to the Administrative Review Tribunal.
That would be appreciated, and in particular, given the nature of these tweets, the offensive nature of them. I don't know about you, but I'm not even going to try and defend the use of the C word publicly, and in particular the partisan nature of the tweets. Could you take me through the social media search that was undertaken on Ms Thompson and whether or not these tweets were found, given that they were publicly available?
I think what I would say is we do some general searches.
Well, did this come up in your general search? Because if it didn't, we're going to go through that process of what the general search was.
Yeah, thanks, Senator.
She had a publicly available Twitter account.
Noted.
Yep.
Noted. So I will ask Ms Samios to take us through. I would note over the course of many years of doing appointments processes, whilst we always undertake general searches, sometimes it is difficult to bring up things.
It is not difficult, believe you me, on this one. any appointment that you put in, their Twitter account would come up if they have one. This Twitter account has now been cleared, and I want to go through exactly why that occurred and whether or not there was any direction by anyone in the department or the Attorney General's office or the government as to whether or not it should be cleared. But if we could, in the first instance, go through the appointment process.
We'll have to rotate the call in a minute.
The appointment process, and in particular the social media searches that are undertaken, and were these discovered during that search?
So we'll be able to, if not the very specifics of that one, we may need to take that on notice, but Ms Samios will certainly tell you the general approach that we took to all the Administrative Review Tribunal appointments. I'll just check with the Chair whether you want us to progress with answering that now.
You can answer that now, and then we'll rotate the call and we'll come back to you, Senator Cash.
Thank you.
So can I just clarify, this question relates specifically to not the appointment process as a whole, or do you want the whole process?
Do you have information in relation to Deputy President Claire Thompson and the social media search that was done in relation to her prior to her appointment, and what was discovered?
So I don't have that information to hand, Senator. I know that the team has conducted a range of search terms, generally based on people's names as well as, you know, potentially positions in their
If you could take me through the social media search that is done generally then in relation to the appointments.
We'll come back to that. Sorry,
Senator, in terms of the detail, I would need to take that on notice because it's a search that is undertaken for a large number of candidates and is somewhat targeted depending on what is in their CV as well as initial searches.
Thanks. We'll come back.
I'll come back to this line of questioning. Thank you.
Yeah, thank you. Senator Polly.
Thank you, Chair. My questions are in relation to the situation in the whole complex around the Burnie and what's happening there. If I can get an update, if people are at the table.
I'll just ask the relevant officers to come to the table.
Thank you. I know how important it is for people of North West Tasmania to have access to family law services, so could you please provide an update on the Federal Circuit and the Family Court of Australia continuing to, well, it's been going on for some time, so can you give us an update on the progress that the Commonwealth has made in making sure those services are available?
Yes, Senator. I think we discussed this at the last instance as well. There has been a range of conversations for some time between the Commonwealth Attorney General's Department and the Department of Justice in Tasmania. And of course the Tasmanian Government has committed to build a new court complex in Burnie. So as part of the discussions, we have worked with the Tasmanian Department of Justice to do a couple of things, but primarily where we have got to is an agreement that we're continuing to work through, which would enable the Federal Circuit and Family Court of Australia to have a presence in Burnie, and we have also, through the court has also continued to work with its counterparts to make sure that the circuiting arrangements can continue while that build is occurring as well.
So can you give me a timeline in terms of when the court is going to be built? I mean, there's real concerns about the state government being able to deliver any infrastructure. So can you give me the timeline for that?
Alice Lineker, First Assistant Secretary, Courts, Tribunals and Commercial Branch. Senator Polly, we are somewhat in the hands of the Tasmanian Government in that respect, although we do understand that they are preparing a range of concept plans and the design process is ongoing, and we have been having conversations with them throughout that process.
Well, you can understand that this has been going on for a long time, and so for the people on the northwest coast of Tasmania, they don't really have a lot of faith in the Tasmanian Government to be able to build this. So can you advise whether or not the Attorney General has met with his state counterpart to discuss this issue?
I understand that there has been a range of engagement with between the Attorney General and his state counterpart, and that has ultimately resulted in Tasmania committing to facilitating a FCFCOA presence in that complex up in Burnie. So we are certain that there will be a facility for the court to circuit through Burnie. We are just in ongoing conversations with Tasmania about what that facility looks like and the detail.
So can you just refresh my memory as to how long the Commonwealth has been negotiating on this issue with the Tasmanian government?
Senator Polly, we have been in conversations with Tasmania for at least 18 months, and through a range of stages of their planning process, we've continued to make contact, and I believe there's been a range of conversations over that time. I'd have to take more detail as to the dates, but it's at least 18 months.
So, in a recent report in the Burnie Advocate, they reported that the Federal Circuit and Family Court of Australia would be accommodated in the new Burnie Court complex when it's built. So we've already established that. What's the time frame? Because this is the same government who ordered 2 new ferries for Tasmania without having a port that was able to actually have the ships. So we're really concerned about the time frame. I mean, that blew out by $60 million. So we need some confirmation of a date for when the court complex is going to be built.
Again, Senator Polly, we are in the hands of the Tasmanian government as to their project timeframes. We do understand that they are progressing a range of tender and planning processes. We meet with them regularly to ensure that the FCFCOA's needs are accommodated, and those conversations are actively ongoing.
So, Senator, if I could also just add, I think one of the things that we are conscious of, and I know that the Federal Circuit and Family Court of Australia is conscious of, is the ability to continue to have a presence while that building is going, because it can take some time for a new building to be established. So I know that there was circuiting arrangements are in place for this year. I would expect that there'll continue to be those conversations about what gets put in place over the coming years while that building is occurring.
So have we, from the Commonwealth's perspective, when do you think that the final agreement is likely to be signed off on with the Tasmanian government?
We met as recently as 10 days ago to discuss next steps with Tasmania, and they're providing us with further information, and we're continuing to engage with them, so that will determine ultimately any agreement that's to be finalised, the settling of those details.
So how far along is the Tasmanian government in terms of, have they finalised the structure and the plans for this court, and have they actually found a site?
I think that would be a matter for Tasmania. They've certainly spoken to us about what the court might need within a structure, and we have the opportunity to provide them some feedback on some initial drawings, but I think more detail about what the final arrangements are would be a matter for Tasmania.
Have we, is the Commonwealth Government contributing any funding for the new complex?
That again is a conversation that we're currently having with the Tasmania. We do expect to make some contribution, but there is a strong commitment from Tasmania and from the Commonwealth to ensure that there is a presence for the FCFCOA to circuit into Burnie, so that is an agreed commitment. The exact amount is to be determined.
So in the last 18 months, there's been a state election. Did that have an impact on the discussions and consultations in this process?
Senator, we've been having those discussions at official level. So I think there was obviously a period of time at which Justice colleagues in Tasmania were in caretaker, but we have continued to engage with them kind of throughout this year and last year. So I don't know that I can answer much further than that.
So how many meetings has the Commonwealth Department had with the Tasmanian Attorney General's Department? How many meetings have you had?
Senator Polly, I'd have to take that on notice, but certainly more than 8 or 9. We've had a lot of conversations over the course of that period to discuss progress and next steps and so on. I can take on notice the exact number.
I would appreciate that. Have you got a date for the next meeting? And for these meetings, is it not unreasonable to have an expectation of a timeline for when you meet? I mean, otherwise, you could still be meeting knowing that government over the next 18 months.
So, Senator, we understand Tasmania has a proposed pathway. I'm not privy to all of their project points. The step that we're involved in at this stage is they are consulting us on what the FCFCO needs might be in terms of ensuring that they have a presence that is fit for purpose for them when they circuit into Burnie. And so once we have spoken to the courts to determine whether their needs are being met, then we will arrange a further conversation.
Do you have the timeline for when the Commonwealth Attorney General has met with the Tasmanian Attorney General? Have you got a schedule of those meetings?
I think we would have to take that on notice.
If you could, and whether or not there's another meeting between the two AGs scheduled, and if so, when?
Again, we would have to take that on notice. It's not something we're privy to.
Thank you, Chair.
Thank you, Senator. Thank you, Senator Polly. Senator Tyrrell, we'll come to you because I think you might be on the same topic.
It's like we planned this. My questions are around the Federal Family Law Court as well, but basically it's the ramifications that flow on about the Tasmanian legal aid funding, which will flow on from that. On the 6th of September, the federal government announced $3.9 billion investment over 5 years as part of a new National Access to Justice partnership. In 22 and 23, legal aid commissions received additional funding known as the cost consequences when the new case management pathway of the Federal Circuit Family Court of Australia was introduced, and in acknowledgement of the additional legal assistance costs. This funding was not provided in the 24-25 budget. Tasmania Legal Aid's proportion of the cost consequences funding, approximately $723,000 annually, went towards the increased costs associated with providing independent children's lawyers and paying for new fee items required by the new court process. The demand for family law services and funding has not decreased. So Tasmanian Legal Aid and other legal aid commissions have had to reduce frontline services because of the shortfall left by no further cost consequences funding. National Cabinet committed to the Commonwealth investment of $3.9 billion over 5 years, ongoing in frontline legal services to be provided through a new 5-year agreement to be called the National Access to Justice Partnership, commencing on 1st of July next year. Will the department continue to supply cost consequences funding so Tasmanian Legal Aid and other legal aid commissions do not lose out under this new funding arrangement and won't have to withdraw more frontline services? Big question, sorry.
That's okay. Thank you, Senator. So under the new National Access to Justice partnership that we're continuing to negotiate with the states and territories, that will include the funding that's currently under the National Legal Assistance Partnership, but kind of at the amounts that reflect the dollar amounts from 2025 onwards. But it also incorporates a range of other parts of other funding streams that were in the NLAP, which were all ending on the 30th of June next year. So they've all been included and importantly made ongoing. The funding that you were referring to specifically was 2 years worth of funding, which was always intended to be non-ongoing funding. So that funding has not been included in the National Access to Justice in that amount. What is in there is additional funding to go towards things like indexation and pay parity, as well as additional services. So we're still finalising the negotiations. Okay. So in terms of the exact amount that will go to each jurisdiction, that isn't yet, we haven't yet agreed that with those jurisdictions.
So within those conversations, are we taking into account that a lot of these services are depleted for staff and that they're under-resourced at the moment?
I
know that's an opinion, but...
The additional approximately $800 million in the National Access to Justice Partnership does recognise it both has a component which is around enabling particularly those community legal services to move towards pay parity, and it also has better indexation attached to it because under the National Legal Assistance Partnership the indexation was fixed. As well as having additional funding for frontline services.
You say pay parity, but a private lawyer versus a community lawyer, there's a huge difference. It's usually an emotional attachment that these people have towards what they're doing rather than a dollar. How do you get pay parity out of that?
So the pay parity is between legal service providers,
okay,
not between legal service providers.
So they're really just not going to be able to...
private sector.
Okay.
I mean, speaking frankly, we couldn't compete with private sector salaries, but the intent is to prevent legal aid commissions are able to pay the best salary, and the intent is to prevent good lawyers who are prepared to work in community legal centres moving to legal aid commissions for slightly higher salaries. So to try and get parity across the legal assistance sector.
Yeah, it's frustrating because I know that every single one in Tasmania and no other states and territories would be the same. They don't have enough staff. They're actually not being able to service children's cases and, you know, lots of other things within their communities. If the government does not continue the $17.1 million cost consequences funding, which you've said they're not, for legal aid commissions, it will create a problem with service provision. Does the government accept that legal aid commissions will have to use the funding to maintain existing frontline services and may be unable to expand their services for victim survivors of domestic and family violence?
So Senator, the funding that was provided for those first 2 years was to acknowledge the kind of the transition piece from the with the new I think it was the case management approach being taken in the FCFCOA, and the additional funding that I referred to beforehand will go to all parts of the sector for their use.
But also the current government's announcement to invest in domestic violence issues, should that have a flow-on effect into community legal and legal aid services? So
obviously in family law matters, we know that there are a range of, we know of people in family law matters can experience family and domestic sexual violence, and that's obviously a focus of the system and a number of the reforms that have taken place, and that funding that is provided for legal aid commissions would enable them to be able to use it in those cases.
Senator, I just note, just in terms of the heads of agreement that was signed between the Commonwealth and the states and the territories at the National Cabinet Agreement, It sets out Commonwealth priorities that the states will administer, and it specifically references family law matters, combating gender-based violence against women and children, particularly First Nations women and children, as well as a range of other areas. But that is a very key priority for the Commonwealth in the new agreement.
Yep. Does that take into account same-sex relationships as well?
It wasn't particularly
Sorry,
distinguished
same gender,
from it, but
apologies, but yeah.
If that means that women or children are subject to family violence, then they would fall within that.
But what if it's two gentlemen?
In terms of gender-based violence against women and children was what I was specifically referencing.
Okay.
But if there are individuals that are experiencing violence in their relationships,
I don't mean to be a problem, but families look so different now.
Yeah, understood.
Okay. Look, 500 million of the 3.9 billion investment for the National Access to Justice Partnership will go towards expanding legal assistance services delivery. How is this funding being allocated, and will any of this funding be prioritised for people living with disability or veterans, given the recent recommendations in the Disability Royal Commission and Defence and Veteran Suicide Royal Commission reports, and the closures of national legal assistance services for these priority groups?
So, Senator, I referred earlier to the negotiations that we are currently having with the states and territories, and that negotiation is still underway.
So it's standby.
And that will have then the allocations to each of the states and territories. The funding that is provided through the national the current agreement is quarantined, and the funding that will be provided through the next agreement will similarly be quarantined to different parts of the sector as well. So the legal aid commissions, the community legal centres, etc.
Thank you so much for your time. Appreciate it, Chair.
Thank you very much, Senator. Senator Cash, you have the call.
Thank you very much. If I could just return back to the issue I was exploring before, and I want to follow up the social media issues. Can I also just ask, though, a Deputy President of the ART, I think a Deputy President of the AAT was paid almost $500,000. What is a Deputy President of the ART paid?
Senator, I think it's a similar...
It's a similar amount.
I think it's similar. I know that there was a new Remuneration Tribunal determination, and I think it's similar. I think we have...
It's about $500,000.
We could access that through the course of today.
Yeah, that's fine. But I just wanted to get the comparison. But it is around the same, around the $500,000. I think we were just exploring the social media checks that are done, A, in the first instance on this Deputy President, Ms Thompson, but B, more generally, and then we got interrupted. Take me through what social media checks. Take me through what is the check when someone is applying for such a position.
So, Senator, I think I indicated I would need to go back and check the exact record, but there are a range of searches undertaken by the team.
And you'll be able to do that for me. And also, could you specifically do in relation to Ms Thompson? Secretary, are you aware if these tweets were identified during the selection process?
Senator, I should note this is you tabling these documents is the first time I've seen these tweets. I'm advised that we weren't aware of them prior to this. So, no, I haven't been previously aware of them.
That's fine. Is anyone in the department, were they aware of these?
Senator, I will need to check with the team, but I would be surprised.
Okay. Secretary, well, that brings up a different issue in terms of the social media checks that are actually undertaken, given this was a live Twitter account. And again, are you able to get for me, after the morning tea break, exactly what is the social media check that is undertaken?
Yeah, we can try and give a fuller detail. I think there will be an issue in terms of the the time frame and how far we go back. Some people are very, very active on Twitter.
Yes, this particular person was.
So that may create some issues, particularly when you're doing so many appointments. But we'll look to see if we can give you any more specific detail on that.
Thank you. I am just going to table another tweet, just so it's on the record, and again, tweeted by Claire Thompson. It was a retweet from the 9th of November 2020, but again, it's just the vile nature of what has been tweeted. An image of Donald Trump decapitating the Statue of Liberty. Minister, given the tweets that I've read out, and this one now as well, which you'll soon have in front of you, an image of Donald Trump decapitating the Statue of Liberty, do you think that these tweets are appropriate?
Well, I haven't seen the tweet you're talking about, but I'm finding it...
presented
Thank
to you now.
I'll have a look at it. I mean, the idea that you, of all people, would be questioning appointments to an administrative review tribunal, I think is just incredible.
Sorry, point of order, Chair.
Well, exactly, that's not an answer to the question.
Well,
it's the minister's not responding to the question. He's making personal.
He's
making personal reflection.
Do you accept
It's a personal reflection on the senator.
No, what I accept is that under this government, to be appointed to the Administrative Review Tribunal, it was not an almost essential criteria to be a member of the Liberal Party, although it turns out that the person we're talking about was a Liberal Senate candidate.
30 years ago.
When your government was in power, you appointed 85 former Liberal MPs, staffers, candidates and other hangers-on to the Administrative Appeals Tribunal.
That is not the issue.
And you're asking questions about one of the former Liberal appointees that we have appointed to the ART.
This is not the issue we're discussing. We're discussing whether or not it is appropriate for a Deputy President of the Administrative Review Tribunal to have made what I consider to be utterly vile tweets of a partisan nature as well, and what's going to be done as a result of it. Are you in any way trying to defend
I've already
these
said
tweets?
that Ms Thompson, that if these are in fact Ms Thompson's tweets, she has used language that I wouldn't use myself. But the notion that Ms Thompson is a partisan appointment, I mean, obviously her politics have changed substantially over the years from being a Liberal Party Senate candidate to being someone who was encouraging a vote for the Labor Party at the last election.
And that is the exact point. They are partisan in a tribunal that is meant to be independent.
When Ms Thompson's appointment was announced, in the very same announcement, I'm not going to name her for her own privacy, but a former long-time Liberal Party staffer was also appointed at the same time as the Deputy President. The former member for Bass, Mr Nikolic, was reappointed to the ART. So you've got an issue with people being appointed who have expressed a view in support of the Labor Party, but you don't have a view with a former Liberal MP appointed, a former Liberal staffer being appointed, along with the 85 Liberals that you appointed when you had the opportunity yourself.
It is the nature of the vile tweets that we are discussing. And if the situation was reversed, I would be sitting there answering questions on your behalf, which I have in another committee before in relation to particular people.
I remember asking you lots of questions about Liberal Party appointees.
The vile tweets that we are discussing. And quite frankly, I would have thought that even the Attorney-General of Australia would not appreciate you sitting here and trying to demean and deflect the nature of these vile tweets. I would have thought the Attorney-General himself would come out and say, quite frankly, they are disgusting.
Well, I've been reminded that, again, when you were in government, your government appointed and retained Mr Warren Mundine on the SBS board, despite him calling a journalist the exact same C word on Twitter. You didn't remove him. Why is it that you've only got an issue with people who
this has been brought
change their politics from being Liberal Party members
and if
to
you
Labor
are
Party
in
supporters?
any way trying to deflect, then quite frankly, shame on the government. This is a new tribunal that is sitting in judgment
with proper
on people.
appointment processes.
The Attorney-General made a huge song and dance about the tribunal being non-partisan, and we will be going through a number of the appointments. But instead you've appointed someone who in the first instance is a Twitter warrior, and I would put to you, in the vilest of terms, using
like
vile language against those she doesn't like. She is a Deputy President on $500,000 a year. So can I ask, Minister, was Mr Dreyfus or his office aware of the social media history in these tweets by Ms Thompson?
I'd have to take that on notice.
Well, considering he's clearly watching the process, or his office is, I would have thought that they can respond to that pretty quickly.
But hang on. So in your view, it's disqualifying behaviour to use words like that to be appointed to the ART.
Let's be very clear,
but
Minister.
It's not disqualifying
I am the one
for
asking
your
the
government
questions.
to have Mr Mundine use the same language as a member of the SBS board.
I am the one asking the questions. The questions are in relation to an appointment by your government as a Deputy President on almost $500,000 a year, and that will be given to me, the exact salary later.
The same salary as the former Liberal Party staffer.
That is what we are referring to. If you are trying in any way to deflect or say that these tweets are not inappropriate, I do not agree with you. I want to now explore the process that is undertaken by the department to determine whether or not this was identified during the selection process.
Well, I suspect a Google search would have shown her former Liberal Party candidacy.
What was the advice given to the Attorney-General? As I said, what does this do to the credibility of the ART when you have people raising this as an issue in terms of utilising such vile language?
The only when you're speaking about yourself in the third person now, you know, people raising this, you're the person who's raised it, and you question the credibility of the ART. You were a lead member of a government and you were the attorney who helped appoint 85 former Liberal Party MPs, candidates, staffers and other hangers-on.
And again, Senator Watt, this is not about the previous government. This is about a particular
And we've appointed former Liberal Party members,
that you
former Liberal
have
Party
staffers
staffers.
as a government
your own former candidate.
the ART. And
Senators,
the tweets that have been discovered.
We're getting Senator Cash.
Secretary, can I ask, do you accept that
Senator Cash, if I call you to order,
I couldn't hear you.
just
Senator, I couldn't
can't hear me over your own voice, Senator. I am going to try to assist you by stopping the back and forth debate which is occurring and ask you if you've got some questions which I think you were about to put.
Yeah, exactly.
Let's put those questions to the department.
Does the department accept that the tweets are problematic and inappropriate now that they have come to your attention?
Senator, obviously I think I would like to be in a position to be able to undertake a review and to assess the tweets.
Yeah, and that was going to be, so in the first instance we're going to undertake, or the department will undertake, a social media, that you'll check to see what social media searches were actually undertaken and whether or not these tweets were actually discovered. Now that these tweets have been put on the record, what is the process from here? Will the department raise this with Ms Thompson? Or, Minister, will the Attorney-General raise this with Ms Thompson?
Well, I'll take that on notice. But again, you might remember it was only a couple of years ago that Mr Barnaby Joyce used very similar language about then Prime Minister Scott Morrison.
Well,
he said,
again, clearly
he described
you're being
Mr Morrison,
fed
he is a
information.
hypocrite and a liar from my observations, and that is over a long time.
Well,
should he resign?
Senator Watt, you're being fed
Should
information to put on the record to try and deflect from the line of questioning that I'm asking, and I accept that. I don't have an issue with that.
No, but so far we've learned
this is in
that
relation
your own member of the
to
SBS board has used the same C-bomb under your government.
From someone
the former
you have
Deputy
appointed
Prime Minister has
as a
used
Deputy
hypocrite and a
President
liar
of
to
the Administrative
describe Mr.
Review
Morrison.
Tribunal.
Are you calling for their resignations?
Again, this is in relation to someone you have appointed as a Deputy President, or the government has appointed as a Deputy President of the Administrative Review Tribunal, and I'm going through the process as I am entitled to do. So we've established that the department will go away and undertake, will find out what social media searches were undertaken in relation to Ms Thompson, but also more generally, what is the social media profile, whether or not these tweets and any other tweets of this nature or any other social media of this nature was identified during the process, but also whether or not that was provided to the Attorney-General or his office and brought to his or his office's attention. Just in relation to Ms Thompson, did she apply or was she asked to apply for this position?
Senator, all the people who went through the process applied in response to the adverts.
So the adverts that were placed in...
Adverts that were placed in the, I can't recall the various press, but the non-judicial Deputy President positions were advertised.
Okay. Just Secretary, in terms of the Public Service Code of Conduct, my understanding is that the social media policy, and you have a social media policy, obviously, it actually states, and this is in relation to the Public Service Code of Conduct, members should be mindful not to post anything on social media which might damage the integrity or the independence of the tribunal and thus compromise the public's trust and confidence in the tribunal and undermine the objectives in Section 9 of the Act. Members should treat anything that they publish on social media as being able to be accessed publicly and permanently. And then it goes on at paragraph 10.1. So this is the ART Code of Conduct. A member must not engage in a public service activity where, because of the nature or purpose of the activity, the identity of other persons engaging in that activity for any other reason, there is a reasonable prospect that the member's engagement in the activity will A, detract from the member's impartiality or independence as a member of the tribunal, B, detract from the independence of the mechanism of review established by the Act, or C, damage public trust and confidence in the tribunal. It then goes on to say, at 10.5, a member must not publish anything on social media that criticises the tribunal, a member of the tribunal, judicial as well as non-judicial, or any tribunal decision. And 10.6, a member must not publish anything on social media that is offensive, insulting, humiliating or degrading towards any person or groups of people. So I put to you, Secretary, do you think that these particular tweets are insulting, humiliating or degrading?
Senator, you're asking for my opinion.
In the context of the Code of Conduct. An opinion would need to be formed.
I'm not quite sure which Code of Conduct.
The ART Code of Conduct, and I'm happy to have that tabled for you.
Yeah. Anyway. But I think you're asking me for my opinion about that, which I don't think it's appropriate for me to provide.
Yeah, I do need to rotate the call as well, Senator Cash. I'll do that now, and then we'll go to the break at 11. I'll give you a small chance, Senator Goshen, and we'll have to cut you off. We can come back again.
No, thank you. Thank you, Chair. I'd like to ask some questions about the Justice Reinvestment initiatives being undertaken by the department.
Yeah, thank you, Senator. That is in this group. So Ms Harvey can commence, and she'll be assisted by Ms Woods and Ms Bogart.
So I asked some questions about these initiatives in the previous rounds of estimates, but can I just ask, I understand that there were another 6 initiatives announced on the 30th of September. Are you able to just outline the organisations that were the recipients of those grants and just briefly outline the initiatives?
Thank you, Senator. I might ask my colleague, Ms Woods, to briefly go through those.
Thank you, Senator. Cassie Woods, Assistant Secretary for the First Nations Justice Branch. I'll just grab the information for you. So the 6 initiatives that were announced in round 2, cycle 1 recently. I'm just trying to get my spreadsheet to work for you. The Aboriginal and Torres Strait Islander Corporation, FVPLS and Dejara. So this initiative is essentially it reflects a new way of doing things in the West, a community-led process to develop a common vision and self-determined agenda to address the rates of incarceration and drivers of contact with the justice system in Western Melbourne. I can go on, but maybe I'll give you a brief one on each of the
that'd
6.
be great. Just an outline. Thank you.
We've also got the Balcana Cape York Development Corporation. In terms of that, sorry, it's frozen again. For that initiative, it's looking at, sorry, this page is just not working. Let me grab a different one, which will help. No, it's fine. It's just the spreadsheets. Let me turn to my trusty papers. Apologies, Senator.
We'll go hard copy, Senator. Whilst Ms Woods is looking to get that, I think just to give a bit of an overview, there's 26 different initiatives that have now been funded under the Justice Reinvestment Program, 9 in Queensland, 6 in Western Australia, 6 in the Northern Territory, and 2 of those are located in Central Australia, 2 in New South Wales, and 1 each in South Australia and Victoria. They've been the subject of extensive engagement with local communities to identify appropriate organisations to work with, and under the program we've received a very large number of applications, but we've had a pretty robust process working with other relevant agencies to identify appropriate providers, and including working with states and territories, because for justice reinvestment projects to be successful, they need to be linked with different levels of government, and there needs to be an enduring commitment to these projects. They're not going to change the world overnight, but they will, we believe, over time, be highly effective in diverting people from the engagement with the criminal justice system.
Sorry, I found it. Oh,
And so I'll just follow up on that answer from the Secretary. So I appreciate that there are 6 new initiatives, but in terms of the initiatives that were funded in earlier rounds, can I just ask if you have any indication of feedback or evaluations or some early signs of success, appreciating what you just said about it being a long-term process?
Yeah, I would caution it is very early in many of these projects. We have built-in evaluation frameworks for these projects. I think it's really critical to be able to build an evidence base of the actual impact they're having in local communities. But I'll just see if Ms Woods wants to add to that answer.
Thank you, Secretary, and thank you, Senator. As the Secretary mentioned, justice reinvestment is long-term, and we do have activity work plans that are established with each of the initiatives in consultation to set out the expectations, deliverables, and be able to measure against that at a grants level. But in terms of, I guess, looking at good news stories. You know, we've already had testimonials come through in terms of some initial wins, I guess, in terms of outcomes that are happening in community. I'd like to, I guess, highlight a couple of those stories that we've had. You know, we've had an initiative where a family was referred to it based on a community connection and identified at-risk students based on attendance. We had subsequent identification for the need for wraparound support and facilitation of contact with a range of family and health support services, and an outcome of significantly improved school attendance and behaviour. And I'll draw you back to the fact that justice reinvestment really is about preventing contact with the justice system, and so tackling those socio-economic factors that lead children and adults into contact with the system is really important, and so this is a real demonstration of that. I guess another one I'd like to highlight is an initiative delivering a diversion and support program for young Aboriginal people involved in or at risk of involvement in the justice system. A pilot camp has been run, which was very successful, with all participants eager to return for the next iteration. So at the community level, at the place-based level, these initiatives are, though in their infancy, they are already having an impact.
I'm just going to stop you there, Senator Ghosh, and we're going to come back. The committee is going to suspend for morning tea and come back at 11:15 a.m. Thanks, everyone.
Thank you.
We will resume its hearing, and we are continuing our questions of officers from the Justice and Communities Group of Attorney General's Department. Senator Cash will return the call to you, and then we'll go back to Senator Ghosh.
Thank you, and I will continue along the line of questioning that I was previously commenting on. Just in terms of, Secretary, evidence is you hadn't seen the tweets or the offensive tweets that had been tweeted by Ms Thompson. And I know you're undertaking a social media search. How were they, though, missed?
Well, Senator, I can't talk to the specifics of this one. We're still needing to undertake inquiries. I think we would, in relation to any statutory or judicial or tribunal appointment, we do some general internet searches that should capture social media usage as well. I think sometimes, though, that may be affected by the profligacy of people if they are massive users and it goes over 4, 5, 6 years and there's thousands of tweets. That is a challenge, a practical challenge to work through. But I can't speak to the specifics of this one just yet.
Okay, so we'll narrow it down then. I understand the evidence you've given. We'll narrow it down then. How many people have been appointed as deputy presidents of the ART?
I'll ask Ms Samios to assist with that.
I do have the figure, Senator. So there are 9.
There are 9?
Yeah.
Okay. And what is the position above a deputy president in terms of the hierarchy of the ART?
I think technically a judicial deputy president is at the same level, but there's a hierarchy issue associated with the judiciary, and then there's the president.
Exactly. So in terms of the 9 people, so I understand they're not members, this is 9 people who have quite a specific role. What social media searches were done in relation to these 9 people, given the importance of their role and what they will be doing?
Without knowing the specifics, I would say that.
I'm happy for.
Yeah, but,
that's not a problem.
I think there's a general procedure that we would apply to all appointments.
But hold on, so I'm specifically asking about, you've got the president, you've got a judicial deputy president, and then you've got 9 deputy presidents. Their roles are different to the roles of members of the ART?
Yes, they are.
Yes, they're paid more?
They are.
Yes, they have a different level of responsibility?
They do.
So I'm just trying to ascertain, you've now got the people that you're going to recommend to the Attorney-General, who would then, I assume, take it to Cabinet. Is there any additional due diligence done in relation to these people, given the nature of the position that they are going to hold, the nature of the decisions that they will make, and clearly also the significant salary that they will be employed under?
I think we would do the same search for any statutory appointment, any judicial appointment, any tribunal appointment. In general terms, I don't think we have a different type of search between deputy president, senior member or member.
That's right.
It's just a general approach.
It's a general approach. Okay, and I'm happy for you to follow up, and if that needs to change, for that evidence to change in terms of what may have been done for these 9 people.
Thank you.
Just in terms of the tweets that we've gone through, if those tweets were made now, given that you've had an opportunity to review the Members' Code of Conduct, would those tweets meet the Members' Code of Conduct?
I think ultimately that would be a matter for the President of the ART. The code is issued by him and it's for him to engage with the relevant people within the tribunal in relation to that. So that would be a matter for the tribunal itself.
So
But
just
also,
in relation...
Also, Senator Cash, if I can make the obvious point that the tweets weren't tweeted after Ms Thompson's appointment.
No, and I'm going to explore that
therefore,
shortly.
any of code of conduct didn't apply to her, unlike Mr Mundine doing a tweet with exactly the same word while he was a serving member of the SBS board.
You can continue to deflect. That is fine.
Well,
that is fine. The information's been fed to you.
You didn't seem bothered by Mr Mundine's tweet when you were standing up with him in a Liberal Party banner
you can continue
through the Voice campaign.
To deflect.
What?
This is
you're concerned about someone using words on Twitter before they're appointed to a role.
And the fact
not
that you continue to try and justify, quite frankly,
the same words
I
when
don't
they're
think
honourable.
it's appropriate for a Minister of the Crown. Minister, does the Attorney-General, his office or the Prime Minister's office have their own policies for vetting candidates' social media, or is it a matter left to the department?
I'd have to take that on notice. If the department may be aware, I'm not aware.
Secretary, could I ask you?
Senator, all I can speak to is we do undertake searches ourselves. I'm not aware if any additional searches are taken by the Attorney-General's office.
Okay. Were candidates for any of the roles, but in particular for the roles of Deputy Presidents of the ART, are they required to disclose any information that A, may affect their appointment, that B, should be brought to the attention of the government, or C, about their social media history?
Senator, there's a form that we require any... I think you'd be familiar with this, that when appointments are being prepared to be considered by Cabinet, there is a personal information... Private information declaration that is required.
Okay. Are you able to table a pro forma copy of the private information disclosure that is required? So not one that's been filled out, obviously, but the pro forma document.
I can take that on notice to table one.
Thank you. Did Ms Thompson disclose these tweets on the form or as part of the private information declaration?
Senator, I think that's sort of getting into personal information space, but can I take that on notice as to whether we can provide an answer?
It also goes to the integrity of the process. That's what I'm interrogating here. Was she required to disclose them, or was any of the candidates required to disclose their social media history as part of a vetting process?
I'll just need to refresh my recollection of the specifics in the private information declaration. I think there is something there to the effect of, is there any information that needs to be brought to the attention? But can I please take that on notice? And
not a problem at all. In the event that the private information declaration does require the disclosure and a person does not disclose and that's subsequently found out, what could actually happen to that person?
I think that's it would depend on the specifics. So it's hard to speculate in the abstract. I know you're relating it to this particular incident, but I think it would depend on a case-by-case basis.
Okay. Secretary, would you accept this kind of conduct from any of your deputies?
Senator...
I'm going to hope the answer's no.
Look, Senator, I think in terms of the public service, we're very keenly aware of our obligations. There is a social media policy that the APSC issues that is applicable.
Similar to, I would have this policy here.
I haven't done a comparison between the two. I suspect there is a lot of commonality between the two, but...
But if you were presented with these vile tweets from one of your deputies, I would hope you would consider that they were inappropriate.
Well, that is a hypothetical because I'm pleased to advise that I don't expect that any of my deputies would be tweeting.
Indulging in that type of behaviour?
Well, tweeting generally, I think is what I would say.
Can I also ask, the account's now been closed down. Was any instruction given to Ms Thompson, indeed any of the deputy presidents or any members of the tribunal, to close down their media accounts, their social media accounts, across any forum?
Senator, I have no visibility of that. It may be once they were appointed there was guidance given about, consistent with the Code of Conduct, about the appropriateness of engaging on social media. But I can't speak to that. I think that would be a matter probably for the ART.
Is anyone else aware whether or not guidance was given or even a request was given to the new appointees, but in particular the deputy presidents, obviously the Judicial Deputy President and the President, that they should close down any of their social media accounts?
No, so I can't speak to anything from the tribunal. In terms of the department, we have a pretty pro forma email we send to people shortly before their appointment, when their appointment's been made,
right,
before it's announced, that advises them that it will be announced shortly, and
yes,
they should be aware of their social media and settings,
okay,
but certainly not a request.
Are you able to also table that pro forma email?
I have to take that on notice.
Yeah, no, but not to anyone in particular, just the pro forma email. Minister, did the Attorney-General or his office have any discussions with Ms Thompson prior to her appointment?
I'll take that on notice.
Okay, prior to her appointment in relation to any topic, and then separately in relation to a social media profile?
I'll take that on notice, and I invite you to tell us whether you ever spoke to Warren Mundine about his tweet using the same
Minister,
word
the good
before
news
you
for me
campaigned
is
alongside him.
I'm on this side of the table and I get to ask the questions.
Pretty hypocritical,
so can you
though, isn't
also
it?
then advise, did the Attorney-General or the Attorney-General's office advise Ms Thompson at any time to delete her social media accounts?
I'll take that on notice.
Okay. Could you also please ask whether or not the Attorney-General or his office were aware of the social media accounts, and in particular what was on the social media accounts, and if so, when the Attorney-General and his office became aware of those social media accounts?
I'll take that on notice. Were you aware of Warren Mundine's account? Before you
could you also
campaigned with
take
him?
on notice whether the Prime Minister or the Prime Minister's office were aware of Ms Thompson's social media accounts?
I will take that on notice.
What was the evidence also was guidance that might have been given to appointees after the appointments. Could you also take on notice to find out if and when the guidance was given, but also when this account was actually closed down?
Senator, we could certainly provide, we'll take on notice that question about the that email that Ms Samios referred to.
Yep.
I'm not sure that we can take on notice details about an individual's account and when it was closed.
Or perhaps I can do that then through the Tribunal, because we've got the Tribunal coming on later on. If these tweets had been identified during the selection process, what would the process then have been? You've identified a series of vile tweets. What is then the process from there?
Senator, I think searches like this can raise some issues. It's hard to answer a hypothetical. It would depend on the nature of the information that a search...
Well, in instances whereby you have identified something via a social media search that you then consider to be inappropriate, what's the process from there? What's the process you've undertaken in the past?
Trying to think in terms of past instances. I think it would... I think at first instance probably a process of verification. I think understanding whether or not you've accurately identified someone's Twitter account, noting the different ways in which people name themselves on social media is not always easy, so I think there would be a process of verification and then, depending on the content of what was discovered, a consideration of whether or not there need to be a conversation with the proposed appointee.
Okay. Would you appoint someone yourself who'd engaged in that conduct and was applying to be a deputy?
It's a bit of a
Honestly, the hypocrisy, like seriously, when you're in a hole, stop digging.
Seriously, Minister Watt, honestly?
Warren Mundine did exactly what you are complaining about.
And the fact that you need to keep raising
kept him on the
this
board of the
is
SBS.
deflection.
Barnaby Joyce called Scott Morrison a hypocrite and a liar. You promoted him.
Deflection
If this is the best
and
you've got,
nothing
it is
more.
Hopeless.
So, Secretary, sorry, would you appoint someone who engaged in that conduct and was applying to be your deputy?
Senator, you're asking me to respond to a hypothetical. Obviously, in terms of anyone who's appointed or employed by the Attorney General's Department, I would expect them to be behaving consistently with the APS Code of Conduct.
Exactly. Thank you. Minister, given this issue has now arisen, will the Attorney General raise this with the President of the Tribunal or have a look and sit down, well, not with Ms Thompson herself, that would be for the Tribunal, but what action will the Attorney General be able to take?
I will take that on notice, but again, I make the point. These were tweets issued by Ms Thompson before she was appointed to the role.
And that's the whole point.
A few years after she was a Liberal Party Senate candidate.
In 1996.
And the very behaviour you have spent probably an hour and a half complaining about is no different to behaviour that Warren Mundine engaged in while a member of the SBS board under your government, that Barnaby Joyce has said about Scott Morrison and many other members of your party. You never do anything about them.
And again, this is an appointment
about
that your
these tweets.
government
Seriously.
made.
Senator
You keep
Cash, I'll have to
defending
rotate
them.
the call. You've got one last question.
I'll come back.
Okay, Senator Shoebridge, we're handing the call to you.
Oh, thanks, Chair. I'm just checking privacy. Is this section?
No, Senator, that's integrity and international.
Oh, my Lord. That section is going to be full. AI copyright.
Yes, that's here.
The December of...
Just get the relevant officers.
As they come. December of last year, the AG established the... It's got a terrible acronym, but it's the Copyright and AI Reference Group as a standing mechanism for engagement with stakeholders. They've had 3 meetings, is that right?
I'll ask Ms Ling, Ms Priestley to talk to that. That sounds about right, but I'll get them to clarify.
Jenna Priestley, Assistant Secretary, Commercial and Copyright Law Branch. Yes, that's right. The Copyright and AI Reference Group has had 3 meetings to date, and there's also been 2 meetings of its steering committee.
All right. The website doesn't contain any details about the meetings of the steering committee. When were those meetings?
Sorry, Senator, let me just find that information.
So, Senator, just the CAIRG does have a somewhat unfortunate acronym, as you have set out.
We can call it CAG, if you like, going forward.
Yes, the Copyright AI Reference Group, and it is a group of around 65 participants, and then it also has a steering committee sitting under it with 20 participants. The steering committee has met twice. On the 16th of April, the steering committee first met to discuss the approach to the first request for information from the reference group. So the reference group has assisted the department with a range of requests for information about their use of copyright. And then again on the 31st of August, the department met with the steering committee to discuss its approach to presenting the findings of that request for information, or questionnaire, as we have called it.
All right. So the
13th of August, sorry, I read that backwards.
13th of August.
Not the 31st, yeah.
Okay. So for the actual KEG, The first meeting, the website suggests the first meeting was on the 22nd of February, and that was was a video conference, a large group of people talking about how it would work, basically. Is that right?
Yes, Senator.
And then the third meeting was on the 4th of September, and that was feeding back the findings from was a feeding back findings about the process to that point. So the substantive meeting of the KEG is the one on the 29th of April. That's the one which actually did the work. Is that right? So we have 22 February, you set it up. 29 February, there's some information presented. And 4th of September, the summary of the Attorney General's Department presents the findings from the information gathering.
So on the 22nd of February, there was the initial meeting of the group, as you've suggested already. The 29th of May was a technical session where...
It says April on the website.
Oh. I have got May in my brief, so I'll take that on notice and come back to you, Senator, just to confirm that date. But that was a technical session where a number of technical experts presented to the group. And then the 4th of September was a meeting to discuss the results of an information request. In between those meetings, there was some out-of-session work done between the department and the reference group. So the first request for information was a questionnaire seeking insights on how copyright materials may be used to develop and deploy AI technologies. We put that request out on the 22nd of May and asked for a written response by the 12th of June. And there's been a subsequent request to the group seeking feedback on copyright and AI transparency issues, and specifically whether amendments to the Copyright Act are required. And that request went out on the 17th of September, requesting responses by the 18th of October, although we did grant a number of extensions.
All right. But the reference groups has only had those 3 meetings, and the entities that presented to that second meeting were Google and Canva, is that right?
Google and Canva presented. I believe there was a third one, but
I don't have the name of the third.
Well, it's not on the website either.
Google and Canva presented to that meeting, yeah.
Take it on notice if there's a third.
Yes.
Well, but both Google and Canva have an interest in not respecting copyright. Their large language model, Google in particular, its large language model hoovers up copyright protected material and feeds it into the system. Canva deploys AI models for its design work. Both of those entities have a strong interest in not protecting copyright in an AI context. Did anyone present to the KEG who had an interest in actually protecting creatives' copyright?
So, Senator, the technical briefing was set up at the request of the reference group, particularly around understanding the tech. So it was not intended to be a presentation of the positions of those companies in respect of copyright. It was to enable fulsome conversation at the reference group that was fully informed by the current tech settings, allow participants in the reference group to ask questions of those tech companies to understand. And it then flowed, of course, into the requests for information, which have produced a range of data sets about what copyright users and copyright holders are interested in terms of how AI may impact their rights holding or may impact their use of work. And so the reference group has invested a lot of time in understanding all sides of the conversation.
Is the summary talks about the summary of findings, or the findings document, talks about the number of responses, and there does seem to be a preponderance within the reference group of AI developers, AI deployers, AI users. and industry bodies, they seem to be the majority, a fairly comfortable majority in the reference group. They obviously all have a potential collective interest in AI not protecting copyright.
Senator, we would be happy to take on notice and provide you with a full list of membership of the AI reference group. I think that there are very wide-ranging members of that group. Of course, again, it is important that we hear from all sides of industry, both rights holders and users, but certainly there is strong representation from copyright holders, from creative and from the creative sector, but we were keen to ensure that all parts of the industry were present and part of that conversation.
So to be clear, is it the direction, has the government given a direction that they want this process to better protect copyright in AI, or to better facilitate AI's use of copyright? Is there a clear direction here to actually protect creatives' rights and remuneration and living?
There is certainly a strong interest in understanding the best way to support creatives. I think in the engagement to date has demonstrated that whilst there are some concerns from creatives about the impact of AI, there are also aspirations for the potential of AI to be used by creatives. So I think it's getting that balance right in terms of both perspectives.
I think the Copyright and AI Reference Group has a focus on the operation of the Copyright Act and the assurance that the Copyright Act will deliver the rights holders with avenues for asserting those rights, and that can take on a number of different features, but at its core it's government's interest in ensuring the Copyright Act will continue to effectively look after those rights that are protected within the Copyright Act.
One of the key issues, particularly from an Australian context, but it's an issue globally, is protecting First Nations cultural knowledge, protecting First Nations artists, cultural rights, but also obviously copyright as well. I had a look at the steering committee, the membership of the steering committee, which is 20 members deep. I can't see a First Nations rep on the steering committee. Given how important protecting First Nations cultural and copyright interests are, how do you explain that?
I'll let Ms Lineker or Ms Priestley talk to that. I know that there have been a lot of significant developments in terms of protection of cultural knowledge recently at the World Intellectual Property Organisation, and a pretty historic agreement that's been established there, but I'll let Ms Lineker speak.
Thank you, Senator, and I think it's certainly been something that we have turned our minds to together with stakeholders. The steering committee does have First Nations representation on it to ensure that we are accessing those perspectives as well, as I have said.
Well, there's a list of 20 people.
Senator, so I understand Tui Raven from Deakin University represents some of those issues.
Is Tui Raven there in a capacity representing Deakin University or in a capacity representing First Nations groups?
I'll have to take that on notice.
Is that who you point to, the Deakin University rep?
I think that we have tried to establish a forum in which those that have interests in this topic and wish to be part of the policy conversation are able to access that conversation. But it isn't the only way that we would say that people can represent views within this conversation. There are a number of different conversations that occur regularly across government in the context of First Nations intellectual property.
Is there any representation, express representation of First Nations peoples in the KEG?
I'll have to take that on notice, Senator.
Was this part of the system design to ensure that First Nations rights, particularly protecting cultural heritage and cultural rights, is this part of the system design when you're looking at how AI can hoover up creatives' work? And if so, explain how, because it's not apparent from any of this material.
It's certainly something that we are turning our mind to, and an issue that has been raised through our consultations with the reference group to date. I'd have to take on notice the specific capacity that members of the reference group are participating in. And I'd also note that we're also working closely with the Office for the Arts, which is leading a process looking at the creation of a standalone right for Indigenous cultural intellectual property.
I appreciate the response, but that's really, this is something that looks like it's been strapped on as a result of the consultation rather than being actually a core part of the consultation. And for myself, I think that's poor design, and it's not doing justice to First Nations cultural rights. And but I look forward to those answers on notice.
Senator, sorry, do you mind if I just come back and answer two questions I took on notice earlier about the dates of the second reference group meeting was on the 29th of May. The website is incorrect, so we will update that. And the third organisation that presented at the technical session was the Gradient Institute.
What's the Gradient Institute?
I'll have to share the call in a moment, Senator.
They're a specialist think tank.
All right. I am going to go into something else.
Okay, thanks, Senator Shoebridge. Senator Ghosh, you have the call. I'll come back to you.
Thank you very much. I'd like to ask some questions about judicial appointments.
Just ensure the right people are at the table.
Yeah, thank you. So the Australian Law Reform Commission released a report entitled Without Fear or Favour that related to impartiality in judicial appointments and the appropriate operation of the law of bias. Can you describe the process for federal judicial appointments that the Albanese government has now put into place?
Thank you, Senator Ghosh. The ALRC report recommended that government consider merit-based appointments, and government has proceeded to put a merits-based appointment process in place. A merits-based appointment process involves an alert, the Attorney General being alerted to a vacancy, that vacancy then being advertised for both the Federal Court and the FCFCOA. The High Court undergoes a different process. The advertisement calls for expressions of interest for all members of the community. The advertising occurs through a range of different places, including local newspapers, Seek, LinkedIn, Lawyers Weekly, and after the advertisement, people may submit an expression of interest through the Attorney General's website, nominating for consideration for an appointment on either the FCFCA Division 1, FCFCA Division 2 or Federal Court. The form of that advertisement can differ depending on the vacancies the Attorney-General has asked the department to consider as part of that process. Once the applications are received, then the department prepares, the Attorney-General advises the department of the formation of a panel for consideration of those applications and shortlisting, and the department works with those panel members to organise times for appropriate consideration. There are often a large number of applications. So, for example, the current rounds of appointment EOIs that are being run in the Federal Court, it's just been advertised they received 172 applications or EOIs, and the FCFCA received over 250. So the department then collates that information, prepares it for the panel, briefs the panel on the task before them, which is to provide a selection report to the Attorney-General with some recommendations of those that may be suitable amongst the candidates for his consideration. And the panel will then meet. Now, there's a huge number of applications, and the panels will often have to meet several times to assess those applications and to form a view as to shortlisting, which would then go to a selection report for the Attorney-General's consideration, or shortlisting followed by interview, in which case the panel would meet again to interview those who've submitted an EOI for application. They would be interviewed, and then the panel would finalise a selection report with the assistance of the department. The Attorney-General is then briefed. After the Attorney-General considers the selection report, he will advise as to which candidates should fill the vacancies that are currently on offer from that report, and then the department prepares relevant documentation for the Cabinet and Exco process to finalise that appointment.
Can I just ask about the timing of that process and how that's worked? So how long are the advertisements and expressions of interest periods? What's the period of time that the panel has to consider those applications? And I appreciate that's a very large number that you've just indicated. And then how long does it take to do the interviews and reference checks? And then if you've got the answer in terms of from the beginning of that process to when a recommendation is made to the Attorney-General?
I could give a general guide, but each process may differ depending on the number of applicants. The availability of panel members can be quite difficult. They're often very eminent people who have agreed to take time out of their day-to-day work to commit to assisting the Attorney-General with this process. So lining up all of those panel members for shortlisting dates, as I've described, or for interview dates, having the selection report settled by those panel members. There can often be some back and forth, as is normal in any recruitment process between panel members. So from commencement of an agreement to advertise right through to the final decision by the Governor-General can take, on average, around sort of 3 months. Is a very fast process. That would be incredibly ambitious, but we would obviously always try best. And then I think more generally we find it takes in the realm of 5 to 6 months over the course of a very large field of applicants. But again, I'm being very general. There are many different factors that go into each round.
So, has there been a merit-based process, or was there a merit-based process in place, appointment process in place before this program was implemented or this policy was implemented?
Senator, I think the department's answered some previous questions on notice on this, and I can indicate that prior to this process there was a different process in place which didn't necessarily involve those steps that Ms Lineker has taken you through.
In terms of the time period that you've just indicated, so I appreciate that that's a general indication and ranged between 3 and 6 months. How does that compare to previous appointment time periods historically?
I don't know that we've...
Senator Ghosh, I'm relatively new to this space, so I have not experienced previous time frames in terms of the process as such, but we could take it on notice.
Yeah, if it's possible. I mean, I appreciate that it's different systems, so it may not be possible, but if it is possible to give an indication of the comparison of those timeframes, that would be very helpful. Chair, I'm going to move on to a different topic, which is the National Legal Assistance Partnership. Do you want to...
I'll have a bit of time and then I'll hand call to Senator Cash.
Wonderful. I saw it was announced that there's a new National Access to Justice Partnership, which replaces, as I understand it, the National Legal Assistance Partnership, which was in place beforehand. Are you able to just, in very brief terms, outline its key elements, when it starts, how much money the new agreement reflects, and how much money is in the new agreement, and how much of that is new funding?
Thank you, Senator. So we currently have a National Legal Assistance Partnership, which will expire on the 30th of June next year. In the lead up to the expiry of the NLAP, the Commonwealth is negotiating a new 5-year agreement with the states and territories, which will be called the National Access to Justice Partnership. The NAJP. We haven't quite nailed the acronym. And it has a number of... if I go back a step, on the 6th of September, the National Cabinet met. Coming out of National Cabinet, there were heads of agreement which kind of outline what the new agreement will be. That also included an announcement of the funding. So the National Access to Justice Partnership will have $3.9 billion in it. In broad terms, at the moment, the NLAP has about $2.4 billion in it. So it's the existing funding in NLAP, but put into tomorrow's money worth. I can't remember the technical term, but the thing here. So there's additional that funding there. It will then also become an ongoing agreement from the 1st of July next year. That funding will be ongoing, and it will be both the baseline funding as well as under the NLAP through the course of it, as additional funding has been made available, then additional streams have been included in there. They were all terminating on the 30th of June next year. They've also been rolled into the baseline as ongoing funding. In addition to, I guess, what's in NLAP, there's some additional programs that are being included in the NAJP. And in addition to that, there will be around $800 million, which enables better indexation to be applied to the next agreement, which enables working towards pay parity for the community legal sector and additional frontline services. So that agreement is still being negotiated. So I guess that's why I went to the top of the kind of headline notes there, but that's where we're up to.
And are you able to indicate how the report of Dr. Mundy into the National Legal Assistance Partnership has informed the National Access to Justice Partnership?
Senator, Dr Mundy's report, which was published earlier this year, was taken into consideration. We've informed the features of the new agreement. I might get Ms Wang to speak a little bit more to the particular ways that some of those have been reflected in the heads of agreement.
Certainly. Thank you, Senator. Leigh Swan, Assistant Secretary of Justice Agreement and Task Force. As Ms Harvey mentioned, and Dr Mundy's independent reviews, the purpose of the reviews is to inform the development and the negotiation of the next agreement. As Ms Harvey mentioned, the agreement is still currently being negotiated. But in the broad terms, the Mundy review made 39 recommendations to Commonwealth and the states and the territory governments. If I can summarise, there was a few key themes in his report. It mentioned the funding certainty. It mentioned having a proper indexations, pay equity issues between LACs and the community legal lawyers, and a more efficient administration arrangement, and the capability building and the closing the gap reforms. And all those key themes has been a feature of the negotiations. As the agreement is currently still being negotiated, I can't go into the details of what the terms of the next agreement, but as Ms Harvey already mentioned a few things, there are additional $800 million, have a better, more proper indexations, their funding set aside to reduce the pay disparities. So there are a range of things, and you can see how the Mundy's review informed the next development of the next agreement.
Sorry, one second.
Just one more question.
May I ask how the funding contained in the new partnership agreement will help the victims of family and sexual violence?
Senator, the National Access to Justice Partnership will have two particularly quarantined... Sorry, let me go back a step. Under the National Legal Assistance Partnership, there are quarantined streams of funding, so for community legal centres, legal aid commissions and National and Aboriginal and Torres Strait Islander legal services. That would be then extended and included in the next agreement would be funding for family violence prevention legal services and also for women's legal services. So both of those, of course, have a strong focus on family, sexual and domestic violence. But of course, I would acknowledge that across the sector there is work that goes on around that issue in a variety of contexts as well.
Thank you. Thank you, Chair.
Thanks, Senator Gosh.
Turn to judicial appointments. Secretary, at the last estimates, I asked you a series of questions about the impact of delays in appointing judicial officers, and that information has now been updated. Can I just please confirm that in relation to the Federal Court, there was a delay of 61 days before the appointment of Justice McDonald?
Senator, I'll ask Ms Lineker and Ms Priestley to talk to the details.
Thank you very much. Thank you. So again, that was just, can you confirm that there was a delay of 61 days before the appointment of Justice McDonald?
We might need to come back with you or we just find that. Oh, yeah.
Senator, I can confirm that.
Sorry, was that you, Ms Harvey?
Yes. Sorry,
thank you.
yes,
Sorry.
Senator, yes.
Thank you. So they confirm that's 61 days before the appointment of Justice McDonald. Are you able to confirm that there was a delay of, I think it's almost 8 months, 233 days before Justice Needham was appointed?
Senator, Justice Jane Needham, I have 233 days. Sorry,
233 days. Thank you very much. Just in terms of notice for Justice McDonald and Justice Needham, how much notice did the department have that those positions were due to become vacant?
Senator, I don't have that information in front of me. Might take that on notice.
Do either of the other officers know?
I'm not sure. We might take it on notice and see.
When would you normally find out that positions are due to become vacant?
It can depend. Sorry, it's a very broad answer, Senator, but obviously when people are a judicial retirement age, the mandatory age of 70,
yes.
So we are aware in advance of that. Sometimes judicial officers will retire earlier or take extended leave ahead of the mandatory retirement date. So it can depend a little bit on the personal circumstances.
So in relation to Justice Needham, the reason was he turned 70?
I don't have that.
Could someone check that for me?
We'll take that on notice.
Need to determine who Justice Needham replaced.
I think we would have to come back to you.
Oh, sorry, the replacement for Justice Needham, sorry,
yes.
Turned 70. And also the replacement for Justice McDonald. Prior to him, what was the reason and when did you become aware?
Yes, we'll take that on notice, Senator.
Now, my understanding also is it 4 newly funded positions in the federal court?
There are, Senator.
And that was a budget measure?
Yes, it was, Senator.
Okay. And in terms of that budget measure, was it just the 4 newly funded positions? Was it 4 newly funded positions?
There are 4 positions in the federal court.
Yes.
That were funded through the budget.
Right.
There were 2 separate measures, Senator, that
yes.
deliver the 4 new positions. Right. 2 of them arise out of a migration measure and
yes.
2 arise out of a native title measure. And then there are, yeah.
Okay, thank you. And who's been appointed to those 4 positions?
So, Senator, the process is underway, and there's been advertisements. There's been I get one of my colleagues to run through it, but there has been a process, and so that is well advanced.
So those positions, though, are currently vacant?
Senator, they haven't yet been filled.
Currently vacant is also a way that you could say that. In terms of the funding, when did it become available? Was it the 1st of July this year?
Yes. Yeah. For both?
Yes. That is correct. So the 1st of July this year, the positions were funded. The department would have been aware of the funding from at least the announcement of the budget night. Is that correct?
Senator, we would have been aware of it, yes.
Yes, okay, thank you very much. In fact, the department would have been aware of it presumably before that in terms of the proposal that went through the budget process.
I won't go to the budget process, Senator, or when the department was aware of it, but certainly from budget.
I'm just trying to confirm the delay in relation to these particular appointments. Even if we take it back to the 1st of July of this year, July, August, September, October, November, it's 4 months. And then from the budget, it's approximately 6 months or more. Why haven't they yet been filled?
Senator, I'll just say, I'm not sure if you heard Ms Lineker gave a very detailed explanation of the process involved in appointments. And of course, we wouldn't initiate any process until after the budget has come down. And so the process was initiated after that. And I think Ms Lineker may be able to give us some more up-to-date information on exactly where how the process has progressed. But I think in this instance, it's moved fairly well.
Yes, the process is well in train.
The budget came down in May, money was available from July, and it's now November, and the positions are still vacant. Is that correct?
So, Senator, the roles were the judicial vacancies were advertised in August.
They were advertised in August, but the money became available on the 1st of July.
Yes, Senator.
Why weren't they advertised on the 1st of July?
Senator, there is a range of work undertaken by the department around judicial vacancies, and there's a range of things that go into the advertising.
So take me through the range of work that was done by the department in relation to these 4 judicial vacancies, and what date in October were they advertised?
August. Senator, they were advertised on the 16th of August.
16th of August. Okay, so that's 6 weeks after the funding became available. So what work was necessitated by these 4 appointments that was different to previous appointments that meant an almost 6 weeks?
So my statement there, Senator, was simply that there is a range of judicial appointment processes. At any given time, we have a team that manages that, and that this was part of the work of that team.
Okay, but again, I'm trying to ascertain, you knew about them on budget night. It was well, you knew about it presumably beforehand, but I understand the announcement on budget night triggers that, yes, it's happened. The money became available on the 1st of July, so take me through the work that was done from the 1st of July to the 16th of August in terms of these advertisements.
So Senator, I'll just reiterate what Ms Harvey said. We have a team that supports a range of judicial processes. I think 6 weeks to prepare advertisements, work through having the advertisements placed, do the necessary documentation to support that is not unreasonable. It takes a lot of time. That team does an enormous amount of work associated with appointments.
What necessary documents do you need to support an advertisement?
Senator, in order to advertise a position, we first brief the Attorney-General to identify whether a new process needs to be undertaken or whether there are available suitable candidates from previous lists and there may not be sufficient candidates remaining on prior lists, and then we also have to undertake a range of normal procurement activities such as seeking permission for money to be put to advertising, drafting advertisements and so on.
The evidence earlier in relation to the line of questioning by Senator Gosh was that it was around a 6-month process. Yeah. So in relation to these particular vacancies, when does that 6-month process begin? Is it when the money was allocated in the budget? Is it the 1st of July? Or is it when the advertisements are placed?
So Senator, obviously we can't put recommendations to the Attorney-General to fill vacancies that are not yet vacancies. They have to be positions, and so once those positions are available, then the process is commenced to identify whether the Attorney-General wishes to run a new advertisement and put together a panel to assess any EOIs that are put forward as part of that process. And I think my evidence was 3 to 6 months. We work as fast as we can.
So in terms of these positions, when do you expect these positions to be filled?
So, Senator, I think there's probably a couple of components to that. So there is obviously the work of the panel in assessing the EOIs and making recommendations.
And who's sitting on that panel? Just remind me.
So that would be the Honourable Chief Justice Deborah Mortimer.
So the Chief Justice of the Federal Court sits on the
Federal Court. The Honourable Justice Nia Perham from the Federal Court of Australia, and Mr Matthew Blunt, the Australian Government Solicitor.
Yep. And so do you expect them to be filled this year?
So, Senator, the other part I was going to go to was, so there's the panel process.
Yep.
Of course, then these are appointments that are made by the Cabinet and go through the Executive Council. And then I understand there's also discussion with the court about when that, and of course the individual, about when the appointment would come into effect. Yes.
And in terms of these 4 appointments, in what jurisdictions have they been advertised for?
So that you go, Jenna.
They were advertised nationally.
But where are the appointments going to go and which jurisdictions?
It's a matter for the Chief Justice. So obviously there are 2 budgeted positions for migration and 2 positions for native title. The exact location of where
will be determined at a later date. Okay, but could you just confirm me, so the Chief Justice sits on this panel?
That's correct.
Okay.
Senator.
Does the Chief Justice sit on every panel? For the Federal Court?
For the Federal Court, I think we've had, from my recollection is we've had 3 panels, and the Chief Justice has sat on those panels.
So the Chief Justice sat on the 3 panels that determined the initial coloured names. Was that correct?
Sorry.
So the Chief Justice did sit on those 3 panels?
Yes, so the Chief Justice, when the former Chief Justice, Alsop, was on a panel, and then Chief Justice Mortimer has been on, I think, 2 panels.
Okay, so that takes you to the 3. In terms of the, I'll use the acronym FCOA, the Division 1, since the last estimates, my understanding is you've now filled the appointments of Justices Boyle, Baran and Anderson. Is that correct?
Senator, sorry, I've got data in front of me, but it doesn't break down from last estimates which positions were filled. But I understand there are no current vacancies in the FCFCOA, so that would appear to be correct, I think.
Okay, and just in terms of the time it took to fill the positions, or to put it another way, the delays in the appointment, can I confirm in relation to Justice Boyle it was 65 days?
Yes, Senator.
Thank you. In relation to Justice Baran, it was 217 days.
Justice Juliet Barons, yes, I have 217 days.
And in relation to Justice Anderson, it was 137 days.
Justice Mark Anderson. Yes.
Justice Mark Anderson, yes, 137. So cumulatively, if I tally that up, it's 419 days in which a judge of Division 1 could have been sitting and hearing cases, but in the total, the respective positions were left vacant. Is that correct, if I total that up? I think I get to 419 days.
Yeah. And apologies. I understand that was the commencement date. So the date from when the vacancy arose.
Could you? Sorry, I can't quite hear you.
Sorry.
No, that's not your
I can't get any closer to the table. To the date of commencement. So yes. So appointment,
yes, correct, exactly.
Appointment
yes,
may have been
correct.
at a different point in time.
One last question, Senator Cash.
Sorry, what was that? Chair, I can't
One
hear
last
you.
question, Senator Cash.
I'm just working through in terms of the 419 days. That's basically an entire year. So you would need an additional judge to sit for more than a year just to make up the lost time in those 3 appointments. And can I just confirm, that's additional information since the last estimates. This is the update, isn't it?
The information we provided in the letter was an update from the last estimates.
Okay. And in terms of Division 1 of the Federal Circuit and Family Court, Division 1 is the family court that deals with obviously complex family matters which are in need of the most urgent resolution. Is that correct?
Senator, Division 1 does deal only with family matters.
Court. Thanks, Senator Cash. I have to rotate the call. Senator Waters.
Thanks very much, Chair. Good afternoon, everyone. Appreciate your presence here. I have some questions about the use of non-disclosure agreements in cases against the Commonwealth involving sexual harassment. Hopefully you've got the right folk in the room.
That's probably more in the Integrity International group, the human rights. team that's been doing respective work. Can you expand a little bit further?
I'm interested in the Commonwealth's policy on the usage of NDAs in sexual harassment matters where the Commonwealth is the respondent.
Yeah, that's the human rights branch that will come up in the Integrity and International group later this afternoon.
Okay.
They're responsible for the Sex Discrimination Act and the work that's been done around respect at work implementation.
I see. Okay, so questions about the positive duty and training and the lack thereof will also belong there.
Correct.
Because that's the most inconvenient time and therefore that's when it is. Okay, thank you very much anyway. That was brief and not terribly helpful, but not your fault. Thank you.
Thanks, Senator Waters. We'll see you later today. Can I just ask I'll ask some questions following up from Senator Cash's questions about judicial appointments. I think my colleague Senator Ghosh asked a little bit about the new process for appointments under the current government. I'm interested in drawing some comparisons with the appointments that occurred under the previous government. You gave us some dates, Ms Harvey, and if it assists you, Ms Harvey, you can pull that microphone closer. I don't think it'll, if that's easier for you. Yeah, thank you. You're not able to give us a sort of average time for judicial appointments. It's sort of on a case-by-case basis.
Sorry, Senator, I couldn't hear.
I'm not sure if one of my other colleagues asked you this question, but are you able to give an average time of appointments? Or do you do it on a case-by-case basis?
For judicial appointments, it's really a case-by-case basis.
Okay. Well, why don't we go through some of those cases? You've obviously this has come up a number of times over previous estimates, so I'm sure that you have those figures going back a few years. Can I ask you, in a similar way to the question Senator Cash put to you, can I ask about some specific examples? Judge Alison Lanhams, I think, was appointed on the 23rd of August 2021. How many days had elapsed from the date that the vacancy arose for Judge Lanhams?
Just a moment, Senator.
That was in 2021, August 2021.
Thank you, Senator. I understand, and this is from a question on notice, that it was Judge Alison Lanhams, that the days there were 353.
353, okay. And Judge Sandra Talagiri was appointed on the 18th of May 2021. How many days had elapsed from the date of vacancy, when the vacancy arose, and the date that Judge Talagiri commenced?
Senator, I understand it was 473.
473. And Judge Gavin Mansfield was appointed on the 13th of December 2021. How many days had elapsed from the date that that vacancy arose and the date that Judge Mansfield started or commenced?
I understand that was 346 days, Senator.
Okay, in the same vein, Judge Natasha Lang was appointed on the 6th of April 2022. How many days had elapsed from the date that the vacancy arose?
Judge Natasha Lang, it was 279 days, Senator.
279. Judge Julie Carney was appointed on the 15th of October 2021. How many days had elapsed from the date the vacancy arose?
So Judge Carney?
Yes.
Is that correct? Sorry, Senator. 287 days.
287. And what about Judge Jonathan Forbes? He was appointed on the 26th of July 2021. How many days had elapsed from the date that that vacancy arose?
Justice Jonathan Forbes, 206 days.
206. I've just got a couple more. Judge Catherine Simmons, same time frame, was appointed on the 26th of July 2021. How many days had elapsed since the vacancy arose?
That was also 206 days, Senator.
206. And Judge Colin Campbell, appointed on the 6th of April 2021. How many days had elapsed from the date that vacancy arose?
So I'm just trying to find... Did you say Colin Campbell?
Colin Campbell.
Uh, 200 days, Senator.
200. And the last one I've got here is in April 2022, so this is just before the previous election. Judge Alison Burt was appointed on the 6th of April 2022. How many days had elapsed from the date that vacancy arose?
Sorry, just working my way through. Oh, Alison Burt. Justice Alison Burt, 173 days, Senator.
Right. I could keep going through a long list of appointments back all the way through to 2013, but in the interest of time, let's just leave it there. I've clearly asked about a range of appointments that occurred when Senator Cash was the Attorney General. I've also done the same exercise that Senator Cash has done, and I've added up those appointments. On my calculations, just those appointments alone, there's around 2,500 days of delay from vacancy to appointment. Does that sound about right from what we've read out?
Senator, I haven't done the maths.
Right, well, I've done some rough maths. That's 2,500 days of, as Senator Cash described, of a day when a judge could have been sitting, 2,500 over the 2021-22 period. That's the calculation that we're making. We're equating those days to days when a judge could have been sitting.
Senator, I don't really have anything to add to that.
That's like 5 years worth of judges. Right. Okay. Now, we know that delay wasn't caused by a merit-based system because there wasn't any under the previous Attorney General's judicial appointments. Can you tell me how many additional judges, that is judges appointed to the newly created positions, has the current Attorney General appointed to the Federal Court and the Federal Circuit and Family Court since June 2022?
Senator, there are three measures. There is the native title. Sorry, was it to the Federal Court or the FCFCOA? All of them?
The Federal Court and the Federal Circuit and Family Court of Australia.
The Federal Court, there was the native title measure, as discussed with Senator Cash, that had 2 additional judges. There was the MyEFO measure to address migration backlogs that had 10 additional FCFCOA judges, and then the budget measure discussed this year had 4 additional FCA judges.
How many is that altogether? These are new positions, not appointments where there's been a vacancy. These are new positions.
That is, my math is 16 new judges.
16 new judges. Right. Okay, thank you. I might just leave that there for the moment. I have a really brief set of questions on the Family Law Act amendments and how they're progressing and how they're being applied, hopefully successfully. Thanks. Thank you. Great.
Good afternoon, Senator. Chris Collett, First Assistant Secretary, Children and Families. Can I just ask, are you referring to the Family Law Amendment Act 2023, the bill last year?
So this is the act that commenced in May 2024, and
There's been so many.
There has been, Senator, thank you.
It's been a prolific era of reform in family law, Mr. Collett. So can you explain, these are the changes that commenced in May 2024, and I'm particularly interested in families able to seek parenting orders through the court.
Fantastic.
Yeah, is that the right? Have I got the right date?
You have indeed, Senator. I might ask
you.
my colleagues, Ms Denley and Ms Mills, to take you through that act. There's also a second act, the Family Law Information Sharing Act 2023, which we can come to if that's also relevant to you, but I'll pass to my colleagues.
Yeah, great. I'm happy to talk about the broad suite of reforms and how they implement the 14 recommendations of the Australian Law Reform Commission report.
Fantastic.
Kathleen Denley, Assistant Secretary of the Family Law Branch. So there's a range of different reforms I can talk you through in the family law space. But
I just asked a question about parenting orders.
Yeah, with the Family Law Amendment Act, which, as you say, those changes came into effect on the 6th of May this year. So, and as you mentioned, it comes out of two reviews, and one of them being the 2019 Australian Law Reform Commission report, Family Law into the Future, and the parenting orders. There are also recommendations related to that in the report of the reports of the Joint Select Committee on Australia's Family Law System, and the legislation responded to a number of those recommendations, including when it came to parenting orders.
Yep.
So,
how many recommendations from previous inquiries were implemented?
Specifically in Tranche 1, I'd have to double check the specific number.
We can work that out as we go.
Yeah.
Yep.
But one of the key changes as relates to parenting orders related to the removal of the presumption of equal shared parental responsibility, which was often misunderstood as relating to equal shared time for parents. And as a majority of separations are negotiated outside of the courts, that was of particular concern, that it was being misinterpreted. And just on that front, it's worthwhile noting the data from the Australian Institute of Family Studies that indicates 97% of parents agree their own parenting arrangements. And of those, 10% use family dispute resolution and 6% use lawyers, then with only 3% actually going before the courts. So parenting orders was of particular focus, and a number of reviews have found that this allowed some parents to be coerced into agreeing to equal time arrangements that were unsafe.
Can you just explain that for us? So, and we have traversed this through the previous estimates and the committee hearings around the bill, but just to be clear, the equal shared parenting responsibility, the repeal of that proposition, obviously it'll be applied by the courts, but one of the things that family violence advocates have said to me is that it was mainly about the message that it sent to families who were trying to negotiate before it got to the courts, and giving them some guidance about what equal shared responsibility or the best interests of the child really meant.
That's right. A lot of these agreements are done in the shadow of the law, so it's the perception of what the law is as opposed to what was specifically in the legislation. And that was something that the Australian Law Reform Commission and other reviews had highlighted was a concern when it came to parenting orders that families were agreeing to, particularly women who were in a vulnerable position, who might not have had the benefit of going to family dispute resolution or a lawyer, to have explained to them that the way the Act should work in practice isn't that it defaults to an equal shared time when it comes to parenting arrangements.
Can I also ask about the changes that were made to the independent children's lawyer, specifically the way that they interact with children they're representing? Can you explain that change that was made and how that's being sort of applied or played out now through the court system?
Yeah, so the Act now has a statutory requirement that in the majority of cases an independent children's lawyer needs to meet with the child and also provide an opportunity for the child to express their views. So it just helps ensure that children are informed about the family law processes and their views are considered when the court makes parenting arrangements. And it also ensures that there's some national consistency in ICL practices. There are a few exceptions. So if the child's under 5 or they don't want to meet with the ICL, or there could be some other exceptional circumstances, for example, if it relates to the child's well-being. But overall, the focus is to ensure that the child has a voice through those conversations with an independent children's lawyer.
Just my last question on these matters. I'm keen to know, given the laws now passed, commenced in May, what education's being undertaken either by the department, the family law court, or other agencies to ensure that the changes are really well understood. As you said, a lot of the impact of the changes is actually on matters before they get to court. So how is that being communicated to families?
Sure, and I might hand to my colleagues, Ms Mills, in a minute to talk about some of the reflections that...
and sorry, not just to families, but to lawyers as well.
Indeed.
Yeah,
so
no offence to lawyers, but they sometimes don't keep up with the times.
There have been a number of things that have been put in place both before and after. So there was extensive awareness raising that we did beforehand with a number of webinars that were run that in total I think had over 11,000 views that my colleague ran for quite a number of organisations. We put out a number of fact sheets as well, both for the legal profession but also for parents, including some fact sheets ensuring that they were translated into various languages as well.
Women's legal centres as well, I imagine.
Sorry?
Yeah, with women's legal services as well, as part of that group.
The webinars.
Yeah.
Did you want to talk a bit about the...
Yeah, thanks, Ms Mills.
Yeah, sure. We ran a series of webinars that included a range of different practitioners. So we did 4 of them that included one that had legal practitioners, and that included women's legal services representatives, a senior legal representative from the family law section of the Law Council. We also had a session that was focused around the dispute resolution context, which included family dispute resolution practitioners from the range of family law services that are funded through the Family Relationship Services Program. And we also had one that particularly focused around the elements of the reforms that aim to better incorporate the First Nations concepts of family and relative and member of the family. And so we had a range of different representatives working in legal practice or family dispute resolution from that First Nations perspective as well. And we ran that series over about a couple of months, and we had significant viewership from the legal profession and from the family law services, as well as some of the academics who work in family law as well.
Sure. And is that work ongoing, especially given there's additional changes that are being made or proposed? That education piece, I just wouldn't want someone to be given the wrong advice or not understand how the law applies to them now that we've gone to the trouble of making these changes to make a positive impact, particularly in circumstances of family violence. Is there an ongoing education process?
There will be ongoing efforts to ensure that, particularly partnering with the Family Law Pathways Network, that we continue to deliver this kind of webinar over the course of this reform. We've also undertaken similar exercises with the recent bill, the Family Law Amendment Bill 2024, which is in the Parliament, to provide an explanation of that to assist different stakeholders in informing their feedback on that bill. We've also undertaken, we've prepared a range of different fact fact sheets are targeted at different audiences, so the public, legal practitioners and family dispute resolution practitioners around the different changes in the bill. I think I would also just note I've recently and in a timely manner come from last week attending the Law Council's Family Law Conference in Perth, where there was highly positive feedback on the impact of a range of measures in the recently passed bill on family law proceedings, and that included in presentations from judges from the Federal Circuit Court, Federal Circuit and Family Court of Australia, Div 1 and Div 2, as well as senior legal practitioners, and they included finding that it's infinitely simpler with the removal of equal shared parental responsibility and the streamlining of best interest factors in the legislation, removing that previously lengthy, really prescriptive pathway with that range of primary and additional factors that needed to be considered to look at a child's best interest. Much simpler now to just focus on the best interests of the child in the particular circumstances of each case, as well as making it easier with the range of mechanisms focused on safety to just emphasise and promote the safety of the children and also anyone with caring responsibility for a child in those matters.
Chair, if I can just add to that, I think it's important to acknowledge we've been incredibly well supported by the family law sector, both the legal sector and the family law services sector, in using the resources that the departments produce, that the courts produced, and promulgating those both through people working in the field and then more broadly out to the community. It's been really impressive to see.
You don't have to defend lawyers in front of me.
It's not usually my practice.
It's okay. I'm sure they're doing a wonderful job and they've welcomed the changes, so that's good news. Thanks very much, and thanks for the work that you do. Appreciate it. It's important.
Can I say something nice?
Of course you can.
Can I also just compliment the members of the department who have been working on this? So, Secretary, I've been really impressed as we've worked through the committee processes with the diligence of members of the department in that respect. So if I can just, I don't know, let me ask you a question. Are you aware of that?
Thank you, Senator. I am aware now, but I appreciate it because we've got a lot of expertise here of people who've been working deeply in this area for a while, and you can see that and the way that they've worked with the sector and with the courts, I think, has been exceptional.
Thanks very much. We are due to go to lunch in a minute, so we might do that now and then come back a little bit earlier. It's only a 2-minute difference. I'm sure that's fine. So the committee will now suspend and we'll return just before 1 o'clock. No, just for 2.
Chair, can I confirm that we're continuing with Justice and Communities
Sorry,
Group?
can I just, I've given the wrong time and I have to give it to broadcasting. 1:30 is when we'll be returning. Sorry, Ms Jones.
And returning to this outcome?
Yes.
Yep.
Sorry. Thank you. Committee will resume its hearing and we'll continue our questioning of officials in the Justice and Communities group. And Senator Cash, you have the call.
Turn to appointments in the Federal Court. And if I could just turn now to Division 2. In the first instance, I just want to talk about the panel. So in terms of the evidence given on the appointment for the Federal Court panel, three panels, Chief Justice, or should I say role of Chief Justice, has been on all of them. How many panels have there been for Division 1 and then Division 2 of the Federal Circuit and Family Court?
Just get the information for you, Senator. 8 in total, Senator.
8?
That includes...
Are they split over Division 1 and Division 2, or are they combined?
In the main, they are combined. I think there was one instance where it was only Division 1.
Okay. And in terms of the 8 panels, how many times has the Chief Justice of the Federal Circuit and Family Court appeared on each panel or participated in the panel?
Yep. 2, 3, 6, Senator.
6. And which panels did he not participate, or she, it is a he not participate in?
Senator, there were 2 panels.
And when were they?
Yep, I'm just sorry, I'm just
no, that's
finding
fine.
them. So there was a migration, a Federal Circuit Family Court Division 2 panel, which was convened earlier this year.
Yes.
And there was a Federal Circuit and Family Court Division 1 panel, which also convened this year.
Was an invitation given to the Chief Justice to participate in those panels?
Not that I'm aware of, Senator.
Okay. Can I ask who then, you've given me who was on the Federal Court panels, who was on those 2 panels?
Yes, Senator. The Federal Circuit and Family Court Division 2 panel.
Yes.
Was the Honourable Ray Finkelstein.
So a member of the court.
KC, former Justice of the Federal Court.
Yep.
The Honourable John Griffiths, former Justice of the Federal Court.
Yep.
And Ms Valerie de Gama Pereira, Chair of the Migration Law Committee.
Okay. So on what basis was the Chief Justice, the person who runs the courts, not invited to be on that particular panel?
Senator, the composition of panels is a matter for the Attorney-General.
So, Minister, on what basis was the Chief Justice of the Federal Circuit and Family Court not invited to be on a panel which chooses judges for his court?
I need to take that one on notice. Senator, if the department has got anything to add, they could do so, but I don't know that myself.
Okay. If you could take that on notice. And in relation to the other panel that the Chief Justice did not appear on?
So the Federal Circuit and Family Court Division 1 panel, which was for Sydney and Parramatta.
Yes.
Ms Louise Glanville, who was then the Chair and Director of National Legal Aid.
Yes.
The Honourable Justice Katrina Banks-Smith,
yep.
a Justice of the Federal Court.
Yep.
And Mr Jamie Burkeet, the Managing Director of a legal firm and New South Wales Solicitor Representative of the Family Law Section of the Law Council of Australia.
Right. But again, the Chief Justice did not appear or was not invited to appear on that court. Was that at the invitation of the Attorney-General as well?
So the Attorney-General determines the composition of each panel.
Right, okay. Minister, can I ask you why or on what basis was the Chief Justice of the Federal Circuit and Family Court not invited to sit on that panel, given again these are judges that sit in his court?
Again, I'll take that on notice, Senator, but I've been reminded that when you were the Attorney-General, there were no merit-based selection panels for judges at all.
And your point's what?
Again, it's a little ironic that you're questioning the composition of selection panels for judges under this government when you didn't even have selection panels and merit-based appointments.
And your point is what?
I think I've made my point.
Well, no, what's your point you're trying to make?
That your questioning all day has been slightly hypocritical.
Right, okay. Well, I don't think that adds any value to the committee. Thank you very much, Senator Watt. Secretary, have there been any Federal Circuit and Family Court panels that have been conducted after those two panels from which the Chief Justice was excluded?
I'll ask Ms Harvey. She's got the detail. I understand he participated in the remainder of the panels.
Yep.
But I'll let Ms Harvey answer that.
Thank you, Ms Harvey.
Senator, for the Federal Circuit and Family Court Divisions 1 and 2, there was a process advertised on the 13th of September.
Recently, just this 13th of September?
Just recently.
Yep.
There are two panels that have been assembled to look at the expressions of interest received. One focused on family law and one focused on general federal law. And the Chief Justice, Willie Molstagren AO, is chairing both of those panels.
He's chairing both of those, and that is at the invitation of the attorney.
Yes,
Thank
Senator.
you. It was described in the evidence, the panel, as being for Sydney and Parramatta, the previous panel we referred to. Is that correct?
It was, that panel was for Division 1 in that jurisdiction.
Okay. Just in terms of the letter that we were provided, it says the federal courts operate on a national basis. As such, applicants for possible judicial appointment do not apply for appointments to particular registries, but to the relevant federal court.
Yep.
How do I marry those two statements together?
Senator, I might see if one of my colleagues can assist here, but they are, of course, applications to be on the particular court, and this was a targeted one for Division 1.
No, I understand that, but I'm trying to work out if they're applying for application to the court as opposed to the registry, why is a panel described as being for Sydney and Parramatta?
Senator, I might be able to assist. So the panel was convened to consider roles in Sydney and Parramatta arising out of an advertisement for a more broad group. So the advertisement itself was then focused on general positions, and panels were created to assess particular needs, in this case for Sydney and Parramatta vacancies.
Thank you. Can I also go back now to Division 2? And at the previous estimates, when I say since we last looked at this issue, in my perspective from the previous estimates, my understanding is you've now filled 15 different vacancies for positions which had either been announced or which had become vacant by way of resignation or retirement. Is that correct?
I'll just see if we have the number.
Yep.
Senator.
It would surprise me if you don't, given you had a lot of information about the previous government and appointments. So if we didn't have information about this government and recent appointments, that would surprise me.
Senator, I just say I think the information of the previous ones was because it was a question on notice that we answered.
And it was found very quickly, yes?
Senator, we have a slightly different number, so we'll just quickly...
What do you have?
Our counting is not great. We're just doing it at the
No,
table.
that's all right.
We seem to have gone to 17, so we just need to double
well,
check.
yeah, if you could, because when I counted, maybe we've missed two. Just in terms of the Sydney Parramatta panel, were any candidates for the Sydney or Parramatta panel, were they appointed to different registries?
Out of that panel report?
Not that I'm aware of, Senator. I think that anyone that had either indicated that they were located in New South Wales or Sydney Parramatta area, or on occasion we ask applicants if they would be willing to relocate for an appointment. They would also be people that may have formed part of that group. We'd need to take more detail on notice.
Would you mind? Because I'm assuming you're saying it's the best person for the job, so they don't need to come from Sydney or Parramatta to be appointed. If they're prepared to relocate,
yes,
you could come from
right.
Queensland, Western Australia, Tasmania. So, did you get to 15 or 17?
We got to 17.
Okay, that is all right. We will go through them then. And you might be able to add to my list. Judge Scaros, if I could just look, there was 217 days that the position was vacant for.
So Judge Scaros was appointed on the 1st of August and commenced on the 5th of August. And my colleague's just coming up with
217 days we have.
Piece.
Thank you very much. Judge Jacobs, 65 days, is that correct?
We have that.
Judge Papadopoulos, 217 days, is that correct?
That's what we have.
Judge McCabe, 217 days.
Yes, we have that.
Judge Cower-Baines, 217 days.
Corbanes, yes, we have that.
Judge Gostanich, 217 days.
Yes.
Judge Gerard, 217 days.
Yes, Senator.
Judge Cuthbertson, 217 days.
Yes.
Judge Coulthard, 217 days.
Yes.
Judge Corbett, 217 days.
Yes.
Judge Zipser, 259 days.
Yes.
Judge Shoebridge, 46 days.
Yep.
Judge Colquhoun, 280 days.
Yes.
Judge Doust, 59 days.
Yes.
Judge Leishman, 76 days. Now, do you have someone else?
No.
1, 2, 3, 4,
We might
5,
just be
6,
doing
7,
bad
8,
maths,
9,
Senator.
10, 11, 12, 13, 14. I still get to 15.
We'll need to go away and confirm.
Would you? No, that would be great. And can you confirm more for me, in between the period that these judges became, or these positions became vacant and the appointment, was Australia subject to a global pandemic? Well, the answer to the question is no.
Sorry, Senator. Sorry. Between all
No,
of these...
we haven't answered the question. But,
Yes.
Sorry, can you...
Was Australia subject to a global pandemic in between the time that these appointments became vacant and the time the appointments were made?
I'm not sure. I'm not sure how we define the exact time frame of the pandemic.
Is this a joke?
We can take that on notice.
Is this actually a joke? Was that a joke answer?
No, just in terms of when we were officially in what was described as the pandemic was over a broad range, so I don't know exactly the time frame.
So your evidence is you are not sure whether or not... So just let's go back to each one and work out what date the appointments
appoint judges because of COVID?
became vacant. Let's just go and work out what appointment each of these judges became vacant. When did Judge Jacobs or the appointment for Judge Jacobs become vacant?
Oh, God.
4th of May 2024.
Sorry, what was it? I can't hear you.
Sorry, the 4th of May 2024.
4th of May 2024. 2024. Judge Scaros?
Those are new positions.
So they're new positions. So when did they become vacant? Take me through the 4 new positions.
So funding for that position became available on the 1st of January 2024.
So how many became available on the 1st of January 2024? The 1st of January.
10, Senator.
10. Are they reflected here?
Yes, they are.
Okay, 1st of January 2024 plus the 4th of May 2024. And I'm assuming that 3 in here will be the 1st of July 2024.
No, Senator.
So the remaining dates are the first vacancy became, the position became vacant on the 1st of August 2024. That's for Shoebridge.
Yep.
Colquhoun, 11th of December 2023. Doust, 16th of August 2024. And
2024.
Leishman, 30th of July 2024.
Okay, so if I now go through Division 2 and if I add up the total elapsed time between when a vacancy became available and when it was filled under the tenure of the current Attorney-General, you are looking at, in my calculation, 4,693 days of lost time, and this is solely in Division 2 of the Federal Circuit and Family Court of Australia. And the observation I will make is with no global pandemic to contend with. Is that correct?
Sorry, Senator, which part of your question?
If you add up all of those lost time hours, it's 4,693 days in lost time. Is that correct?
Senator, I haven't added up the days, and those are the days that are between when the vacancy commences and when the person commences in their role, which of course might be a different date from the date that they're appointed.
Well, what you get to is more than 12 and a half years of lost time where people could have actually been getting access to justice. Minister, do you think that is acceptable?
No. Well, I think what we've seen is that there was a very similar issue while you were the Attorney-General.
Again,
and
Minister,
I'm wondering why
your government kept telling the Australian people it was going to do things better. So is that acceptable under your government?
Why are you so intent on using estimates to score own goals? That's
I'm not excusing scoring own goals. I'm asking you about a delay under this Attorney-General of 4,693 days, and that is only in Division 2.
Well, of course, we'd all prefer judges to be appointed as quickly as possible, but we've already seen that exactly the same thing happened when you were the Attorney-General. You're putting up some crazy excuse that it was COVID, as if COVID shut down your computer system, that it meant you couldn't sign documents. It's just, like, clearly it takes time to appoint judges.
It does take time, but
just as it did under you.
Is 12 and a half years of lost time acceptable to you?
We've gone through the same figures for you.
I'm asking, is 12 and a half years acceptable?
As I've said, we would all like to see judges appointed as quickly as possible, but I suspect that for similar reasons as it took you some time to appoint judges, from time to time it takes time to appoint judges under this government as well.
Exactly.
Thank you for accepting my point that the same issue would apply under you.
Senator Cash, I do need to rotate the call.
Oh, okay.
Thank you.
Bizarre.
Senator Shoebridge, you have the call.
Thanks, Chair. Last estimates, I asked some questions about NLAP. We just had the Monday review handed down a few days before, and a series of questions I put on notice asking for some detailed breakdown of where the government's funding allocations would be delivered. And Secretary, none of the questions were answered in substance. There was no detail of where the Commonwealth's funding would go, no detail of which services would get funded, no detail of how much would go to legal aid commissions or Aboriginal and Torres Strait Islander legal services. No detail at all was given. I can't tell you how frustrating that has been for the sector to not know where the money's going, but it's also not responding to perfectly reasonable requests in estimates about where some, I think, $500 million of additional money to frontline sectors over 5 years is intended to go. Are you in a position to tell the sector where this additional $500 million will go over the next 5 years?
Senator, I'll ask Ms Harvey, and in terms of she'll explain in terms of the timing of the answers for the questions on notice, as well as what we can provide now.
Senator, the National Access to Justice Partnership is still being negotiated with the states and the territories. And so part of that negotiation is, of course, around the funding. And so we are continuing to work with the states and territories to finalise the agreement. We're very conscious of the desire of the sector to know when the funding that will be provided. And so the heads of agreement that were agreed by the National Cabinet on the 6th of September commit to the final details to be settled and signed by Attorneys General by the end of November 2024, and also the states agree to provide funding certainty to providers within their jurisdiction in terms of the 25-26 financial year. So that breakdown is still being finalised.
So have the states and the Commonwealth agreed to a hard deadline at the end of November?
So the heads
the
heads of agreement that were agreed as part of the National Cabinet indicate that Attorneys General will settle by the end of November.
One of the questions that I asked was, will there be a full government response issued to the 39 recommendations of the independent review of the National Legal Assistance Partnership, and if so, when will that be? I'll read you the answer. The purpose of Dr Warren Mundy's independent review of the National Legal Assistance Partnership is to inform the negotiations and development of legal assistance funding arrangements under the new National Access to Justice Partnership following the expiry of the current National Legal Assistance Partnership on 30 June 2025. I've read that twice this morning before I came in here. I'm still yet to see how it answers my question. So I'm going to ask the question again. Will there be a full government response issued to the 39 recommendations in the independent review of the National Legal Assistance Partnership, and if so, when will that be?
Senator, I think, sorry, I'm just looking at these parliamentary questions on notice. The answer that was provided is correct in that
it might be correct, but it's answering a different question.
Well, Dr Mundy's review was undertaken as part of the National Legal Assistance Partnership. It was incorporated in the partnership itself that there would be this review that would then inform the next one. It wasn't undertaken as a review that would then be responded to in a formal, recommendation by recommendation way by governments.
So if I'm to read this in light of what you've just said, the answer is no. There won't be a response to the 39 recommendations set out in the Mundy review. If I'm reading between the lines, the answer is no. Is that correct?
That's correct.
Yes, Senator.
Why didn't you say that? If the answer is no, why do we instead get some oblique non-answer as the answer? I know it might be awkward to say that the government won't respond to Dr Mundy's 39 recommendations, but it's not an appropriate response to deflect and not answer it.
Senator, I think the response goes to explaining the use of the report by Dr Mundy.
My question was, will the government be responding to the 39 recommendations? And no matter how many times you read it, the answer there is no answer to that. You get an oblique reference that Dr Mundy's report is going to be used to inform negotiations. Dr Mundy made 39 carefully calibrated recommendations after hearing from the sector, and the sector, which is in an incredibly resource-scarce environment, delivered substantial parts of their resources to inform Dr Mundy and to get those recommendations. And then we find out now, a year and a bit after more than that, 18 months after the review commenced, that the government won't even have the decency of responding to Dr Mundy's recommendations. That is a slap in the face to the sector, and it makes you question what was the purpose of an independent review that the government isn't responding to.
Senator, reviews like this are regularly done. They don't necessarily result in a formal government response, but they are used to inform the policy and policy work of engaging with the states and the territories and in terms of the development of the new agreement.
But the terms of reference for Dr Mundy's review were not just about the new agreement. It was to do a review of the funding adequacy and the needs for the sector. It wasn't, the terms of reference weren't narrowed down to the agreement. It appears that what the government has now decided to do is that many of those recommendations are awkward and expensive, and rather than address the recommendations, you'll just say, well, we're only using it for this very narrow purpose, only for the purpose of the next funding round.
Senator, the context of the review by Dr Mundy was the National Legal Assistance Partnership. I can't remember the provision, but it is provided for in the NLAP itself, similar to the reviews that were done following the National Partnership Agreement. It was to inform what happens next. Yes, it was a broad review. My colleague Ms Bogart might be able to talk a little bit more about how we have, the review has informed what is going into the NAJP, but it did come out, the context of it was coming out of the NLAP.
Yeah, we could spend the next 10 minutes reading on the extremely lengthy terms of reference for the Mundine review. It was in the context of NLAP, but by no means was it limited to NLAP. It was looking at, to quote it, a holistic assessment of legal need and all Commonwealth legal assistance funding, including, and then there's a list, the effectiveness and challenges of delivering core legal assistance services and what funding is needed to address that. Cultural appropriateness of legal assistance services, issues about gender services, the adequacy of services to actually implement the National Plan to End Violence Against Women and Children. That's what the 39 recommendations are directed to, and the government is choosing to ignore them. I
don't think that's accurate, Senator Shoebridge. As you're probably aware, the review was commissioned either because of or in line with the existing provisions of the NLAP, and the NLAP itself has noted that future arrangements will take into account the recommendations of the review. In addition, the government has already provided an $800 million increase on current funding levels for the legal assistance sector, which means it's the biggest Commonwealth investment in legal assistance ever. It's going to go a long way towards addressing some of the issues you raised around the pay rates and pay parity for the Community Legal Centre, for women's legal services, for Aboriginal and Torres Strait Islander legal services, and the recommendations of the review will be considered as future arrangements are prepared. But you can't just airbrush the fact there's been a massive new investment in community legal centres under this government.
Well, how much has been invested? What's the additional funding for community legal centres? So you say I can't ignore that.
So there's the new agreement is $3.9 billion, including an $800 million increase on current funding levels for the legal assistance sector, plus a commitment to ongoing funding.
Minister, you said I can't ignore how much has been delivered, additional funding for community legal centres. So now I'm going to ask the department to tell me how much of additional funding is going to community legal centres, the figure that I can't ignore. How much?
So, Senator, as I mentioned at the start, so we are still negotiating the National Access to Justice Partnership. The roughly $800 million that Minister Watt referred to has a couple of different components. Some of that goes towards pay parity, some of that goes towards better indexation. The pay parity, for example, is targeted towards a number of parts of the sector, so community legal centres being one of them, to be able to have go towards pay parity as against legal aid commissions. But the precise breakdown of those figures is still being finalised through these negotiations.
Well, how much is going to pay parity?
So
you can't say.
Pardon?
You can't say?
So at the moment, we are still going through the final negotiations and what all those figures will look like.
So the answer that I did get was that there's a $3.9 billion commitment to the Commonwealth. The bulk of that is rolling over existing commitments. There is an $800 million of additional funding, of which $500 million is actually going to frontline services. So what is the discrepancy between the $500 million going to frontline services over 5 years? So it's $100 million a year over 5 years. What is the other $300 million going towards?
So, Senator, the $3.9 billion is made up of, so under the National Legal Assistance Partnership at the moment, which is around about $2.4 billion, there is baseline funding, and then there's a number of streams of funding, all of which are scheduled to come to an end on the 30th of June next year. And so those, as well as the baseline funding, all of those will be continued into the next agreement, and and then that next agreement also provides for ongoing funding, so beyond the 5 years. So all of that will become effectively new baseline.
The sector would have gone into open revolt had you pulled any of the existing funding away. So you're retaining the existing funding and making sure that existing funding continues over. But that's not what I'm asking you about. I'm asking you about the $800 million. You say there's $800 million of additional funding over the next, I assume it's over the next 5 years. You say $500 million of that is going to funding frontline services. What's the other $300 million?
So just to come to that, Senator, so then there is effectively those two amounts that you referenced. So the 500, which is focused on frontline, and then but the $300 million is where the pay parity and the better indexation amounts sit. So, of course, in reality, they go to frontline service delivery as well, because it is supporting staff in legal assistance services. So the reason it's different is because that the indexation is this is where it starts getting a little bit complicated, but it is effectively additional indexation on top of that $3.1 billion.
This is because the NLAP indexation was radically below inflation over the last 3 years.
So it was set in 2020 and didn't increase.
Yes, it was set in 2020 with the assumptions that inflation would go in one direction, and then we had a variety of global shocks and inflation shot well above where the indexation was. And the end result was, for the last 3 years, the indexation under NLAP has been radically less than inflation and seen a substantial reduction in the real funding that frontline services have had over the last 3 years. That we agree on that, don't we?
So, Senator, I agree that the indexation has been static over that time.
The indexation has been well below inflation.
Call in a second, Senator.
The indexation has been well below inflation, and the real value of the funds going to the sector from the Commonwealth has fallen dramatically as a result of that gap between indexation and inflation. Do you have an assessment of what that gap is? The reduction in real funding was?
I don't, Attorney.
And so in part the indexation...
Senator Sheepridge, I will have to share the call. We will come back to you.
Can I just finish this one?
Of course.
The indexation is to try and plug a small part of that gap that happened over the last 3 years. And the pay parity is so that Aboriginal legal services and community legal services stop losing every one of their solicitors because they're paying them so less even than legal aid. That's what those two things are about. They're just stemming the flow, aren't they?
Well, I wouldn't characterise it just as stemming the flow, but in terms of your description around pay parity, it certainly is intended to ensure that Aboriginal legal services and community legal centres can provide salaries that would prevent people from leaving them and moving into legal aid commissions.
And if I could
Thanks, Senator. Sorry.
Last answer, Senator. Just in terms of indexation, there was, of course, a budget measure this year for $44 million for this current financial year as well.
And
So
on,
I just
yes, and on notice you'll tell me which services got that.
the 44 million.
Yep.
Yes, I think we probably.
You could do it on notice because the chair wants to move on.
Thank you. That's Senator Thorpe. You're on video conference, I understand, and have questions.
I do. Thank you, Chair. Can you hear me?
Yes. Well, you'll have close to 15 minutes. I'll cut you off with a few minutes to go.
Thank you. And sorry, I just tried to turn my camera on, but it's not working. So my apologies.
That's fine. We can hear you.
Great. I'm just asking about the Justice Policy Partnership that was established under Closing the Gap, and want to know what the prioritisation, sorry, I'm babysitting as my grandson at the same time, what the prioritisation of community control was in that program or in that policy decision.
Senator, in terms of the, sorry, it's Tamsin Harvey here. Sorry, Senator, I'm not sure if you can see me or not. The Justice Policy Partnership came together as part of, as providers for, under the Closing the Gap National Agreement, and brings together 5 Aboriginally community-controlled organisations, a member from each state, territory and Commonwealth government, and 5 independent Aboriginal and Torres Strait Islander people, generally in the justice system as well. I'm sorry, I'm not sure if that answers your question.
I'm aware of who's involved. My question is so my understanding that this program, the Justice Reinvestment program particularly, is supposed to prioritise the community-controlled sector and strengthening. So in relation to that, can I just confirm that that was the priority, that it would strengthen community-controlled sector?
Senator, I might ask one of my colleagues to step in. Ms Bogart might step in and talk about the design of the program in a bit more detail.
Thank you. It's really more about the community-controlled component rather than a narrative on the whole program.
Yep, understood, Senator.
Thank you.
Thank you, Senator. Esther Bogart, First Assistant Secretary of the First Nations and Justice Policy Division. I'm also online. Senator, the guidelines for the Justice Reinvestment Program were co-designed with Aboriginal and Torres Strait Islander people and members of the Justice Policy Partnership. And one of the key sort of points of that of those guidelines is that we do prioritise Aboriginal and Torres Strait Islander community-controlled organisations when we are assessing applications. And if an organisation is not an Aboriginal or Torres Strait Islander organisation, they must demonstrate a plan to transition to an Aboriginal and Torres Strait Islander community-controlled organisation within the period of the grant. So it is an absolute priority for that program.
Yeah, thank you. I know that there's a number of white organisations that are being paid out of this so-called community-controlled, but I'll leave that question for later. Thank you very much. Can I ask then why your department publicly opposed this mandate and its decision to establish the Justice Reinvestment Unit within the Attorney General's department, rather than being in partnership with an Aboriginal community-controlled organisation as recommended by the Justice Policy Partnership? So the department were told, righto, this is best in community-controlled hands, self-determination, let blackfellas decide for themselves. And the department said, no. we want to control this. Can you tell me why that happened?
So, Senator, the Justice Reinvestment Unit was part of the government's election commitment around justice reinvestment. So there was the program, which I just mentioned, and then the unit was $12.5 million intended to support the initiatives that were funded under the program. We did, as you say, we spent almost 12 months co-designing and working with a Justice Policy Partnership, Justice Reinvestment working group about the design of that unit. The Justice Policy Partnership did make a recommendation that the partnership or the unit would be stood up as a hybrid partnership between government and an Aboriginal community controlled organisation, although an organisation was not identified as part of that recommendation. A decision was made, given that there are now 26 initiatives funded under the Justice Reinvestment Program, that an interim unit, so only an interim unit for 12 to 18 months, would be stood up within the department that would allow those communities to be supported immediately, with a plan to transition and co-design the final unit, which is likely to be independent of government, but it is being designed in partnership with the Justice Policy Partnership, but also with those communities that are funded through the initiatives, the 26 initiatives, and we thought it was really important that those communities had an opportunity to be part of the final design of the unit. So, as you say, it has been stood up in government for an interim period so that that community engagement can occur immediately, but there will be a final design which is still being developed in partnership.
Yeah, it's a pity because our organisations are over 50 years old, and this transition excuse is just another reason to take self-determination straight out of our hands and have a unit set up that takes away that. So, can you confirm that the long-term unit will not be in the AG department and it will be community control? Can you absolutely say that?
Senator, the recommendation is that it does go to a community-controlled organisation. But as I said, the final design is being designed in partnership with the initiatives, the communities that are in the initiatives. But it is intended that the final unit will be independent.
So when will that be? Because it's been 200 years already. When will this be?
The interim unit is intended to be in place for 12 to 18 months and no longer than that.
So it may not happen, given we've got an election looming. Okay, thank you. My next question relates to the Justice Reinvestment funding in Cowra. This is where you've funded a wide organisation over a very, very renowned, self-determined Aboriginal organisation that are very well connected in the community. Someone in your office decided that we'll give it to a wide organisation. So I want to ask some questions around that. And can you tell me why was authority granted to a wide organisation, the Cowra Information Neighbourhood Centre, who are also profiling our children, to independently appoint First Nations representatives when there was already a First Nations representative group known as Wallamara Alliance? That community had elected and respected themselves. Why did the government come in and overlook this self-determined organisation?
Thank you, Senator. I might just start and then I'll hand over to my colleague, Ms Woods. So I just wanted to be clear that the decisions about which initiatives are funded are made by a panel under the Grant Opportunity Guidelines, which is made up of government representatives, but also community representatives, state and territory representatives, and Coalition of the Peaks.
Can we have names on notice, please, and when that meeting took place to make that terrible decision?
On notice, we can probably provide you then the composition of the panel. But what I will tell you, Senator, is that under the grant opportunity guidelines, there's a mixture of different people and organisations, and there is a requirement that at least 50% of that panel be made up of Aboriginal and Torres Strait Islander people. So it was not solely a government decision about who was funded, and I'll just reiterate.
That doesn't answer my question. In all due respect, why? I don't care who. I don't care how many blackfellas. Sorry, I'm speaking. I don't care how many blackfellas you got on your committees. I want to know why this community was overlooked for a white organisation who are profiling our kids. That's what I want to know. I don't care about your friends on your committees, because sometimes those people don't do what's right for us either. I want to know why this community, self-determined, with elders who are looking after our kids, why you've overlooked this organisation and given it straight to a white organisation who has no connection and is actually doing more harm than good. Tell me that.
Senator, I'll ask Ms Woods to provide some information about the application that was received, noting that we can only fund those organisations that do apply for funding, but I will hand over to Ms Woods.
Thank you. Thanks, Senator. For the Cowra initiative, they actually applied under round 1, cycle 1 of the National Justice Reinvestment Program, and per the grant opportunity guidelines requirements, they provided letters of support from local elders and community stakeholders to support their application, as well as a plan to transition to an ACO. To actually be recommended as an initiative, you have to satisfy all GOG's requirements, and the panel itself is the one that makes recommendations to the Attorney General. It's not a decision of the Attorney General in the panel assessment. It is the panel, which is an independent panel, including government reps, as well as the range of other representatives that Ms Bogart spoke about, that make recommendations on the basis of having satisfied all requirements of the grant opportunity guidelines, which Cowra did. We're working with Cowra to develop an activity work plan, which is another requirement of the grant opportunity guidelines and the executed funding agreement, to detail how they're delivering their initiative in consultation with community in accordance with the program objectives.
I'm hearing exactly how they're delivering, and it's really not a good situation. So can I ask, why was your department made aware of this white organisation, Neighbourhood Centre, their decision to revoke the Wallamara Alliance role via an email? They sent an email to this Aboriginal organisation who are working on the ground to say that they are revoking their role without any notice of consultation with the community. So how does your department justify that decision when this community organisation, white community organisation, are using extreme tactics, in my view, to dismiss a grassroots, self-determined Aboriginal alliance role? Why are they not working with them? Why are they creating such division in that community? Are you aware of any of this?
Senator, it's Catherine Jones, the Secretary of the Department. I think what I would propose is that we take on notice those issues that you've raised, and look at what information that we have and how we could respond to you in relation to those matters that you've raised.
I'd appreciate that.
Senator Thorpe, I'm just going to give you a little wind up. You've got about 2 minutes left.
Thank you. I'd appreciate that, because I've had a number of community members from that community who this white organisation have accused respected community members, Wallamara Alliance members, of disruptive and bullying behaviour without no substantiated evidence, and issued them with a cease and desist letter to silence the community's right to share truthful information with their community. So I'd appreciate that the department looks into this very serious issue, particularly where I've heard that this community organisation, that the neighbourhood organisation, is actively working with the police to profile and identify Aboriginal children. Now, that is not on, and that absolutely needs to be investigated. And I'd really urge the department to speak with the Woolamara Alliance elders and community members if you want to do your due diligence. Now, Chair, I know I'm running out. So
you have run out of time. That was a long preamble, sorry. So I will have to rotate the call. Thank you.
Okay, thank you.
Now, Senator Cash, we're going to come back to you, or Senator...
Senator... Yeah.
All right, sorry. We'll head to you now.
Thank you.
Yep.
Look, I'd like to return to NLAP and specifically to try and understand the funding arrangements that were made. I'm happy to table if people like, but I'm going to refer to a media release that was put out by the government in relation to that funding, and you're happy to read that directly. But in essence, it says that the Albanese government will commit $4.4 billion in new funding to address the scourge of gender-based violence and respond to the rapid review into prevention approaches, including investing in frontline services and initiatives to prevent violence. So what I'd like to ask you is how that funding is actually broken down, because from the sector's perspective, there has actually been no new funding. This was an agreement they were expecting, and that it actually doesn't really leave them much better off than they have been. So what I'd like to understand from this is the reference to the media release talks about the reason for NLAP and the negotiations was to address a funding cliff. Did that agreement come to an end in 2025?
Yes, Senator.
But the government came into government in 2022, yes?
So the agreement was a five-year agreement negotiated with the states and the territories, which concludes on the 30th of June 2025.
Right, but the government came in 2022 and the agreement expired in 2025. So I wouldn't characterise that as a funding cliff. Is that normal for your negotiations to take 2 years? I mean, it's hardly a funding cliff.
Senator, the funding under the agreement was all scheduled to end on 30 June 20... It does end. The NLAP finishes on 30 June next year. And so the replacement, the National Access to Justice Partnership, is underway now, so that there is clarity around the funding that will be available for ongoing legal services, noting those organisations have a range of obligations and expenses.
Okay, I would hardly characterise that as a funding cliff, given 2022 in May, and we're now in November 2025. Can you confirm for me, the family violence prevention legal services, are they now captured under this NLAP?
Senator, no, they are not under the NLAP.
So they still sit separately to NLAP?
They're still funded under, I think it must be under the Indigenous Advancement Strategy.
Right.
So they will come into the National Access to Justice Partnership. That is the intention from 1 July next year.
Okay. So I just wanted to understand, this current agreement expired in 2025. If you work on the basis of a 5-year agreement, we're talking about 91 million a year to fund those legal services that are captured under the NLAP, going back the last 5 years?
It's a little bit complicated, because I think when the agreement was signed in 2020, it was worth about $2 billion. It's now worth about 2.4. So, sorry, maths on the run isn't my strong suit.
So the 68 million that's part of the family violence prevention legal services, is that separate to that. So we're only talking about 91 million. So we're not talking about 159 million for services to respond to family violence and community legal services.
Sorry, Senator, I'm not sure which amounts you're referencing. Sorry,
yeah, we're all a bit
Sorry.
confused about all of these figures and how they came about. The sector has been telling me for some time that they are actually worse off under these funding arrangements. Is that the case?
Well, the new arrangements haven't commenced yet. They are subject to being the agreement being finalised,
but we've had an announcement. You're talking about for the 4.4 billion. We've had an announcement of a number.
Yes, and the 4.4 billion was for the broad package that was discussed at the National Cabinet meeting to address gender-based violence. 3.9 of that relates to legal assistance funding. The remainder of that goes to a range of initiatives responding both to the rapid review and some other initiatives, including initiatives that our department is responsible for developing that go to addressing family violence perpetrator behaviours.
So in terms of that announcement about 4.4 billion, does that include the money that you're hoping that the states will contribute, or is that just Commonwealth funding?
That's just Commonwealth funding.
Yeah.
Right. Okay. In terms of the CPI and the relevant modern awards, the sector's saying that the increases mean they will actually have less money because under the relevant modern award, the amount payable to people who work within their sector has actually increased. How have you taken that into account? You've talked about indexation and you've talked about pay parity, but what about in relation to the relevant modern award? Because they're really concerned that when that kicks in, that they are going to be much worse off than they currently are.
I'll ask my colleague to assist on that.
Senator, yes, you're right. And the indexation usually takes into account the changes in wages and the price, consumer price. So I can't comment on because that's will not be my expertise, because it is a responsibility of the Department of Finance in terms of a different way methodologies to construct indexations. But what I can say is that indexations is certainly a methodology to take into account the changes in the increase in wages.
Are you able to provide me with a breakdown of the funding between the legal aid centres, the Aboriginal and Torres Strait Islander legal aid services, family and domestic violence legal services and the community legal services under this 4.4 billion?
So, Senator, the 4.4 billion includes the 3.9 billion that will be the National Access to Justice Partnership, which will commence on 1 July next year, and that agreement is still being negotiated with the states and territories, so I can't provide that at this stage.
Right. So those services that are desperate, and now I think the reference in this media release is even recognising that there's unacceptable and unrelenting rates of domestic and family violence, it won't kick into July. So they won't have any certainty, operational certainty, at least until they're advised of this. The money from the rapid review, we're told yesterday, the majority of it won't even kick in until the 1 of July. So how does this go any way in responding to an unacceptable and unrelenting rate of domestic and family violence? Have you given these services additional money at all in the interim?
So, Senator, this $3.9 billion is for the next agreement, so it does start on 1 July. There was some additional funding in this year's budget, around $44 million for the legal assistance sector.
But that's for indexation and pay parity and also for Aboriginal legal services. That's not for all of the community legal services.
think it went...
Yeah, it went for all the legal, community legal services, and including community legal centres and FEPOS and Aboriginal Torres Strait Islander legal services. It went to all those three community legal sectors.
So how did you share that out?
We can give you that breakdown, the formula on notice.
Yeah. Okay. So did you actually fund NARJA under the additional funding that you gave for domestic and family violence, under that additional funding you just talked about?
So under the $44 million, I think we'll probably have...
So sorry, Senator, your question is, have we funded NARJA for family domestic violence?
Under that additional funding. So while they've had significant governance issues, I'm asking whether you continue to fund that organisation.
So we have continued to provide funding under the National Legal Assistance Partnership to the Northern Territory, which then is responsible for funding legal assistance organisations, including NARJA.
So I put to you, the sector has said that that they are going to be worse off. You're saying you're not really sure until you get to finalise these agreements. The Monday report, which spent some time doing work to inform this agreement, that said that 41 million extra was actually needed. That's not in this funding agreement, is it, in terms of the 4.4 billion? You can't see an additional anywhere near 41 million. In fact, the sector has told me, several in the sector, that there's probably an additional 1 million to be divided between all of those organisations.
Senator, the overall amount, in addition to the base funding, the additional funding is $800 million.
That's additional over 5 years.
Yes, and we're still negotiating with the states and the territories about the specific allocation of that. So that general question you asked us, we're not in a position to answer now, although we will be in several months' time, be able to provide the detail of that.
So rather than here's the government's media release saying that they've been left with a funding cliff, which is just nonsense when you look at 2.5 years of government, but you're leaving the family violence sector with a cliff because you haven't finalised the agreements, and they're pushing towards a 1 July, which isn't too far away for them. It's not an ideal situation, is it?
Well, it's pretty, to be honest with you, in terms of finalising a new agreement at the end of an old agreement, it's quite early compared to what would normally happen.
Okay. Still a cliff. Thank you.
Thanks, Senator Liddell. Senator Cash, other senators have agreed to put their questions on notice for this group. So if you've got
issues that I would like to explore
on justice and communities.
Yes.
Okay.
The first is in relation to the terms of reference for the review of the Federal Circuit and Family Court.
This one had to come to the table.
Can I just confirm that there's a review of the merged courts going on right now?
Yes, Senator.
Thank you. And that review was always planned, I understand, but the government has brought it forward. Is that correct?
Senator, the statutory review of the Federal Circuit and Family Court of Australia Act 2021 has commenced.
And when did it commence?
Yes, it commenced on the 2nd of September.
2nd of September. Was that brought forward by the government?
So, Senator, it was provided for in that, I think it was actually in that Act when it was enacted. The date that it commenced, I'll get my words out.
That's all right.
Did change and has came forward by, I think, 2 years.
Oh, sorry, okay, right. So when was it meant to commence?
So it was originally required to be conducted within 6 months after the 5th anniversary of the commencement of the FCFCOA Act.
So by how much has it been brought forward by?
It's been brought forward by 2 years.
So you said 2 years?
Yes, Senator.
Okay. On what basis was it brought forward?
I think it was brought forward in the Family Law Amendment Act of 2023, and the explanatory memorandum sets out that it will be for a timelier assessment of the effectiveness and impact of the FCFCOA Act on the operation of the court and its users.
Just remind me when the merger actually commenced.
The Act commenced on the 1st of September 2021.
2021, okay. And it was meant to be 5 years afterwards, and it's now effectively
3.
3 years, okay. Just in terms of the terms of reference for the review, Secretary, when did the drafting of the terms of reference for the review commence?
I'd need to ask colleagues to give a precise date. We may need to take that on notice in terms of the drafting, but I think obviously once the legislation had been amended to bring forward the review, but I'll just check unless anyone's got a precise date.
Or is there any ballpark to the nearest month in a particular year?
I think we would have to take a notice. Certainly, terms of reference, the drafting commenced before the review commenced, so in the months preceding that.
Yeah, sometime earlier this year, I suspect, Senator, but we will take that on notice.
Okay. So next question then is, when were the terms of reference for the review settled?
Don't know if we've got the final date.
Again, we would have to take that on notice, Senator. They were settled prior to the commencement of the review.
Which commenced on the 2nd of September.
That's right, the exact date.
And who drafted them?
Senator, we provided an initial draft.
Provided an initial draft?
We provided an initial draft to the Attorney General's office.
Yep. And was that amended?
I think it's fair to say the draft went through some iterations before they were finalised.
Are you able to table for the Senate committee the original draft and then all the iterations of the terms of review?
I'll need to take that on notice, Senator.
Who are the reviewers?
There are 2 reviewers. There is the Honourable Linda Dessau, AC CVO, and Professor Helen Rhodes, OAM.
Professor Helen Rhodes. And how were the reviewers chosen?
They were chosen by the Attorney General, Senator.
Okay. So they were appointed by. Was there a process to go through in terms of the reviewers?
The Attorney...
A selection process? Did the department make any recommendations in terms of who might be appropriate to review?
Yes, Senator,
the
in
merger
the
of the
ordinary
Federal
course,
Court?
we put forward some recommendations and the Attorney General provided his choice.
Okay. And were these 2 put forward by the department?
I believe one of them was, and the other one was the Attorney General's.
Okay. So which one was the Attorney General's pick?
I don't know.
We might need to take that on notice, Senator.
Why would you need to take it on notice? It was either one or the other.
So Helen Rhodes, OAM, was put forward by the department, and the Honourable Linda Dessau was an addition by the Attorney General.
Okay. And can I ask, I don't know, Linda Dessau's background?
Linda Dessau is a former governor of Victoria, and a long esteemed legal background. I would have to give you more data, but she's very well regarded.
But she wasn't put forward by the department, though.
Senator Liam DeManuel, Assistant Secretary, Courts and Tribunals Branch. As Ms Lineker mentioned, Ms Desso was a former Governor of Victoria, but also was a judge, I understand, of the then Family Court of Australia, of the former Family Court of Australia. And Professor Helen Rhodes is an academic of long-standing and practice in the field of family law, and had previously been involved with the Australian Law Reform Commission, including on an inquiry relating to family law matters in Australia.
Okay, I'm not sure how that answered my question. I didn't ask for that. My question was, but Ms Desau was not put forward by the department.
Sorry, we thought you were asking about what her background was.
No, my question was, but Ms Desau was not put forward by the department. Is that correct?
Yes.
Yes, it was a captain's pick by the Attorney-General. Was she subject to a merit-based and transparent appointment process, or was it the Attorney-General who decided that she would be picked?
She's only a former governor and judge.
And your point is what?
Well, on what merit criteria would she not be
Well, that's
qualified?
a very good question, Senator Watt. So why didn't the department put her forward? And I thought the Attorney-General was always about merit-based assessment processes, not captain's pick. So here we go again. The Attorney-General says something prior to the election, makes a huge song and dance, but when we actually work through all the processes, and we're going to work through a little bit more, we find that he goes against what he tells everybody else. He's a great preacher, but he's not a great practicer, is he? So
Coming
again,
from
can I
someone who
just
never had
confirm
merit-based
that
processes?
Was she
honestly
subject to? So if Mr Dreyfus makes a selection, is that a merit-based process? Minister Watt, is that what you're saying?
No, I was just observing that I would have thought that a former governor and long-term judge would satisfy any.
Well, that is not the point, is it? That is not.
Well, it's not your point.
The point. The point is, both prior to the election and now, the Attorney-General lauds his merit-based selection process, and it would appear here that when Mr Dreyfus makes a selection, according to this government, doesn't matter, that's a merit-based selection process. This person was not put forward by the department. How many names were put forward by the department to the Attorney-General?
I would have to take that on notice, Senator Cash.
Is there a reason you need to take it on notice? Who was involved in this process?
I just can't remember, Senator Cash. I'd need to refresh my memory by referring to the relevant documents.
When was this put forward to the Attorney-General, these names? In what month?
I would need to take it on notice. It would be in the months preceding the commencement of the review.
Okay. Did the court have any input into the reviewers?
I don't recall, Senator. We can check our notes and come back to you on notice.
You don't recall. Secretary, did the court have any input into the reviewers?
I can't add to Ms Lineker's answer, although I'm not aware of whether or not there was any engagement from the Attorney or the Attorney's office with the court. I don't have visibility of that.
Minister, did the court have any input into the appointment process?
I have to add on notice.
I'm sure you do.
Well, I can't be expected to know every detail.
Well,
but
it's amazing what you are able to provide the committee via communications and what you're then not able to provide the committee. Secretary, did the court have any input into the terms of reference for the review? Seeing as there were several iterations, and we'll establish how many iterations there were that appeared to go back and forward.
Senator, yes.
Yes?
Yes, I think the Chief Justice was provided with a draft of the terms of reference and provided some comments.
What comments were they?
Look, I'd need to take that on notice.
Did he agree with the terms of reference?
Well, he provided some comments on it.
Okay, so did he agree with the terms of reference?
Well, I can't speak for him. I mean, I can't say implicitly. He provided some comments.
So what comments
they were
did he
taken
provide
into account
then in relation to the terms of reference?
I'd need to take that on notice.
So you recall that he provided comments, but you can't recall the comments he provided?
Correct.
Does anybody else here know about the comments that the Chief Justice of the Federal Circuit and Family Court of Australia provided in relation to the terms of reference of a review that was brought forward by a number of years into his court?
Senator,
I would have thought myself it would have been top of mind.
Senator, I recall that there were comments around the terms of reference, which were then taken into account. I don't have the details of it in front of me.
It's fine. So could you please take on notice to provide the details of the comments that the Chief Justice, the relevant Chief Justice of this court made in relation to the terms of reference, and in relation to the commencement of the drafting of the terms of reference and then the final settling of the terms of reference, so the final version, on what date was the Chief Justice of this particular court first provided with an opportunity to make comment on them?
I'll take that on notice, Senator.
Secretary, could I just go back to the comments? Do you recall anything about those comments?
I genuinely don't, Senator.
Does anybody here recall anything about the comments? Was the Chief Justice jumping up and down and clapping his hands and saying, I would have drafted these myself, they're that good?
I'd like to see a Chief Justice do that.
Nobody has any recollection here about the comments of the Chief Justice in relation to the terms of review in relation to the merger of his court?
Senator, as I mentioned, I recall the Chief Justice had textual changes to it. I don't have them
textual changes.
Don't have them in front of me.
Do we recall if he was happy with the terms of review?
How is he feeling?
On a scale of 1 to 10.
Well, it's a very good question then, on a scale of 1 to 10, if we could say that, because he is the Chief Justice of a court
I don't think
that is being reviewed.
Excuse me, it's sorry, if I can phrase it another way from the Chair's point of view, I'm not quite sure that the officials in front of you can give you evidence about the way the Chief Justice was feeling. You may want to ask a process question.
Well, were any changes made as a result of the Chief Justice's comments?
Yes.
Yes. What changes were they? Seeing as you knew that straight away, what changes were made as a result of the Chief Justice's comments?
My recollection, Senator, is that there were those textual changes. So as I said, he made some suggestions about the text. We made some textual changes.
What do you define as a textual change?
So a change to the operative parts of the terms of reference. So he, I don't have them to mind, Senator, but he came back with some changes. We made some changes.
And again, you seem to know that he made comment. You know that he made changes, but you can't tell me what those changes or comments are.
I don't have them in front of me, Senator.
Just the general gist of what they were?
They were around the operative provisions of the review and what it's to look into.
Okay. Just in terms... Oh, actually, what I will get you to do is, can I please have can you please table for the committee a copy of the terms of reference that were provided to the Chief Justice, and then a copy of the terms of reference as a result of the Chief Justice's comments, so at least then I can see what those textual, did you say? Textual changes are.
Yes, Senator.
Okay. And was the Chief Justice then provided with a final copy?
Yes, Senator.
Okay. Do you know on what date the Chief Justice was provided with a final copy?
I'll take that on notice, Senator.
Sorry?
I don't recall. I'll take it on notice.
Okay. Just in terms of the terms of review, the terms of reference for the review. The very first thing that is listed in the terms of reference is not about the impact on families or the speed with which matters are resolved, which I would have thought is actually what the review should be looking at. What has it actually done to ensure that families are better serviced and there is more efficiencies within the court, or anything to do, for example, with family violence. It's in relation to dual appointments. Can I ask, how many dual appointments are there?
There's
My colleague might have a...
Yep.
Senator, there's a number of dual appointments. So Chief Justice Alstergren is duly appointed Chief Justice and Chief Judge of Division
So that's
1 and
Yep.
Division 2 respectively. Respectively, sorry. Justice McClelland is duly appointed. I think that there's the two...
So out of the whole court, there's 2 dual appointments.
Judicial dual appointments.
Yep.
And I believe that the Chief Executive Principal Registrar sits across both courts as well.
Yeah, which is obviously separate too. And I suppose that's where my confusion lies. If I look at the AGD website, it says the Federal Court and Family Circuit operates under the leadership of 1 Chief Justice with the support of 1 Deputy Chief Justice who hold a dual commission in both divisions of the court. My concern lies in the fact that instead of making the priority of the review to focus on the users of the court, so the people that actually get into the system and want to get out of the system as quickly as possible, the review's focusing on dual appointments, of which there are 2. Can I ask the rationale behind that, please?
Senator, I just draw to your attention. So, indeed, there are 3 elements under matters to be considered. There's the impact of the structural reforms, which has a number of things drawn out for consideration by the independent reviewers, but it then does also go on to talk about aspects of the Act that have had unintended impacts on the operation and effectiveness of the court's federal family law and general federal law division procedure or jurisprudence. And then the third point is whether the operation of the Act can be improved through legislative amendments or other non-legislative changes, including structural changes. So I think the intention is that the terms of reference cover a broad range of operating issues and legal jurisdictional issues within the court.
Okay, so what is the first dot point under the heading impact of the structural reforms?
It is dual appointments, and then it is followed by 4 further dot points, and they are sub-points to the overall impact of the structural reforms with respect to these things. So that's the structural reforms, but then the substantive operation and effectiveness of those jurisdictions is drawn out in the second.
Did the department place that in the terms of reference, or was that from the Attorney-General?
I can't recall, Senator Cash.
Are you able to take that on notice? Again, it just goes to my concern that this should all be about the users of the system and the speed with which they get access to justice, and yet the priority, as stated under the first dot point, impact of the structural reforms, is looking at dual commissions or dual appointments, of which there appears to be 2. Can I also confirm that you've also asked the reviewers to look at the allocation of original and appellate jurisdiction in the federal family law matters, the level of specialisation of judicial officers exercising family law jurisdiction, and any impact of the change of the name, Federal Circuit and Family Court of Australia, Division 1 and Division 2. Given that we're dealing with a court system that has, this court system would have probably more direct impact on people's and families' lives than any other court. Why is the Attorney-General focused on the court's name?
Senator, I think that is one of 5 things. I would note that the second item on that list is the operation of the FCFCA as a single point of entry for federal family law matters. So it certainly draws out the experience of families entering this jurisdiction there, but I think it is one of a number of things that the independent reviewers have been asked to turn their minds to.
Can you also then take on notice who put that particular point in the terms of reference, whether it was department or whether or not it was the Attorney-General or the Attorney-General's office? But on that point as well, why on earth would this Attorney-General want to attack the single point of entry that has, when you look at actually what has been achieved by this court, it has provided so much benefit to the efficiency of Australia's law system, the family law system.
I think, Senator, the terms of reference are simply matters for the independent reviewers to turn their mind to. They don't presuppose an outcome.
In terms of then, and I might say it does presuppose an outcome, which is the abolition of the merger, which the government has always been against the merger, and bringing forward the review enables that opportunity. But just to look at then the limitations, because I found this quite extraordinary in terms of the limitations in the terms of reference, which read as follows: broader consideration of the family law system and the Family Law Act, 1975 Commonwealth, outside of the impact of the Federal Circuit and Family Court of Australia Act, resourcing for the courts or an economic evaluation of the efficiency of the courts are not to form part of the review. I'm just a little bit confused because, Secretary, if you're ordering a review of the courts, wouldn't you want to know about the broader impact on the family law system, but also in particular any issues about resourcing and efficiency?
Senator, I think subsequent to the provision that was made in the original Act, the review was targeted to these particular issues.
Or not targeted in this? This is an exception.
Well, targeted to the particular issues that are in items 1, 2 and 3.
So you agree that what I've just said is not to form part of the review?
Well, I think that's an accurate reading of what's been set out in the terms of reference, yes.
Again, my comment is that I'm just very concerned, and it's been raised with me by a number of appointments, that in the first instance it appears to be targeted to dual appointments and the court's name, and that is of great concern to people within the profession, in particular within the profession of those who work within the Federal Circuit and Family Court of Australia. And the concern they are raising in particular is that what I just said, that the broader consideration of the family law system and the Family Law Act outside of the impact on this court, resourcing for the courts or an economic evaluation of the efficiency of the courts are not to form part of the review. Minister, can you shed any light on why that wouldn't be part of the review, when I would have thought it's obvious that that's exactly what you want as part of the review?
No, I cannot shed any light on that.
Okay. Senator Cash, we can come back to this, but we had some discussions about breaking at 3 and having a discussion offline about the program going forward, so we might seek to do that.
I understand.
Yeah.
Yes.
If that's okay. So the committee will suspend and we'll return at 3:15 and we'll come back with some news about the program, hopefully. Thank you. I understand there might be a bit of shuffling around, so we'll let that happen now. Thank you very much to those officials that have been with us this morning.
Sorry, Chair. Senator Thorpe here.
Oh, sorry, Senator.
I wasn't privy to that, and I still had a number of questions.
Okay, well, I apologise. I wasn't sure whether you'd finished your questioning or not. We are really keen to move on. Can you finish off your questions in the next block?
It's in relation to NLAP.
Yeah, sorry. I'm saying if we give you another block of questions, can you finish off your questions in that block? Yeah, great. Yep. Okay, well, almost got there. Sorry about that. We have one more set of questions for Justice and Communities Group from Senator Thorpe, who is joining us online, and then after that we'll move on to the next outcome.
Thank you. I appreciate that, Chair. I won't take up too much time.
Just hold. Yeah. Okay. Thank you.
Thank you. So I just want to ask some further questions about legal services funding. What, in the department's view, is the exact funding shortfall for First Nations legal services between what was recommended by Dr. Mundy and what was provided?
Senator, we aren't able to answer that question. In part, I'd note we are still, as I referenced earlier, negotiating the National Access to Justice Partnership.
Right, okay. So, okay. First Nations Legal Services have advised that they need $400 million per year alone. These estimates have been provided to the department. So what is the department's evaluation of the figures provided by the sector? And do you agree that the government has not fully met this need?
Senator, I don't know that we have evaluated I understand we have received some of these estimations from the sector, but ultimately funding is a matter for government.
Righto. So with ATSL's currently receiving only approximately 22% of legal assistance funding, as noted in Dr. Mundy's independent review of NLAP, how does the government, in its strategy, plan to address this imbalance and ensure that ATSLs are prioritised to receive the necessary resources to meet the legal needs of our communities? Now, we've got to remember we're the most incarcerated people in the world, right here, our people. So what's going on?
So, Senator, there's a couple of things I would note. Under the heads of agreement coming out of the National Cabinet meeting in early September, there was that $3.9 billion, of which, as I've described, and around $800 million was to go towards towards pay parity, increasing indexation, and enabling additional frontline services. The Commonwealth's priorities were also for funding were also set out in that heads of agreement, and so they go to, for example, combating gender-based violence against women and children, particularly First Nations women and children, closing the gap and reducing incarceration rates.
Yeah, I understand that, and with all due respect, I have hundreds of our women calling my office because they can't access services. They're on the streets. They can't call the police because then they're profiled as a black woman. So they can't access Aboriginal legal services because they're shutting the doors. They have no resources to deal with the women coming to their door, the women and children coming to the door. They have to shut the door. So I know that's not on you, but on the ground, this is not working, and the Mundy Review did recommend that federal government provide $215 million in urgent top-up funding for legal assistance, and that hasn't happened. The government provided just $44.1 million, leaving $170 million shortfall for this financial year. Is that right?
Senator, it's correct that there is the $44.1 million for this financial year.
So I know that, you know, in Canberra, people don't understand what it's like for black women on the ground and their babies trying to flee a domestic violence situation. But, you know, someone with lived experience, back then I could go to a service and they could service me, they could help me and my babies. But today, under your government and under your programs that you're making decisions on, so many of our women don't have access anymore, and women are dying and children are at risk because these services don't have the resources. So do you understand the reality of on the ground for these women? Do you know the reality?
Senator, I'm very conscious of the reality of a number of people who seek help through legal assistance services, and I am very conscious of that.
Can you tell the black women watching this Senate estimates who can't access any services because their services that we rely on have shut the door? Can you tell those women where, those children and those women, where they should go? Should they go to your department? Like, is there someone that we can give? And I've spoken to the Minister, I've spoken to Katie Gallagher, in fact, about a number of women who are on the run and have no support because of lack of funding. Like, where can I send these women and children? To your department?
Senator, it's Catherine Jones, the Secretary here. Obviously, there's a role for legal assistance providers to support women and children in those circumstances, but there's also a range of other services available from both Commonwealth and state funding, including refuges and other areas. So I think I recognise the incredibly difficult circumstances of some individuals and the challenge about working out where is the best place to get support. But it's the support that's available for men in those circumstances is broader than legal assistance services.
Yeah, okay. That's a good answer. Thank you. And that's just, you've just said that to all the black women out there who, you know, may or may not agree with you, which understandably so. When an Aboriginal person who doesn't speak English as a first language is forced to represent themselves in court, does the department consider this a breach of the right to a fair trial and hearing, which are supposed to be guaranteed by the International Covenant on Civil and Political Rights?
Senator, obviously in those circumstances, if individuals are before state courts, because I think primarily you're talking about the experience would be in state courts or magistrates' courts, or
territory.
Yes, or territory courts, absolutely. I am aware that there are some services around language support in some areas. I don't know how comprehensive that is. But
sorry to interrupt. Are you aware that there are non-English speaking Aboriginal people rocking up to court with no legal representation because of these legal services not having the resources to deal with the amount of need out there? Now, remember, there's a lot of racism going on and blackfellas are being targeted everywhere. Where do they go if they can't speak English? They're proper language speaking people. Where do they go? They're not being represented by a lawyer or any services in this country right now. Where do they go?
So, Senator, the only way I can answer that is that we are looking at continuing to support ATSLs and family violence prevention legal services. Legal aid commissions also can provide services.
There's no evidence of that. I'm sorry, that the funding says otherwise. With all due respect, the funding says otherwise. We have our people in those services working 24/7. They're not white fellas. They don't rock up at 9 and clock off at 5. They work 24/7 in their communities. They know their communities, and they are working on a minimum wage as it is, and are not being resourced to deal with the people that are coming for help. And that's on the department and that's on the government. So can I ask on that, in that sense, does the department have figures around how many First Peoples are currently in prison who did not have legal representation? And we're talking children too, right? 10-year-old children that the colony locks up today. So do you have figures on that?
Senator, I don't have those figures. I would note the Family Violence Prevention Legal Services, which is not administered by this department, but I understand did receive additional funding this financial year as well, in order of around 20%. And additional funding will be provided to all parts of the legal sector through the National Access to Justice Partnership.
Yep. Can I ask then that you take that on notice? Because I'd like to know how many First Peoples are currently in prison who did not have legal representation. I think that is something, that's a human right. And I think if this government doesn't know that answer, then that's a very serious concern in terms of closing the gap and all things, you know, trying to reconcile what's gone on in this country. So do you mind taking that on notice?
We can take that on notice, Senator, though a lot of any information in that regard will be held by the states and the territories in relation to their courts. But can we take on notice and look at what we can provide in response to that question?
Thank you. And would you mind taking it up with SCAG, given that SCAG doesn't seem to have anything on its agenda at the moment other than a race to the bottom of lowering the age of legal responsibility and locking up more babies? I'm sure that they could provide some space on the agenda for gathering data that clearly demonstrates that there are gaps in legal representation. And it's actually, you know, I don't want to preempt things here, but you could all be complicit of genocide if you're making decisions that deny our people legal representation as part of our human rights. So be very careful about what decisions are made, and we've got to stop this ongoing genocide of Aboriginal people in this country. And I'd appreciate if you could put that on SCAG's agenda, given we're not a priority since a referendum. We're just an afterthought, and our people are being jailed more and more and more every day.
Senator
and
Thorpe,
that includes our babies.
Senator Thorpe, I think the officials have agreed to put that on notice. They were nodding, but you...
Senator, I was just going to add that closing the gap remains on the SCAG agenda, and take the rest on notice.
I just have one final question, Chair, and it's just going back to
I was about to try to wrap you up, Senator Thorpe. So if you just, if you do have one last one, you can put, and then we can move to the next outcome. Thank you.
Appreciate that. Thank you. Just going back to justice reinvestment, and I'm happy for this to go on notice, but of the total funding going towards justice reinvestment, because I've heard that the government's trying to spend the money now and get things out the door to make announcements. How much funding has been allocated to administrative costs to date, both within the department and within recipient organisations, compared to funding gone to actually delivering programs? So how much has the bureaucracy and the administrative process taken up, and how much money is actually getting to our people to deliver the programs? What specific amount has the department spent on travel or staff relating to consultations for justice reinvestment program, including costs of flights, hotels and travel allowance? And I'm happy for that to be taken on notice.
Thanks, Senator. We'll see what we can do to respond to that question.
I look forward to receiving it. Thank you very much.
Thanks, Senator Thorpe. That's all the questions we have for Justice and Communities Group, so thank you to those officials.
Chair, we just wanted to take the opportunity, Ms Lineker was going to come to the table. There was a piece of information that we provided earlier that was incorrect, that went to the number of new judicial appointments, and we just wanted to take the opportunity to correct that if we could.
Thank you. I did not include 4 additional judges. So when I mentioned 16 new judicial positions, the correct number is 20. That's 14 for the FCFCOA and 6 for the FCA. Thank you.
Thanks for that correction.
Thank you.
Thank you. We'll now call officials from the National Security and Criminal Justice Group. And while those officials are coming to the table, if it assists in terms of programming, we have some questions for National Security and Justice Group, a large amount of questions and senators seeking the call for Integrity International Group. So I don't think we'll be getting to the AFP until after dinner. We will certainly try to make up some time and we'll try to provide some information about the agencies at the end of the program around dinner time. As a courtesy, senators, we'll see how we go. We may have to drop down to sort of 10-minute blocks to get through the amount of people seeking the call, which is expected, but we'll do our very best. So I'm going to hand the call now to Senator Scarr, who's going to kick us off.
I'll actually...
Oh, sorry, Senator.
I will now do it. So just very
okay.
Can I please look at parole for federal offenders?
Yeah, I know. I'm going to give you the call.
Yes, it is. Brilliant. Yes. Okay, I'll move through these as quickly as possible. Can I confirm that the Attorney-General has considered 40 parole matters since the 1st of July 2022?
Oh, sorry, we're just finding those.
Yes.
Tara Inverarity, First Assistant Secretary, International and Security Cooperation Division. Yes, that's correct.
Thank you very much. What was the matter in which he granted parole?
Sorry, Senator, we're just considering, given the case-specific information, given there's only one matter in that category.
What was the nature of the offence?
It was a terrorist offender, Senator.
It was a terrorist offence, okay. What was the nature of the terrorist offence?
I think we'd have to take that on notice, Senator. We don't have those details.
It's a pretty significant... So he's made one decision. Sorry, he's made 40 parole decisions. He's released someone. Is this the only person that's been released by the Attorney-General in relation to a parole matters that he's considered?
Yes.
Yes, okay. So let's now work on this person. What was the nature of the terrorist offence that was committed by this person?
Yeah, Senator, we don't have that detail, and there are issues. We'll need to take it on notice because as we get down to further detail, it becomes identified.
So in
as well.
39 cases, the Attorney-General refused parole, but he decided to parole a terrorist offender. Who was the terrorist offender?
We've taken that on notice.
Do you know who it is?
Yes, we do.
Right. And can I ask why you're not providing the committee with the name of the terrorist offender that has been released?
Because we, in parole matters, generally don't provide case-specific information, both because of risk to individuals and privacy issues. So we would like to take that on notice.
When was the decision made by the attorney to release the terrorist offender on parole?
Yes, we don't have that information with us. So
you do not have that information in front of you?
No.
Are you able to obtain that information?
We'll take that on notice.
So you're not able to give that to the committee tonight. What year was the terrorist released by the Attorney-General?
We don't have that with us. We'll see what we can do this evening.
What information do you have, Ms Chidgey, in relation to the parole of a terrorist offender by the Attorney-General?
I would just say generally on these matters that the thresholds for granting parole are very high for terrorist offenders.
I didn't ask that.
Well, I'm able to just tell you about the decision-making process in general without necessarily identifying the individual. We've taken that on notice. The process is that there's expert advice from law enforcement and corrective service agencies and that the safety of the community is considered as the most important consideration in all those decisions. And anyone who is released on parole is subject to very close supervision of state and territory corrective service agencies at all times with a range of conditions that can include electronic monitoring, approval of access to social media and restrictions on association, amongst other things.
So in every other jurisdiction, parole is a public matter because it is an aspect of sentencing which is always public. So again, I'm going to ask you, why can't you provide details on a terrorist offender who was granted parole by the Attorney-General of Australia?
Senator, I've given that answer that we don't disclose the details of individual parole matters for the safety of individuals and the community and privacy, and we've taken that on notice to consider.
Secretary, do you know who this terrorist is?
I am aware, yes.
You are aware. Are you able to provide the committee with the nature of this particular terrorist offence?
That I don't know. No,
you don't know, but you do
detail.
know the name of the terrorist who is now in the community?
Yeah, I do.
Okay. What is the process by which a recommendation is provided to the Attorney-General in relation to a parole for a federal offence?
The department provides the Attorney-General with a submission with a significant amount of information, including advice from law enforcement agencies, including joint counter-terrorism teams and corrective services. That is quite an extensive analysis.
Okay. Is Mr Dreyfus bound by that advice?
No.
No, he's not. So Mr Dreyfus could choose, if the advice or the recommendation of the department is to release a terrorist, to choose not to release the terrorist.
It's right. The Attorney-General is the decision-maker.
Right, the Attorney-General is the decision-maker. Did the department recommend to Mr Dreyfus that the terrorist be released?
We won't discuss the details of our advice to the Attorney-General. What I would say is that...
On what basis will you not discuss the advice provided to the Attorney-General in relation to a terrorist that has been released by Mr Dreyfus in relation to a parole decision? Because, you see, he didn't have to be, or she did not have to be released, so I want to pursue this matter. On what basis are you saying that you will not provide this advice?
Our advice to the Attorney-General contains a range of sensitive information and legal advice.
Yeah, and is that a public
Yes.
interest immunity claim?
We will need to take that on notice.
What are you taking on notice?
Whether a claim for public interest immunity. I've given you the reasons that we wouldn't disclose, but we can take it on notice to seek the Attorney-General's view on a public interest immunity.
Minister, that needs to be provided to the Minister to actually make the claim.
Well, it would go to the Attorney-General.
Sorry, what was that?
We've taken on notice to ask the Attorney-General.
You've taken on notice to ask the Attorney-General what?
It's the Attorney-General who would make a decision on a public interest immunity claim.
But this is the Minister representing the Attorney-General. The Attorney-General
I think you understand that I'm here representing another minister, and the officials obviously need to confer with the minister responsible for the portfolio.
Are you able to confer, Minister, with the Attorney-General to see whether or not... I'm just interested to know what the department's recommendation to the Attorney or to Mr Dreyfus was in relation to the releasing of a terrorist.
I will take that on notice.
Okay. Did Mr Dreyfus consider the community safety when he released the terrorist into the community?
The Attorney-General has made it clear that the safety of the community is his highest priority.
And how has the Attorney-General made that clear, given this is a terrorist who did not have to be released? The Attorney-General did not have to release this particular person on parole. We still don't know the nature of this person's offence, other than it was a terrorist offence. How has the Attorney-General made clear that he considers community safety his highest priority?
So, as I said, he gets very extensive advice from law enforcement and corrective services agencies.
Well, that's their advice, that's not the Attorney-General.
It is their advice that he considers keeping the safety of the community as the most important consideration, and in appropriate circumstances, parole can keep the community safer because it means that there are mandatory controls and supervision in place on release.
So that's an interesting statement. Parole can keep the community safer. Okay, so let's work through that. Where was the terrorist prior to the Attorney-General, Mr Dreyfus, releasing him or her?
In a correctional facility.
Well, I will put it in plain English. I'll ask in plain English. Was the person locked up?
Yes, Senator.
Right. So on what basis are you saying that community safety can actually be enhanced in the event that the Attorney-General releases a terrorist on parole and they are in the community?
So individuals, when they've served their sentence in full, are released, and
had this person released their sentence in full?
Well, I won't get into their details, but parole means that there's a period of supervised supervision in the community for a short period.
That wasn't my question. I'll have to share the call in a moment if you've got one last question. Yep.
Why were the circumstances appropriate for Mr Dreyfus to release this terrorist into the community?
So, Senator, the legislation requires exceptional circumstances, and the Attorney-General was satisfied that those exceptional circumstances existed in this matter.
But let's be clear, you are given parole if you have not completed your sentence.
That's right.
That is correct.
And the parole exists for community safety
I understand,
purposes.
but the question I had put to you was, has this particular terrorist served their sentence in full?
I think I could say they have now, Senator.
Well, I don't want to know if they have now. At the time that the Attorney-General, Mr Dreyfus, released the terrorist...
Cash, I've called you to order a couple of times. I have to share the call. We can come back to you.
I'm happy to come back, Chair.
Chair, could I just... I can't obviously give details of the individual offender here, but I've got some general points I can make in response to some of Senator Cash's questions.
Do you want to put that now and then we can move on to Senator Shoebridge? I know he's really keen to ask some questions.
Sure. So obviously the safety of the community is the Attorney-General's highest priority at all times, including when making parole decisions. In relation to cases such as the one we're talking about here, involving a terrorist offender, there's a very high threshold that must be met for a person to be granted parole. the safety of the community is the most important consideration in these decisions. We need to remember that parole is designed in a way to keep communities safe. It means mandatory controls and mandatory supervision are in place, which otherwise might not be available at the end of someone's sentence. As Senator Cash, I'm sure, would be aware, people who are on parole are subject to strict supervision conditions, which are informed by the advice of law enforcement and corrective services agencies. At all times, parolees are under the close supervision of state and territory corrective services agencies. And I would make the point that former Coalition Attorneys General and Assistant Ministers have also made decisions to release individuals on parole.
We'll come back to those statements, I'm sure, Senator. Senator Shoebridge, you have the call.
Thanks, Chair. While we're on parole, Secretary has, and it does feel that way, Secretary, are there any moves to establish an independent parole board or an independent parole body at a Commonwealth level? Every state and territory has an independent parole board or authority, and that's why you don't get questions like this about politicised parole decisions at a state and territory level. It's just the Commonwealth that has failed to do that. Are there any moves so as we can depoliticise parole?
Thanks, Senator. That has been an issue that we've been doing some policy work on to develop a model. It's not concluded yet, but I think for some of the reasons you've outlined, there are obviously arguments in favour of having a model like that at the Commonwealth level.
So is there any draft legislation? Is there any public consultation? Because this issue won't go away, the politicised decisions about paroles. And indeed, there's likely to be a series of high-profile parole decisions having to be made at a Commonwealth level in the next few years. Is there a time frame to establish finally an independent parole body for the Commonwealth?
Can't give you a time frame, but can say that it is being considered by government.
On what basis does the attorney currently decide whether or not the attorney will make a decision on parole or someone who they've delegated will make a decision on parole?
Yeah, I'll get my colleague, Ms. Imbarati, to tell you how we decide that.
Thank you. It's really up to the preferences and direction of the Attorney-General of the day. The current Attorney-General makes decisions on terrorist offenders, and all other matters are considered by departmental delegates. It has been different in the past with other Attorneys-General, so it really is just dependent on the views of the holder of that office. And
is that currently set out in a formal policy, or is it just the department understands the current expressed discretion review of the attorney?
I think we've had that arrangement settled through a ministerial submission to the Attorney-General.
And does that say the Attorney-General will only consider terrorist-related matters, or does it say the Attorney-General wishes to consider terrorist-related matters?
It certainly gives the department clear direction that no departmental delegate will make a decision in relation to a terrorist offender. That's always submitted to the Attorney-General. Where there are other highly complex or high-risk decisions, we will often engage with the Attorney-General's office to bring to their attention a particular matter and see if the Attorney-General wished to be the decision-maker in a particular matter, but otherwise it's simply the case that terrorist offenders are considered by the Attorney-General.
So at some point in the next 2 years, unless David McBride succeeds on his appeal, either as to conviction or sentence, and if it's as to sentence, it may be even sooner, at some point it is likely that David McBride would bring a parole application on the basis of what you said, Ms. Inverarity. That would likely fall within the complex/contentious matters. And would we really have a situation where the Attorney-General, who David McBride has been deeply critical of for allowing the prosecution to continue, would sit there and exercise a discretion on parole, or even exercise a discretion as to whether or not to exercise a discretion on parole? Is that the kind of highly politicised situation we'll be in?
First, I'd just like to point out that under the Commonwealth Parole scheme, offenders do not need to apply for parole. They are automatically considered at the expiry of their non-parole period and then at a minimum every 12 months after that. You are correct that the Crimes Act vests the decision-making power in the Attorney-General. And apologies, the other thing I was just going to mention is that all parole decisions are reviewable under the Administrative Decisions Judicial Review Act as well. So the absence of a Commonwealth Parole Board does not mean that decisions are unable to be reviewed.
But we come to this point that because not just this administration, but the previous administration and the one before that have failed to put in place an independent Commonwealth Parole Board, we could well find ourselves in the situation next year where we have a highly politicised parole application being decided by an Attorney-General who has been the subject of repeated and deep criticism from the person seeking parole on a highly politicised point. That would be a terrible situation to put the justice system in, a highly politicised, terrible situation for the justice system.
I don't think I accept the characterisation of the McBride matter as being highly politicised.
Well, we'll have to agree to disagree on that, Secretary. Most people see it as a political prosecution, and most people that I know and much of the public debate sees David McBride as a political prisoner because he told the truth about war crimes. And we'll just have to agree to disagree on that.
And Senator, all those decisions are subject to administrative law requirements, so there are all of those requirements about that decision making needing to be made on a proper basis.
All right. Could I ask you about, could I get some explanation from the department about the unconscionable delay in the extradition of Adriana Rivas?
Sorry, we missed that.
Adriana Rivas. For assistance, she is a woman who has been charged with 7 counts of aggravated kidnapping and disappearance of 7 political dissidents during the Pinochet regime in Chile. The Chilean diaspora here are distraught at the delay in her extradition and cannot understand how a woman who was charged in 2007, who escaped from Chile to come back to Australia in 2010, has still not had the extradition process completed. They cannot comprehend it. Can you explain the delay?
Senator, I'll ask my colleagues to expand. Obviously, the extradition process has multiple steps, and at each point in those steps, people can avail themselves of review and appeal rights, and that's definitely happened in this case. But I'll ask Ms Inverarity to expand on that.
Thanks. In addition to the Secretary's comments about the appeal process, the other thing I would say is that extensive procedural fairness is undertaken before the Attorney-General or another decision-maker considers the surrender determination, and in this case there has been extensive procedural fairness involving both Ms Rivas and Chile to ensure that the Attorney's decision is attended by all of the facts and circumstances. The other thing I would just note in this matter is that although the Extradition Act provides for the Attorney-General to be the decision-maker, in this case he authorised the Minister for Finance, Senator Gallagher, to be the decision-maker in accordance with the Act's Interpretation Act, and it's Senator Gallagher who's considered the surrender determination.
And I assume that's because, and I'm not being critical of the Attorney in 2014 made a public push to have the extradition actioned.
It's to avoid any perception of apprehended bias in the decision.
Has Minister Gallagher made a determination?
Yes, she has.
I'll just take you to the timeline as I understand it, and I don't see how it's explained by simply the granting of natural justice. Ms Rivas is alleged to have committed these crimes, appalling crimes, against political dissidents of torture and disappearance during the Pinochet regime between 1974 and 1977. She, for some reason, she comes to Australia soon after, in the late 70s, lives in Australia, and then returns to Chile and is arrested and charged in 2007. She skips bail and escapes back to Australia in 2010 or 2011, and then nothing is done at all from Australian perspective, it appears, until 2019 officially, when Australia eventually accepts an extradition request from the Chilean Supreme Court, which is conveyed to Australia. What happened between her return in late 2010 or early 2011 and 2019?
We'd have to take it on notice, but Senator, that is largely, it's for the Chilean government and authorities to apply to us. I mean, we work very collaboratively with other central authorities in these international crime cooperation matters, but at the end of the day, it's a matter for them in terms of putting in the extradition request.
And in many cases, there needs to be work in terms of the content of their extradition request to meet our legal requirements. The team here often provides assistance with that. I would add as well that the natural justice process is very extensive on a complex case like this, with multiple involving translation and multiple requirements to go to the parties.
That request was first made in 2014 from Chile. So it took from 2014 to 2019 for Australia to accept it. Was that because of natural justice reasons, that 5-year delay?
The natural justice is after the magistrate's decision. The earlier process is often that it requires considerable work from the country proposing to make the request to conform to the requirements that need to be met at our end. But we've taken on notice any specifics that we can give you about that.
Well, I'd ask if you could, on notice, to provide details that explain. I repeat, the Chilean diaspora here, the community, are distraught at the fact it took 5 years from the first request from Chile. And we're talking about some of the most serious charges possible. Effectively, multiple disappearances and tortures charges against family members of the Chilean diaspora here who want some justice. So will you provide an explanation for that delay between 2014 and 2019?
Yes, we'll do that. I would like to say, though, Senator, I know just how much work there has been done in the team in the Attorney General's Department on this matter, and it is very considerable. Well,
perhaps finally, after multiple legal challenges against the bail seeking bail and not succeeding in those challenges between, we're talking June 2019 and June 2020, there's finally a trial, a hearing on the extradition, and in October, the New South Wales local court finally orders the surrender. That was October 2020. We're now in November 2024. How do we explain the next 4 years of delay?
And that is the procedural fairness requirements, which we can also look at what details we can.
But this is a woman who's had a hearing in the federal court where her claim was rejected, a hearing in the full bench of the federal court where her claim was rejected, a second attempt to appeal in the federal court where her claim was rejected, an application to the High Court which was eventually abandoned, and a certificate of abandonment happened in the 9th of May 2022. And so from the finally ending all the legal challenges in May of 2022, we then get another, 2.5 years of delay before an order is made by Minister Gallagher in, was it September of this year?
It was the 28th of August this year.
2.5 years of delay. That's not natural justice for the victims. It's not natural justice that anybody that I speak with recognise. These are for crimes that were committed in 1974 to 77. How do you explain 2.5 years more delay after 2 years of delay in the court and 5 years of delay from the first extradition?
We would just say that doing procedural fairness processes properly and thoroughly is very important to the ultimate success of the extradition. Ms Rivas has most recently filed a further application, as you've noted, seeking judicial review. If we don't do proper procedural fairness, then we put at risk the whole process.
Is the Chilean,
just one more question.
Is the Chilean community, has there been a stay ordered with the application for judicial review? Has the Commonwealth consented to a stay?
Yes, Senator, we won't extradite while there is judicial review on foot.
So potentially years more delay, while yet another likely totally unmeritorious challenge is made, and all the while a notorious instance where there's alleged to be multiple cases of torture and kidnapping and disappearances of political dissidents doesn't come to trial in Chile. Can you not understand how distraught the Chilean community is about this here?
Senator, we absolutely understand that extradition processes can be very lengthy and the issues associated with that. The significance of the decision to extradite means there are multiple steps, as the Secretary
But that's
indicated.
already happened.
Thank you.
And those steps are not completed, and Ms Rivas is exercising the legal rights she has.
Thanks, Senator Schubert. Senator Cash, I'll come to you again.
Thank you. If I could just return to the line of questioning I was previously pursuing, just in relation to the release by Mr Dreyfus of the terrorist, in relation to this particular person, how long was their sentence? For how many years were they sentenced?
We need to take that on notice.
Another one you need to take on notice?
Yes.
Okay. What were the conditions imposed on the parole?
Again, I think that goes to the individual's details, so we will take that on notice.
How does that go to the individual's details? I'm merely asking for the conditions that were placed on parole. You've taken on notice whether or not you're able to provide me with the person's name.
Yeah, we'll have to consider whether there's anything about that I could identify the individual, but we'll take that on notice. We don't have those details.
Were there conditions placed on the person's parole?
So the Crimes Act requires every parole order to have in it a condition that the person be of good behaviour and not breach any law. Beyond that, the decision maker has a discretion about further conditions that should be imposed.
So the decision maker being Mr Dreyfus?
Correct.
Did Mr Dreyfus place any conditions? I'm not asking what conditions because you won't provide the committee with that information. Did Mr Dreyfus provide any conditions on this particular terrorist?
Yes, I've never seen a parole order which has but one condition. They always include additional conditions.
And yet you can't tell me what those conditions are. You've taken that on notice.
We just don't have those details with us, so we'll have to take it on notice.
Okay. What state was the terrorist released into?
We'll have to take that on notice.
Do you know where the terrorist currently is?
No.
You don't? Okay,
No.
You don't. So the terrorist is able to move freely between states?
So the sentence is complete, as we mentioned
The sentence
before.
is now complete?
Yes, fully complete,
Okay.
which means there's no legal basis for any monitoring.
So this particular person is no longer being monitored?
Not under parole, not under a legal regime.
Okay. Are they being monitored under any other regime?
That would be a matter for agencies if there were any issues, and
Well, would
that
you
would
be made
obviously
aware of
something
that as the Attorney General's Department if a particular person that had been released?
That would be a matter for agencies and not something
Are
that
you
would be
aware
disclosed.
if this person is being monitored in any other way?
We are not.
Okay. Secretary, are you aware if this person's being monitored in any other way?
I have nothing to add from what Ms Chigi has said.
So you said he was subject to close monitoring. That is correct? That was your evidence?
I said that parole conditions can include
so you didn't say that this particular person was subject to close monitoring?
Anyone on parole is subject to the close supervision.
Right, so there was a general as rather the particular terrorist. When was this particular terrorist sentence complete?
We need to take that on notice.
Okay. Just in relation to the line of questioning that Senator Shoebridge was pursuing, can I just confirm that the only parole decisions that Mr Dreyfus as Attorney-General considers are in relation to terrorists or terrorist offences?
That's right, terrorist offenders.
Right. Everything else has been delegated to a departmental official?
To be clear, all of the decision-making powers under the Crimes Act are delegated. The department will not exercise those delegations in relation to terrorist offenders. They go to the Attorney-General. But yes, all of the other categories
that's what I'm trying to ascertain.
Offenders.
There are a number of federal offences.
Absolutely. They are
parole applications come up. The Attorney-General has determined that he is not going to exercise his right to say yes or no, other than, as you've stated, in the terrorism cases. Just on this one that was released, did they wear an ankle bracelet?
I think that falls into the category of details that we've taken on notice.
I look forward to receiving them. Child sex offences. Child sex offences include child pornography?
Yes, we tend to refer to it as child exploitation material.
Child exploitation. Can you just take me through what a child sex offence entails at a federal level?
There's a range of child sexual exploitation offences in the criminal code. They can relate to offenders who travel overseas for the purpose of exploiting a child sexually. They can relate to online offending, and I think that they're the main categories.
Okay, but the Attorney-General does not make decisions in that regard, parole decisions. That's delegated to the department?
That's correct.
And an instrument of delegation was signed by Mr Dreyfus?
Yes, there is an instrument of delegation for parole decisions.
Okay, so it was an active decision not to actually consider the parole decisions for child sex offenders by Mr Dreyfus?
The Attorney-General has not indicated that he wishes to make parole decisions for child sexual offences.
Does the department tell Mr Dreyfus when it releases a child sex offender on parole?
Apologies, Senator, I missed that question.
Does the department tell Mr Dreyfus or his office when the department releases a child sex offender on parole?
No.
No. And the Attorney-General, has he ever asked how many child sex offenders has the department released on parole?
Not to my knowledge.
Okay. So on page 16 of 16 of the response provided by the Secretary to the questions asked by coalition senators, it states at page point 14, parole for federal offenders. Parole decisions from the 1st of July 2022 to the 28th of October 2024. Departmental delegate granted parole in 483 instances, refused parole in 446 instances. So in over 50% of cases, the department has granted parole to a federal offender. How many of those 929 cases in total related to child sex offences?
Senator, as I think we've explained before, we're not able to provide data that cross-references the decisions that have been made to grant and refuse parole with the nature of the offending. It's not how our database holds the information, so we're not able to tell you of those decisions to grant or refuse parole how many related to drug offences, fraud offences, child sex offences. We just don't capture the data that way.
There were 929 parole decisions. You could stack up the 929 briefs. You could divide them into two piles. One is granted, 483. The other is refused, 446. And quite frankly, you could actually go through and work out how many child sex offenders the department has granted parole to, how many drug offenders the department has granted parole to. Is this not something that you could actually do, given that the total is only 929?
No, it's not something we can do, and we've explained before we would not be able to compile that information with accuracy.
So do you report to the Attorney-General, or Mr Dreyfus, at all in relation to the 483 instances that the department has granted parole to federal offenders, including child sex offenders? Do you report to him at all in relation to the nature of the offence and why you decided to grant parole to these people?
No.
No, you don't. And the Attorney-General, has he ever raised these issues with you?
No.
Right.
Could I note, Senator Cash, Senator Gosh recently asked a question on notice about this as well, and in the period 1st of January 2020 to the 23rd of May 2022, the then Attorney-General, who I'm guessing might have been yourself, granted 2 applications for parole. The Assistant Minister granted 1 and the departmental delegate granted 481 for a total of 484.
And your point is what?
Well, again, I think for the 3rd time today, we've been able to demonstrate that the very thing you are asking questions about and implicitly criticising the Attorney about are exactly the same things that you did when you were the Attorney-General.
And your point is what?
What I just said.
Well, it's hardly relevant to this government and the questions that have been asked.
I'm just surprised that you're making an issue out of things that you did yourself.
I don't recall releasing a terrorist.
I just think it's surprising that you're making an issue out of...
Well, you can be surprised. Good on you for being surprised. I don't recall releasing a terrorist, and that is the line of questioning that I have been
We've
pursuing.
just been talking about child sex offenders.
And the delegations by the department, by the Attorney-General. In terms of the delegations, at what level of seniority are decisions made by the department?
Thank you. The delegation is made to the Secretary, the SES Band 3, which is Ms Chidgey, myself, I hold the delegation, and then there are 3 SES Band 1 officers in the department who hold that delegation as well.
So in total, how many delegations are there in terms of the number of people who are able to review a parole decision and then determine whether or not it's granted or not?
There are 6 positions that hold that delegation.
And is anyone able to delegate those positions down?
No.
Okay. Can I ask for... You've confirmed that departmental officers do not consider terrorism matters?
Correct.
Okay, that is for the purview of the Attorney-General. All of the parole decisions are reviewable, is that correct?
That is correct, under the Administrative Decisions Judicial Review
And just in terms of, I asked about parole decisions in terms of the timeline that I had presented from the 1st of July 2022. Can I just go back in time? Did the Mr Dreyfus make any parole decisions between the 23rd of May 2022 and the 30th of June 2022?
I'm not sure, Senator. We will have to take that on notice and check.
And can you also then confirm, or can you also have a look at, did the department make any parole decisions in that same period of time?
There is no doubt the department made parole decisions.
And it will get me how many then.
We'll take on notice the numbers.
I should have, that's fine.
Just one last question, Senator Cash.
Oh, I finished that topic. I can move on to a different topic.
I might just ask some follow-ups, then I'll hand over to my colleague, Senator Polly, who I think has some questions. Can I ask on the question on notice, BE 24144, I think that was some questions from my colleague, Senator Ghosh, about previous parole decisions. We were able to get an answer of number parole granted by the Attorney-General or the Assistant Minister, so the Minister at the time, between the 1st of January 2020 and the 23rd of May 2022. And there were 3, is that right, if you put the 2 together? So the Assistant Minister or the Attorney-General, there were 3 parole granted by members of the previous government.
I apologise, Senator. I don't think we have that answer to the question on notice
Is that
with
the
us.
answer, though? You'd recall that data. There's only 3 of them.
Senator Luke Brown, Assistant Secretary within the department. We just don't quite have that with us. What I can say that in the calendar year, the financial year 2021-22, the Attorney General or Assistant Minister made 2 decisions. In the calendar year 2020 to 21, there were 2 decisions to grant parole.
Do you want to take me through that again? Because that's a bit different from the
financial year 2020-21, there were 2 decisions to grant parole that were made by the Attorney General or the Assistant Minister. And in the financial year 2021-22, there were also 2 decisions to grant parole by the Attorney General or the Assistant Minister.
So 4 possibly altogether. Now, we asked for that data actually going back to the 18th of September 2013 so we could understand how many parole decisions were made during the lifetime of the previous government across the 3 different Attorney Generals. Unfortunately, the department was unable to give us that information. Can you explain why?
Certainly, Senator. We transitioned to a new sentence management database in 2020, and the data integrity can only be assured from the 1st of January 2020, so that was the date from which we provided the data. Anything before that would require extensive manual review of files, and we would not be able to assure ourselves of the accuracy of that data.
So it's highly likely the number is more than 4 between 2013 to 2022, but you can't give us that data.
I'm afraid I just don't know how many decisions might have been made prior to that date by an Attorney General or an Assistant Minister.
I know you just don't know, but there were obviously decisions made during that time. That's right, isn't it? I'm not asking you for the number. I'm asking you for whether decisions would have been made.
Decisions would have been
put on
made.
hold because you didn't have a data
Decisions would
system.
absolutely have been made. Whether they were decisions to grant parole is harder to speculate on.
Sure, okay. So it could be more than 4. All right. And do you know of those 4 what the offences were?
I do not have those details.
Okay, we might ask that on notice. We might come back to that. Thank you. Senator Polly, I understand you have some questions.
Yes, I do. Thank you, Chair. I want to talk about what's happening in relation to anti-money laundering and counter-terrorism financing risks and what impact that's having on the Australian community.
Senator Polly, before you proceed, and this might assist other senators who also have questions on this topic, we are currently inquiring into a bill in relation to this policy area. We've already had our hearing, so senators aren't going to miss out on an opportunity to ask questions, but we'll be a little careful about provisions of the bill and asking advice about the provisions of the bill, but the general policy should be fine in terms of asking questions. That's a nice little quirk of a Senate committee process. We haven't reported yet. Thanks.
No, thank you. And there's another, the Joint Committee is also looking into this. So
does that make
can
sense?
you give us an overview, please?
Yes. Senator, do you mind just repeating your question?
I was limping my way up, apologies.
Okay. What are Australia's anti-money laundering and counter-terrorism financing risks? So in other words, what are the risks to our economy and to the Australian community?
Thank you, Senator Polly. Apologies. Andrew Warnes, First Assistant Secretary, Criminal Justice Division. So illicit financing causes significant harm to the Australian community. It distorts the economy and it deprives government of limited resources. So the estimated costs of serious and organised crime in Australia is up to $60.1 billion a year. The true total cost of crime is much greater given the illicit nature of the activities and the second-order effects of the community and the economy. It's always hard to quantify these things. The estimation is that the amount of money laundered in Australia is up to 2.3% of GDP. Now, maths not being my strong point, I'd say that that's around $40 billion a year that it's estimated money of laundered money in Australia. So the idea of expanding the regime and simplifying the regime is to take the opportunity away from the criminals to exploit that avenue into the financial ecosystem. So there are some other harms that we've looked at that are also difficult to quantify as well, such as inflated prices for goods and services that are targeted for money laundering, so things like real estate, market distortions for small businesses unfairly competing against laundering fronts, and obviously the personal impacts, sometimes quite devastating on victims of serious crime that's related as well.
So can you explain to us how money laundering enables crime in this country?
Do you want to take that one?
Thanks, Alex Engel, Assistant Secretary, Transnational Crime. The way we view money laundering, I think it can sometimes be viewed as quite a either white-collar or victimless issue, but when we look at serious organised crime, it's normally the key motivator for these groups, so it's all about making the profit. That's why they do the activities that they do. Then they've got to do something with this profit. So that's where the proceeds of crime and the money laundering comes into it. They're either wanting to launder it so they can use it, enjoy the proceeds of their crime. The second element is that they then use it to reinvest into further criminal activity. So we do have some research from the Australian Institute of Criminology that shows that for serious organised crime groups where they are able to launder their proceeds, there's 50% more harm into the community from that. So it's reinvesting in further harm as well. So.
Thank you for that. When was Trench 1 of the anti-money laundering and counter-terrorism financing, when was that regime introduced? And why was it called Trench 1?
Thank you, Senator. So it was introduced in 2006. I think it was called Tranche 1 because there was an expectation that Tranche 2 would follow shortly after.
Sorry, you said 2006, and the second one was going to be introduced shortly afterwards.
That's right, Senator. So the Tranche 2 entities that would be covered, so the first tranche covered the financial sector, financial services sector. The second tranche of entities that we've spoken about at length at the hearing last week was around real estate accountants, lawyers, precious metal dealers, gold bullion dealers.
So for roughly, 12 years, there was no action on this until last year?
Senator, I don't think I'd characterise the last 20-odd years as no action on this. I think the department's been working on and off on this for probably about that length of time.
So the Financial Action Task Force, or the Global Financing Watchdog, conducted a mutual evaluation of Australia in 2015. Is that correct? And what was the outcome?
Yeah, thank you, Senator. They did conduct a review in 2015. The outcome was that we went into enhanced follow-up, which means that we had a range of areas that we needed to improve money laundering legislation in relation to the FATF recommendations. The bill that is before the committee for consideration is one that seeks to address a range of those, not only the Tranche 2 entities and bringing them into the regime, but it also deals with virtual asset and currency. So a couple of others.
Yeah, a couple of other technical amendments, but that's the bulk of it.
So seeking to bring Australia more in line in response to those, in response to the review, noting that we'll be due for a review again shortly towards the end of 2026 will be Australia's next mutual evaluation. One of the things that I mentioned in the committee hearing previously, but I'll just mention again, is that it continues to ramp up. So there's an expectation from the FATF each time. We're about to go into the 5th round, so the expectations are higher than what those were in the 4th round. They continue to revise the standards and enhance the recommendations to try and continue to combat money laundering and provide stronger frameworks across the globe.
So how many other countries in the world are currently non-compliant with AFTA standard in relation to regulating Tranche 2 entities?
Unfortunately, Senator, we're in a reasonably small cohort of zero when it comes to countries that are completely not compliant with regulating tranche 2 entities. The FATF recently did what's called a horizontal review looking at compliance with tranche 2. Australia ranked right down the bottom. The average across the globe was 74% compliance with those recommendations, so we're a fair way off that.
So it's pretty embarrassing then that nothing really has happened since 2015, when we understand that money laundering is actually having a real impact on our economy and Australians. So why was there no action?
I don't think I can comment on why there was no action. Ultimately, it's a matter for governments about whether they introduce legislation. I'm not sure I can comment.
So in terms of money laundering, I mean, it's a bit like cybercrime. There's no borders there. But don't we have a responsibility as a nation to ensure that we protect Australians, but we also play our role internationally?
I think the point, again, I feel like I'm repeating a bit of evidence I gave on Wednesday, but I think the point that I made at the committee is that other countries look to us to uphold these standards. We're one of the founding members of the Financial Action Task Force, so we set the global standards, we impose those standards and judge other countries on those standards, not only through the 40-member FATF, but also the FATF regional style bodies, which we're a member of the Asia Pacific Group on Money Laundering, where we judge the Pacific region on their compliance. And so I think it's important that we uphold those standards, or seek to uphold those standards as best we can as well.
So would it be a fair assessment, before the Chair closes me down, would it be a fair assessment to say, though, seriously, that Australia would have been seen and is being seen as an easy place to launder money? We're attractive in terms of organised crime, child abuse, because we failed to take any action over the last, 9-10 years.
I'm not sure that's how I'd characterise it, Senator. I would characterise it as there are gaps in our regime, and we can certainly harden our environment to stop exploitation from serious and organised criminals.
Sounds like a diplomatic answer. I think my assessment is a more accurate one, but thank you very much, Chair.
Thank you, Senator Polly. Senator Cash, we're coming back to you. Oh, sorry. Senator Chandler.
Thank you, Chair. I just have a couple of questions about the IRGC listing that I know I've spoken to officials about at previous estimates. Is the Attorney-General's Department aware of any change to the Australian Government position on the listing of the IRGC, which was articulated in the September 2023 Government response to the Senate inquiry report, in which it is explained that the Government's position is that it does not accept the recommendation to enable a listing of the IRGC because the AGD advises that the IRGC cannot be listed under current legislation?
That response hasn't changed.
Thank you, Ms Chidgey. Was it ever put to the Attorney-General's Department informing this position, or subsequently, that the IRGC should not be listed as a terrorist organisation because it is not in the national interest?
No.
Thank you, Ms Chidgey. Is it still the case, as it was when I asked at previous estimates, that the department has not done any further work to develop options to enable a listing of the IRGC?
Senator, we haven't been working on listing that organisation. I think the evidence I've given previously at estimates has explained that issues with covering state entities under our current criminal terrorism provisions.
Indeed. I just wanted to confirm that since our last estimates, no further work or no work had been done, that this was still the case. Has it ever been put to the Attorney-General's Department, either by the Attorney-General's Office or any other part of government, that the department should not develop options to enable a listing of the IRGC?
No one's given us a direction not to.
Thank you, Ms Chidgey. As the department which had responsibility for making the determination that the IRGC couldn't be listed as a terrorist organisation, and given that this has formed the entire basis of the government's rationale for not listing the IRGC as a terrorist organisation from its formal response to the committee recommendation. Do you have any awareness of how a member of the government could have formed the view that the reason the IRGC hasn't been listed as a terrorist organisation is because the government is seeking to manage diplomatic relations with Iran?
No, Senator, I have nothing to say about that. The only thing I would say, however, and it's a matter for the Department of Foreign Affairs and Trade, but the government has used all its available tools to ensure the IRGC faces consequences for its conduct, and that includes sanctioning 200 Iran-linked individuals and entities across multiple sanctions frameworks, and that includes almost 100 IRGC-linked individuals and entities.
Mm-hmm. When you say it's a matter for the Department of Foreign Affairs and Trade, could you be a little more specific in terms of what you mean by that?
That department is responsible for the sanctions regimes.
Sure, but okay, so in your view, the Department of Foreign Affairs and Trade is responsible for the sanctions regime, but would you say that the Department of Foreign Affairs and Trade is responsible for all elements of managing that relationship with Iran? Sorry, these might seem like really simple questions, and they probably are, but I just want to be very clear about what the department's view is.
I'm not sure what I'd say about that. I think I would just say, I mean, that department's obviously responsible for foreign affairs and is responsible for those sanctions measures. So if you wanted further detail on that, obviously
Sure.
the Department of Foreign Affairs could assist, but it's not that no action has been taken against the IRGC.
Yes.
In fact, significant action has been taken by the government.
I'm sure we'll hear about that on Thursday, but just so I'm very clear, the Attorney-General's Department hasn't done anything within your remit to allow for a listing to occur, for example, a proposal to amend legislation?
No, Senator.
Okay, thank you very much. That's all from me, Chair.
Thanks, Senator Chandler. Senator Cash, we'll come back to you for this.
No,
block of
I'm happy that we
coalition
can
senators.
move on to the next section if that assists.
I think that's very good news. That is all the questions we have for the national... Oh, sorry, can I just check? Senator Thorpe, did you have questions for National Security and Criminal Justice Group? Apologies, I've almost skipped over you again.
That's okay, and thanks for bearing with me. So this includes ICJ.
Secretary?
No, not ICJ.
Not ICJ.
That would be the next group? Yep.
Okay. No problem then.
Okay, so you're happy to move on as well then? Yep.
Yes.
Okay, thanks, Senator Thorpe. Well, that means that we are dismissing officials from the National Security and Criminal Justice Group. Thank you very much. We'll now invite officials from the Integrity and International Group and ask as many questions as we can before dinner. I suspect we'll get a large... Okay. Sorry? Yeah, we're on to integrity.
Class actions? Yep, brilliant.
I'll come to you after Cash, and I know Larissa's coming in as well. Of course. Go for it. Okay, I think we can start. Senator Cash, if you have questions. Oh, Senator Scarr.
Secretary, I'd like to ask some questions about some really disturbing international developments in relation to the funding of class action litigation.
Senator Anthony, we've restarted. Yeah.
So in particular, In March 28, Bloomberg Law published an article exposing an investment firm established by Russian billionaires that's funded lawsuits globally from litigation funders. Has the department looked at this trend? And I'm going to provide another few quotes, in particular from the US Department of Justice Foreign Agents Registration Act team in relation to concerns, certainly in some overseas jurisdictions, in relation to sovereign wealth funds, other actors, I referred to Russian actors, potentially investing in litigation funding organisations, and those funding groups then funding civil litigation in jurisdictions which have certainly raised concerns, substantial concerns by, for example, the US Department of Justice.
Senator, I'll just check, but in terms of the specifics, I would need to take it on notice and check whether there's information held in the department. In terms of the issue, I know that there was an article in The Australian yesterday that caught my interest, that referenced broadly this topic, that prompted me to want to explore that further and have a look at the report that was mentioned in the article, which I will be doing. But I'm not aware that we've received any particular information from our colleagues in the Department of Justice, although we do work closely with them on a range of issues. So I think that the answer is I'd need to check whether there's any further information held. I'm looking at Mr Newnham, and I don't think that he's got anything just yet, but we can take it on notice.
If I can just to give you an opportunity to reflect and maybe to get information from anyone else in the department who might be watching, there was an example given in a report produced by the US Department of Justice Foreign Agents Registration Act team, which specifically cited sovereign wealth funds and foreign litigation funding as areas of concern for the Department of Justice. And I'll just give you a quote from this that might assist people watching this and might assist you to get some information at the table. Chief Turgeon explained that the unit's focus is on sovereign wealth funds that serve as the alter egos of foreign governments and thus engage in activities that directly promote foreign governments' interests. Department of Justice is actively looking at sovereign wealth funds to determine whether they engaged in registrable conduct. Chief Turgeon declined to identify a regional focus. The key question for Department of Justice is whether a sovereign wealth fund's activities serve a true commercial purpose or if they merely advance policy-related interests. Such scrutiny is not entirely new, but it publicly affirms Department of Justice's interests in sovereign wealth funds and indicates its potential scepticism when evaluating their activities that have an effect on the United States. So, end quote. So there's this real issue in the context of the rise and rise of class action litigation in conjunction with litigation support funds, which are established for commercial reasons, as to whether or not the international context is indicating that foreign governments, through sovereign wealth funds or other actors, are engaging with those class action litigation funders to actually promote the interests of overseas actors. So that's the issue which has emerged. Disturbing reports coming out of a number of jurisdictions in that regard. So very keen to hear if it's on the radar of the department, what work's being done to monitor the issue and any other update you can provide.
So, Senator, we'll take that on notice to explore further. I also note that we're engaged with relevant agencies through the Foreign Interference Task Force that is in Home Affairs but has a range of intelligence agencies associated with that. So I will look to engage with the Foreign Interference Task Force to see whether that is something that's been considered in that context, as well as check within the organisation if there's been any work. I don't believe we've received we've had any engagement directly with the US Department of Justice on this issue, but I'd like to check that and come back to you.
Mr Newman, do you have anything else to add before I ask a few more questions on that?
Senator Simon Newnham, Deputy Secretary, Integrity International Group. I'd very much agree with the comments so far from the Secretary. I would note the Foreign Influence Transparency Scheme is what we are responsible for, but I would note that sits alongside other resilience frameworks, and I particularly, based on, I've listened very carefully to your readouts. I've noted, of course, some of the media reporting about that. But I think, based on the contours of what you've described today, it would be prudent for us to take that on notice, noting that there may well be other resilience frameworks across the system that are enlivened by the sorts of things that you've raised today.
And Mr Newnham, I'm asking these questions in a context where, and tell me if I'm incorrect in this, where class action litigation funders aren't subject to any particular regulatory regime at the moment. They no longer need an Australian financial services licence. So that means there's less transparency, there's less disclosure around who they are, who owns them, who's behind them. Can you understand why, especially given the report, an example of a report I just read out, why that again puts the focus on what's the appropriate regulatory regime with respect to class action litigation funders?
Yep. So the group that's just gone are the ones where we have a responsibility for class action, the policy associated with class actions. But what I would like to do is, take this issue on notice and come back to you with any further information, as well as I think looking at whether or not this has come to the attention of the Foreign Interference Task Force and the Department of Justice information.
Okay. All right. Thank you.
Thanks, Senator Scarr. Now, we've got a lot of guests.
Cast of thousands.
We've got a lot of guests, so we're going to try to get through everyone quickly, or as quick as possible. But Senator Lambie, you've been patiently waiting, so we're going to give you the call, and then we'll come to our colleagues.
Thank you. I just want to go into the Inspector General of the Australian Defence Forces report and the Royal Commission and the bungle that went on there, because I'd like some answers. Can you tell me what was the employment arrangements for the Secretary of the Royal Commission, in the veteran suicide once the final report was completed? Were they employed under the Attorney General's department?
Senator, have staff here, the staff of a Royal Commission are employed by the department, though obviously operate separately, independent and supporting the Royal Commission. But I'll ask Ms Haig or Ms Swinburne to assist with more detail on that.
No, that's okay. I just wanted to know, so they are employed by the Attorney General?
The Attorney General's department.
Okay, and what happened once the final report was completed? Where are those people now? Are they still working? They moved around? What is the go here? Does it just stop? What's the go?
There's a process of winding down following the conclusion of a Royal Commission, where we retain a core of staff to assist in issues associated with ensuring record keeping and administrative issues are dealt with. I believe as of the 18th of October, that was the end date for the staff associated with the Royal Commission, and they are no longer engaged for that purpose.
Okay, so so they take all their directions from the Attorney General's office, whether that's from the Attorney himself or through advisors? Is that how it works?
No, Senator. They operate separately, and whilst they're formally employed by the Attorney General's department, they're independent of the department, and their role is to support the Royal Commissioners and the Royal Commission.
So So who does the secretary, who does the official secretary to the Royal Commission, who do they take directions from?
It is a slightly unusual situation because they are employed by the Attorney General's Department, and so they are an SES officer who is formally employed under the department, but in terms of their role through the duration of the Royal Commission, they work to support the Royal Commissioners in their terms of reference.
Okay, so on the 18th of December 2024, we had a bit of a dilemma. So just to quickly run through that, thanks to Senator Shoebridge at the time, he was able to locate something, you know what I'm talking about, and then it was taken down. So the wish, it was a requirement. There's only one way that got up there, and that would have been the requirement of those Royal Commissioners would have asked for that to be tabled so the public could see it. So we want to know who authorised the takedown of that IGADF, of the report that was done on them by Justice Duncan Kerr. Who authorised that and who ordered that to be removed?
I think Ms Haig will be able to give the detail on that, Senator.
Thank you, Senator. Catherine Haig, First Assistant Secretary, Legal Services and Modern Slavery Division. Senator, as you have referenced, yes, the IGADF 20-year report was inadvertently published on the Royal Commission website.
Sorry, inadvertently. Where did you get that information from? Could you show me where you got that information, where it was inadvertently? So yes. The Royal Commissioners said that, did they?
Senator, I understand that's what the official secretary of the Royal Commission said. There was
where did she get her info? I want to see the trail. This is what I mean, because I do not believe that the Royal Commissioners actually told you to take that down.
Senator, if I may, I can take you through a timeline which might help explain the sequence of events. So, as you're aware, the document was published on the Royal Commission website on the 23rd of August 2024. For context, that occurred along with the publication of approximately 400 other documents. Then sometime later, on the 17th of September, the Royal Commission staff, at the direction of the official secretary, asked for the document to be removed.
Oh, that's after we called them. We called them, you know that, don't we? Called them and alerted them that we'd found the document on them, and within 2 hours, this is the process that we went through. You do know that?
Yes.
Right, so as soon as I called them out, they pulled it down.
And we have been advised that the official secretary gave that direction because once she'd been made aware of the publication, she recognised that the publication was inconsistent with the policy of the Royal Commission.
No, that's not what it said on the original document. It said for publication.
To publish a report that was currently being considered by government, as the AGADF report was at that time.
But I think the Royal Commission made it very clear, not the one that you gave me, but the original one said for publication. That was removed off the document that came from your attorney's office. So why don't you explain that to me?
I don't think there was a document that came from the attorney's office.
No, Senator.
Well, somebody removed that for publication off it. I want to know why. I have the original one off there that said for publication, and when I got when I got the other one sent to me, that had been removed off the top.
Senator, I'm not sure if we're going to be able to take that further today, but I can take that on notice in relation to those two words.
So who approved the, if you can take that on notice because I want to know. Can you also, you gave out a statement. Who cleared that statement to go out? Because it wouldn't have been the secretary, someone had to clear it. So who cleared that statement to go out within the attorney's office?
Senator, perhaps
she didn't do it off her own steam. She was given direction and she had to get that approved. Who approved it?
Senator Emma Swinburne, Royal Commission's Branch Assistant Secretary. My understanding is the official secretary authorised that statement. She indicated to the department that it should be published on the Royal Commission's website.
The statement that was released?
On the 18th of September, that's right, Senator.
Yeah, the statement that said the Royal Commission inadvertently included the redacted version of the IGADF report. I'm talking about that release that you put out.
That's right.
And that came from her, solely from her?
Yes, that's my understanding, Senator.
Wow. So there was no consultation done with the Australian Government solicitors when deciding to remove the IGADF report from the Royal Commission website?
No, Senator.
So nobody asked for any legal opinion about that? The Secretary just decided in her goodwill, I'm going to remove that right now after I'd called her 2 hours beforehand. Is that what you're telling me? There was no discussion with anyone, she just did that? Because I actually don't believe that.
Senator, the official secretary spoke to the Royal Commission's branch of this department and informed us that she'd been made aware that the report had been published.
The Royal Commission branch, and that would have been?
Of the Attorney General's Department.
That was me, Senator.
And how many people are in that branch?
At the moment, just me, Senator.
And who was there on that date, on the 18th?
Me.
Sorry, was
the
it
official secretary spoke to me, Senator, and told me that she had become aware that the report was on the Royal Commission's website and that she had arranged for it to be removed.
Do you think by removing that and trying to hide documents would have brought more moral injury? Did you actually consider, instead of worrying about covering the backside of the government, what it was actually doing to those veterans out there? Did you take their health and well-being into account? Did you take that into account?
Senator, the decision was taken by the official secretary, not by Ms Swinburne or anyone in the department.
I'm asking you whether that was taken into account, the health and wellbeing of veterans that have been out there, have sold their souls, gone out there, said it how it is, told everything without any backup now. There's no help for them there now, by the way, so that's more moral injury that's been done. This has been done very poorly, the pull out of it. Okay, you've set up no system out there. You've set out no system. As soon as that Royal Commission stopped, they can't see psychologists, they can't see psychiatrists or anything. There's been putting nothing in there after they've relived their experiences. You've hung them out to dry. And in the meantime, you try and remove something that should have been left out there as a public document, because quite frankly, the terms of reference had a little bit into it. Do you understand what that is doing to veterans out there by you doing that? Did you not hear through the Royal Commission that a lot of this cover-up was part of the reason they were taking their lives and that? Did you take their health and well-being into consideration when she made that, when she decided to do that?
So, Senator, I just repeat, the decision was taken independently by the official secretary, and the colleagues here at the table didn't.
Okay, can I get an answer to that? Whether or not they took into consideration the health and well-being of veterans? That's the only question. I think that's a fair call.
Senator, apart from what is contained in the statement of the official secretary, we're unable to take it any further as to what was in her mind when she made the decision that the document ought to be removed from the Royal Commission website.
So when she notified the next person and said, I'm going to do this, did anybody ask her any questions? Who was involved in it?
I think it was just a matter that she advised us that's what she was doing, Senator.
Jesus. Did anyone bother to suggest, because of the health and wellbeing, that she probably shouldn't do that?
That was a decision for the official secretary.
Does she regret that decision now, and that it's brought more harm to veterans? Does she intend to come out and apologise for that rash decision she made? When we'd already copied it, chucked it out there to everyone? That she still thinks she can cover that by removing it? What sort of stupidity is that? Let alone the harm it's caused. No? No answers? Wow. Okay. How many documents did the Royal Commission into Defence and Veterans Suicide receive?
Senator, I'll have to take that on notice.
Okay. I want to know how many documents, after those you received them, I want to know how many documents had actually been published on the Royal Commission out of all the ones you received onto the website, and whether or not there's other documents that have been placed up there that were published and then you decided to delete them from the website during the period, and for what reason you decided to remove those documents.
Senator, I just reiterate that the decisions were taken by the official secretary to the Royal Commission, not by the officers that are sitting here at the table.
And that, Senator Lambie, the reason that the officials can't provide answers to a number of these questions is that the Royal Commission operates completely independently of the government, whether that be ministers or departments. So decisions were made by the official secretary, the management of documents is done by the Royal Commission. They're completely separate to government, and that's important that they operate independently and not be directed by government about what to do.
So who gives the secretary the okay to overrule what the commissioners have put up there and say, I'm pulling that down? Why does she get a higher call than those Royal Commissioners? Were they consulted about this on whether or not they should remove it?
I can't answer that,
Jesus.
Senator.
Okay. No worries, I'm done with that, thanks. I'm done with that. Thank you.
Thanks, Senator Lambie. Senator Waters?
Thanks very much, Chair. Hello again, folks. I have questions about the use of non-disclosure agreements in sexual assault and sexual harassment cases against the Commonwealth. Thank you. So firstly, what is the current policy of the government on using non-disclosure agreements in claims against the Commonwealth involving workplace sexual assault or sexual harassment?
Thank you, Senator. The general policy is provided for in paragraph 4.5 of the Legal Services Directions that transparency in Commonwealth settlements is the default approach, and confidentiality ought only be sought where that is necessary to protect the Commonwealth's interests. Now, in particular, in relation to workplace sexual assault or sexual harassment claim, the government's approach is generally not to seek confidentiality in relation to settlements of such matters, and importantly, only to agree to confidentiality where this has been requested by the claimant. And Senator, you'll appreciate this approach is consistent with the guidelines in the in recommendation 38 of the Respect at Work report.
Yes, thank you. So there's a lot of caveats in that. There's a general this and except where it's in the interest of the Commonwealth that. So can you give me some figures, please, on how many times the Commonwealth has used a non-disclosure agreement?
Yeah. My colleague, Mr Johnson, has some data he can share.
Thanks.
Thank you, Senator. Michael Johnson, Assistant Secretary, Office of Legal Services Coordination. And I have that data for you, and I'll just precede it with just an explanation that the role of this department is, amongst other things, to administer the legal services directions, under which agencies are responsible for managing their own legal matters. A certain category of legal matters, which are called significant issues, are required to be reported to this department. And for any settlement of those matters that are significant issues, they can't be settled except with the approval of the Attorney-General. The reason for that introduction is we have visibility of settlements of those matters only. There may be other matters that aren't reported as significant issues.
Are they a particular type of matter that the
so they're supposed to cover the most significant matters. So I would expect a very large proportion of claims that are about workplace sexual harassment and sexual assault managed by a Commonwealth entity would constitute a significant issue. I wouldn't be able to say it's 100%, but certainly I would expect a significant
let's
proportion.
Assume they're in scope.
Yep, so of that category, and I've got figures which date back to 1st of June 2022, and a current
Okay.
as at 28 October, so a couple of days ago, and I don't
Great.
think there has been any more since then. There have been the approval of settlement terms, so this is not the actual settlement, these are the terms we approve that then authorise the entity to go and settle. There have been approval of 6 matters to be settled that could be categorised as a claim of workplace sexual harassment or workplace sexual assault managed by a Commonwealth entity, 6 matters. Of those, 2 matters, 2 of the 6 included a condition that the Commonwealth was not to seek confidentiality but could agree to it if it was requested by the claimant. Then there were 3 matters in which the Commonwealth was approved to seek confidentiality only in respect of the sum of money and were prevented from seeking confidentiality on any other aspect, including the fact of the settlement and any of the details of the claim, again, unless the claimant sought for that confidentiality. And then 1 matter in which there was no provision in the approval and which allowed the entity itself to make its own assessment of what is appropriate.
And was an NDA used in that final instance?
In the matter itself, the one in which it was silent,
Yes.
my information is that that matter has not settled.
Oh, okay. Unresolved as so. Okay. Thank you for that. So you've got... there's a variety of approaches there, and I'm not sure I would consider that to be reflective of your legal services direction that you should not use them except in, you know, particular circumstances. Can I ask you on notice, please, to go back a little further in your timeframes and provide me, I don't know what a reasonable timeframe could be, but if it's not impossible to pull together the last 10 years, I think that would give a really good picture of trends.
We can certainly take that on notice. I do have some figures going further back, but for matters generally, they're not for only workplace sexual
I'm
harassment.
particularly interested in the workplace sexual harassment and assault issues. So, yeah, thank you for
Certainly, we'll
pulling
do our best.
together what you can.
I'll say there are challenges in that because that does involve manual checking of documents involved, but we'll take it on notice and do our best.
Thank you.
Senator.
I appreciate that. I think it's important that those guidelines are given effect to. There's that proviso in the guidelines, except where necessary to protect the Commonwealth's interest. Who gets to make the decision about what's in the Commonwealth's interest?
Certainly, Senator. Again, I'll begin with the distinction between significant issues and other matters. So for significant issues, the entity is not allowed to settle it without approval of the Attorney-General or the Attorney-General's delegate. And so in that instance, it will be the Attorney-General or the Attorney-General's delegate. And of the ones I went through, the only ones that included any provision for any type of confidentiality was only in respect of the sum, the dollar figure. And they were all, the rationale for each of those was because the claim was part of a cohort, so there were other claims that were very similar, and to protect the Commonwealth's interest in being able to manage the other matters fairly and equitably and not to have expectations raised about what the particular dollar figure is, because the appropriate dollar figure changes from claim to claim, even when actions are very similar, because about the very specific effects on the person and injuries and medical expenses and things like that. The sum was kept confidential to better enable the Commonwealth to manage the other claims in the cohort. So that was the reason.
Yes, I understand. You want to save yourself money.
It was not to save money, to make sure the matters are managed properly. And to allow for an appropriate resolution of the claims. And so that's the sole reason that there was any confidentiality imposed on any of the 6 that I referenced.
Thank you. So just sticking with that, when it's in the Commonwealth's interest and the AG or the delegate gets to determine that, in making that decision, is there any application of trauma-informed training or decision-making influence? It's obviously a very significant decision, and it has a great impact on survivors of sexual assault and sexual harassment. And it's important that it's not just the Commonwealth's financial interests that are, in my view, decided and prioritised in that decision. Actually, the quality of life and the needs of the survivor need to be front of mind, I think.
Absolutely.
And so I'd like to know what guidance the attorney has in determining the Commonwealth's interest, and is there any rule, and if there's not, there should be, that says the attorney actually has to take into account the well-being of the survivor?
Certainly, Senator. And So our approach is absolutely to take a trauma-informed and a victim first approach in how these matters are managed. Like I said, it's always the responsibility of the entity managing the matter, but when it comes to us to consider and approve settlement terms, the interests of the claimant, the victim, and a trauma-informed approach is very front of mind. We comply with the guidelines that came out of the Respect at Work report, and that informs why in these 6 matters, it's a small sample size, but in these 6 matters, there were 2 matters in which there was no confidentiality whatsoever. So to make sure that unless the claimant wanted otherwise, the claimant was free to tell their story and free to reference every single part of the settlement. In the 3 in which it was only the settlement sum, every other aspect of the settlement was not.
Yes, thank you. You did run me through that, and I'm sorry to interrupt, but time's limited. I appreciate your assertion that you take a trauma-informed approach, but I'd like to see some evidence of that. I'd like you, if you could on notice, please provide me with where that's written in what document that guides whom, so I can have a bit more confidence that rather than that just being your personal approach, which is the appropriate one, that is in fact an approach that's adopted by everyone involved, including the attorney when they're making the decision about whether it's in the Commonwealth's interest to insist on the use of a non-disclosure agreement, whether that be for the sum or for the broad settlement terms.
Certainly, Senator. And the relevant document is the guidance that we referenced, the guidelines on the use of confidentiality clauses and the resolution of workplace sexual harassment complaints. And we refer to that and we utilise that in our decision making.
And in your view, do you at all times comply with that guideline? Are there instances that you're aware of where you've, fudged it a bit?
I'm confident that any decision that I've made personally, Senator, and any recommendation I've put to the Attorney-General, Senator, in respect to the confidentiality aspect, that we have complied with those guidelines, yes.
And what would the status of those guidelines? They're just guidelines, right? They're not actually binding, so you could in fact ignore them if you wished. How do we fix that?
That is correct, but it is our policy and it's the Attorney-General's policy that we do comply with those guidelines in the management of settlements of matters that fall into this category.
Would they bind a future administration?
No.
Have you thought about trying to make that binding while you still can?
It would be a matter for government.
It would indeed. Not sure the minister's paying particular attention. I'm sure he's got important work to do. I'll take that up separately then. In the very brief time I've got left, quickly on positive duty, there was a really...
Are you unhappy with... Did you want to ask me something?
No, I'll take it up with the attorney.
Okay.
And there was a report released earlier in the year that had surveyed, and it's not a scientific survey, but they'd surveyed 300 large workplaces, and they found that 60% of them had implemented clear policies on sexual harassment, so 40% had not. And 1/3 of them had no plans to implement sexual harassment training or reporting pathways. So I'm interested in what the government has done since the positive duty that came into effect. What's the government done to raise awareness with employers about their obligations under the positive duty?
Thanks, Senator. Anne Sheehan, First Assistant Secretary, International Law and Human Rights Division. As you're aware, the positive duty provisions and the Human Rights Commission's enforcement and compliance functions commenced in December last year. They were provided with a 12-month delayed commencement arrangement to allow them to provide guidance material and training for employers. They'll be able to speak in more detail to that later tonight when the Human Rights Commission is here. They were provided with $5.8 million in the 22-23 budget to be able to educate employers about the positive duty by issuing guidance. They have developed a range of guidance material on the positive duty, which is published on their website in August last year. I'm aware they have been conducting a range of education materials and campaigns, and I don't have the details of all of that, but the Commission will be able to speak to that in more detail when they're here tonight.
Thank you. So is the government, sorry, and I will wrap up, Chair, is the government doing anything beyond tasking the Human Rights Commission to do that work? Is there any responsibility that actually the government is taking on to raise awareness of those rules and to make sure that there's compliance with them?
In relation to the positive duty, the regulatory function sits with the Human Rights Commission, so they are primarily responsible for promoting and providing education on those obligations.
Okay. Well, I think the decision was taken that the Human Rights Commission would be funded to do that education piece.
Yes, clearly it was taken, and $5.8 million was allocated for that function. I understand that. It just seems like the anecdotal evidence is perhaps it's not enough. Perhaps people aren't accessing that material. I'm sure the material is of high quality, but does the government at any point, are you going to do a check on the level of awareness amongst employers and, you know, check whether your $5.8 million is in fact achieving the outcome that you wanted it to, and then maybe think about other options if it's not? Or is it a set and forget?
In terms of the funding, I should have mentioned that there's also $1.8 million per year ongoing funding that's provided. In terms of awareness by employers, I think that's something that the Sex Discrimination Commissioner could speak to in terms of her regulatory activities and levels of awareness that she is seeing in the industry.
Okay, but my question was to you, is the government going to consider whether it's an adequate awareness raising task or whether there's something at some point you want to step back in and elevate that?
So I think what I would say is we would always keep under review whether or not the information campaign and materials that have been prepared and disseminated by the Human Rights Commission were adequate. This is something, you know, we meet on a regular basis with the Australian Human Rights Commission, and we will continue to engage with them. You've obviously quoted some other data as well in terms of feedback on awareness, and that's the sort of thing that we'll continue to look at.
Okay, just for the record, and this is my last contribution, I'm not criticising the quality of work of the Human Rights Commission. I'm suggesting that perhaps employers might not be aware of it or not be taking that up, and I still think it's the government's job to make sure that people are aware of those new obligations.
Thanks.
So next time I'll come back to you on how much under review that is.
Thank you.
Thank you.
Senator
Thanks,
Waters. Senator Cash, we're coming back to you.
Thank you. I was directed this morning to ask questions in relation to the visas granted to Palestinians leaving Gaza in this section. So the first instance, Secretary, what is a significant legal issue?
Senator, I think we've discussed this at previous estimates, but in terms of the very specific definition that we have, I'll ask Mr Johnson to come to the table to assist.
Thank you, Senator. Apologies, I don't have the precise wording in front of me.
Not a problem at all, Mr Johnson.
Generally speaking, they're matters of legal matters, first and foremost, that are of whole of government significance that warrant reporting and visibility by the Attorney-General.
Okay. So can I just ask then, Secretary, when did the Significant Legal Issues Committee last consider the government's decision to issue approximately 3,000 visas to Palestinians leaving Hamas-controlled Gaza?
Senator, I'll ask Ms Haig to respond to that.
Thank you, Ms Haig.
Thank you, Secretary. Senator, we have checked our records, and this has not been a topic that has been considered by the Significant Legal Issues Committee.
Can I ask then, Secretary, who determines whether or not this is a matter is a significant legal issue?
So it's a matter of self-reporting, but also that the department may consider that an issue should be categorised as a significant legal issue. I'll ask Ms Haig to expand on that.
Senator, as my colleague Mr Johnson was explaining, a significant legal issue is described in paragraph 3.1 of the directions as a matter that a certain type of Commonwealth entity was required to report on as soon as possible to the Attorney-General or AUSC that arises in the provision of legal services, especially in the handling of claims and conducting litigation. So given that definition, I think there's an issue as to what you're describing is actually captured by paragraph 3.1. But of course, as the department with policy responsibility for the issue, that would be a matter for Home Affairs.
So just confirming then, the lack of consideration by the Significant Legal Issues Committee shows that neither the Home Affairs Minister, which is now Minister Burke, nor the Attorney General, Mr Dreyfus, think that this is a significant legal issue. Is that correct?
Senator, I would not be able to comment on that. What I can tell you, Senator, is that this issue has not been on the agenda of the SLIC, and in the broad way you've described the issue, it has not also been reported by Home Affairs to either to AUSC as a significant legal issue under paragraph 3.1.
Okay. So can I just ask, you are aware that the government has granted nearly 3,000 tourist visas to Palestinians leaving the Hamas-controlled territory of Gaza?
That's a matter that's within the responsibility of the Department of Home Affairs.
No, I understand that, but I'm asking you, are you aware of that?
Only in very general terms, Senator.
Okay. So on the 8th of August, I just want to explore why this is not considered by the Attorney-General in particular, a significant legal issue. So on the 8th of August, Minister Burke said the following: well, certainly no country in the world would send people back to Gaza at the moment. We have to work through what happens as the visas that people are currently on expire, but it's not a decision that has been made and there's no announcement to make at the moment. So given the Minister's comments, there would appear that there's no real prospect a person could be returned to Gaza in the reasonably foreseeable future. So on that basis, the legal issues that arise are what happens if the temporary visas expire or the visas are cancelled onshore on security or character grounds, similar to NZYQ. What planning is the Attorney-General's Department doing to deal with that contingency in terms of the nature of the legal issues that may arise?
So that is very much a responsibility of the Department of Home Affairs. They have their own legal area, and I would expect that any consideration of that issue is being done by the Department of Home Affairs.
But given what occurred with the NZYQ cohort, and we've talked about that previously, and obviously Senator Patterson has pursued that in detail in a separate portfolio, is the department not concerned that you could end up in a similar situation?
I just reiterate that's a key responsibility of the Department of Home Affairs. We work with them as required, but that is a matter for the Home Affairs Department.
From the Attorney-General's perspective...
We had a bit of a discussion about this yesterday as well, Senator Cash. I think Senator Patterson was there for it. One factual issue is that what was the date of the comments that you cited from Minister Burke?
They were on August the 8th of this year.
So just one factual point. I've forgotten the exact number, but there are now some of that cohort of people who were granted tourist visas who have now been granted a longer-term visa. I've forgotten the name of that visa, but it's essentially a 3-year visa, very similar to the process that it was adopted for Ukrainian people when they came here. So I guess the point I'm making is that there are some people who were reaching the expiry of their tourist visa, and a solution, if albeit temporary, has been put in place for those people, and I'd expect there may be more apply for and receive those longer-term visas as time goes on.
Okay. Secretary, we've previously discussed the NZYQ NZYQ case, did you consider that to be a significant legal issue?
I'll just I'll ask my colleagues because I believe it was reported as a significant legal issue.
Exactly, yes. So could you just, whoever that, Mr Johnson, please.
Senator, I can assist. Yes, certainly the department regarded that as a significant legal issue, and Home Affairs reported that matter to us as such.
So the issue that arises is, unless you grant every single one of the 3,000 applicants a longer term visa, you've set things up for an NZYQ cohort all over again, and that's the concern that I have. If any of these individuals have their visas cancelled, you can't let them stay, but you also can't foreseeably send them back to Gaza, which means that based on the NZYQ precedent, they can't be held in immigration detention. Can I ask, Secretary, were you consulted at any point on the potential legal ramifications of granting these visas?
Senator, I'd probably need to take that on notice. It's possible that some people in the department might have been involved in IDCs or other meetings that the Department of Home Affairs convenes. But I reiterate that this is a core Home Affairs responsibility.
No, I understand that, but this is also the Attorney General's department. The Attorney General's department is where the Significant Legals Issue Committee, or the office looking after this, lies. Do you do any proactive work in relation to identifying significant legal issues, and in particular, where you've already had a precedent set in a particular case?
Senator, as the Secretary said, we have regular engagement with Home Affairs between their legal team and AUSC.
I would just add, though, I'm not sure I accept the premise around it being a precedent, the NZYQ being a precedent for this other category, but the decision-making around those visas is very much a matter for Home Affairs.
I understand all of that. But the NZYQ case was considered to be a significant legal issue, and there were obviously ramifications of the decision that was made by the court. You now have a case here where nearly 3,000 visas, tourist visas, have been granted to Palestinians leaving the Hamas-controlled territory of Gaza. At this point in time, and in particular based on the comments made by Minister Burke, if those visas do expire, they will be unable to be returned. So what I'm asking again is, has there been any legal contingency planning done at all, or is it literally a situation where we just hope that these people do nothing wrong?
Senator, you'd have to direct those questions to the Department of Home Affairs. They have responsibility for those matters. They have their own legal division that would be working through those considerations.
Again, though, this is the Attorney General's department. I completely understand that. That is where the matter sits. I understand that. The point is, though, the Attorney General is the first law officer. The Attorney General, Mr Dreyfus, is responsible for significant legal issues. If you actually look at comments made in the Robo-debt Royal Commission, they made a very clear recommendation in 19.8, and they said, the title of the recommendation is the Office of Legal Services Coordination, which I'm assuming is this office. Yes. That is correct. To assist agencies with significant issues reporting. So again, this is not solely a Home Affairs problem. Yes, the matter may well sit with Home Affairs, but again, I go back to NZYQ was considered to be a significant legal issue. Similar circumstances arise in this case. So I'm again to, have you done any legal contingency planning at all, given that nearly 3,000 tourist visas have been granted?
Senator, I just repeat that in terms of the decision-making around visas and the management of that, it's Home Affairs. The NZYQ was a matter that was before the High Court. I think it attracted much more of the criteria that would bring it before the Significant Legal Issues Committee. In terms of decision-making around visas, that is very much in the Department of Home Affairs responsibility.
No, again, I understand that.
Senator Cash, if you've got one more question, but you seem to be asking the same
what
one.
I'm hearing, though, is there's no forward-leaning by the Attorney-General's Department. There doesn't appear to be any interest in significant legal issues in any other portfolios unless it is brought to this department's attention. And I would have thought that given what occurred with NZYQ, the fact that you've stated that it is a significant legal issue, this would almost be a no-brainer that this is a significant legal issue. So again, has the Attorney-General raised this in any regards, that there may be significant legal issues to look at in the event that these visas expire?
Not that I'm personally aware of, but as I said, I think it's still very much in the remit of the Minister for Home Affairs and the Department of Home Affairs.
Thanks, Senator Cash. Thank you, Secretary Jones. Senator Payman, you have the call. You still there? Yep.
Okay, my questions relate to the amendments to the Fair Work Registered Organisations Act 2009 this year, which enabled the construction and general division of the CFMEU to be put into administration on 23rd of August this year. I'll wait for the officials.
I'm not sure. We may be able to assist to some degree, but it's, I think, more a matter for when the Department of Employment and Workplace Relations appears at estimates tomorrow, but we'll just check if there's anything we can do to assist.
Yes, no, thank you. I received advice from the Attorney-General's Department that this line of questioning would be most appropriate directed to the Integrity and International Group, and some of the questions are to the Minister. So thank you for seeking that clarification. Minister, under the section 323HA of the Act, how many complaints has the Administrator received regarding the actions of members of the CFMEU?
Wait a second. Senator Payman, advice or not from an agency or an advisor, it's the committee that decides whether questions are relevant, and the questions that you're asking need to be relevant to this department and to the officials that are in front of us. And I don't understand, or I can't see how those questions could necessarily be relevant to Mr. Lewis and the work that he does. You'll need to clarify why these questions are relevant to this.
To the Attorney General's?
Yeah, to the Attorney General's Department.
Because it falls under the Integrity and International Group in terms of asking for an update on what's been happening in the administrator's role, which obviously has been in the purview of the Attorney General.
Well, no, Secretary, do you want to clarify, and we can go?
I'll just clarify that whilst the Attorney General was delegated some decision-making role on that, he was supported by the Department of Employment and Workplace Relations. The Attorney General's Department didn't provide that support to him, so any questions regarding that could be put to the Department of Employment and Workplace Relations tomorrow when they appear.
So the Act is not administered by this department?
No, Senator.
Okay. All right, well, we can pick this up tomorrow.
Yeah,
thank you.
We'll make sure you've got the right time tomorrow to ask those questions. Thank you, Senator Payman. Senator Barbara Pocock, thank you.
Thank you, Chair. And thanks, folks, for being here. My questions relate to Robo-debt. So I'm sure you're all very well aware the deep concerns that are out there in the community about the consequences of Robo-debt for hundreds of thousands of Australians, their families. Some people have lost their lives. Certainly the biggest public sector scandal and maladministration that I've seen in my working life, which is quite long these days. Very appalling events, and I'm conscious that the Robo-debt events occurred under a previous government, but clearly the response is occurring under the current government. So I want to ask about the Robo-debt Royal Commission and specifically the recommendations of the Commission for which the Attorney-General's Department is responsible. Could you walk me through which of those have been implemented and describe what's underway?
Thanks, Senator. Yes, we were responsible to, under the government response, to lead on a number of the recommendations. So I'll ask Ms Swinburne to talk to that, noting responsibility for implementation of those recommendations sits in a few areas in the department, but we should be able to bring it together for you.
Yes, Senator, I can give you an overview of recommendations and their overarching status, and if there's particular recommendations that you're interested in, we might find other officers to speak to that. But the Attorney-General's portfolio is leading or jointly leading or supporting implementation of 22 recommendations. 13 have been implemented and 9 are in progress.
9 are what? Sorry.
In progress.
In progress. Are any, how many are outstanding then? Any?
So of the 9, so 9 are in progress. So still outstanding. I can take you through which recommendations fall in each of those categories, if that would assist.
If you could talk me through, as briefly as you can, those that are implemented and those outstanding or in progress.
So the 13 that have been implemented are 12.4, 19.5, 19.9, 19.11, 19.12, 15.1, 15.2, 15.3, 15.4, 20.4, 21.3, 21.4 and 21.5. And the 9 in progress, would you like those two?
I think we should skip that.
Can you describe what the 9 in progress are?
Yes,
so
yes.
It's a bit more meaningful. Sure.
So the 9 in progress are 17.1 and 17.2, which our department are co-leading with the DISA, the acronym escapes me, the full name escapes me at the moment, and the DTA, and they relate to reform of legislation and implementation of regulation in relation to automated decision making. They're broadly in relation to automated decision making. Recommendations 19.7, 19.8 and 19.10 are all being led by this department and they relate to the work of the Office of Legal Services Coordination. Recommendation 20.5 is being led by this department, and that concerns reinstating the Administrative Review Council. And recommendations 20.1 and 20.2 are being co-led by this department and Treasury and relate to matters concerning the Ombudsman. And the final one is recommendation 23.4, which is being led by this department, and it relates to provision of training and resources for the Administrative Review Council.
Are any actions outstanding on the sealed section of the Royal Commission's report?
I think in relation to the sealed section, it remains under consideration by government.
Can you say a little more about what is the timeline there, or what's going to happen?
I can't really expand on that at this point, Senator. It's just under consideration by government, but I'll see if Mr Newnham wants to add anything to that.
Senator, all I could add is that decisions about that chapter and the timing of those decisions are matters for government.
So it's been reported that the Attorney General's been considering whether he can release the sealed chapter of the Robo-debt Royal Commission, and there have been media reports that the department is informing individuals named in the sealed section that it will be published soon. Is that the case? Is that an accurate report?
Senator, we're certainly aware of the media reporting. I can say that the government is considering these issues, but it would not be appropriate to comment on whether or not affected individuals have been notified in relation to the confidential chapter.
Recent developments at the NAC on this probably mean that any attempts by the Attorney-General to publish the names of those referred to civil and criminal authorities over Robo-debt will likely be delayed. Is that correct? Is that what we're looking at here? There's a delay because of those recent events that have been widely talked about in the press?
Senator, thank you. Obviously, we're highly aware of the recent inspector's report in relation to the NAC and the NAC's response to that. But I would not be able to comment on the impact of that process on government decision-making in the future on the Robo-debt sealed chapter.
Given the public interest in this, and we've had extensive questioning in other parts of estimates on this, and the lamentable response in terms of responsibility and accountability within areas of the public sector, there is real concern out there about how the public is able to see real action in response to such an appalling chapter in public administration. What is the likely time frame now on the release of that section, the sealed section?
Senator, we couldn't comment on the decision by government or the timing for the decision on government. What I could say is, aside from the specifics of this situation, in situations such as these, a number of factors may well be relevant for consideration by government. They include legal advice, parallel processes, the well-being of individuals involved, the privacy considerations that may well be in place, public interest considerations, the nature of the material. So there's a range of factors that decisions of these nature often need to take account of, but I cannot answer your question on specific timing.
Minister, how satisfactory is this, do you believe, given the public concern on this question of seeing action and understanding the full range of responses from government and wanting to see them implemented in a timely way?
Yeah, I very much understand the public's strong feelings about the whole Robo-debt issue. I recognise the work you've undertaken on it. There's a number of other senators, particularly Labor senators, who did a lot of work on this in opposition. As the officials have said, the government is giving consideration to whether to release the seal section, and if so, when. Obviously, it's a big decision, and it's being approached in a considered way. But we understand the level of public interest in this.
What is stopping the Attorney-General from publishing the sealed chapter?
I think maybe it might be best if I get the officials to outline, to the extent they can, some of the factors that would need to be taken into account.
I'll ask Mr Newnham, because I think he's already alluded to a few of the factors that need to be worked through, but I'll ask him to expand.
Yes, Senator, absolutely acknowledge the comments you've made and too by the Minister on the impacts on individuals here. What I can say is that in situations such as these, government may need to take into account a range of considerations, and they include, as I said earlier, other parallel processes, and you've mentioned, Senator, the inspector report and the NAC response to that, but so too the well-being of individuals involved, the legal advice, including risk to Commonwealth and compliance with legal services directions. I mentioned a moment ago privacy safeguards that may well be in place, public interest considerations, which you've very much underscored, the nature of the material, the timing, and indeed any confidentiality and restrictions on disclosure, but so too procedural fairness considerations may well be in play in these sorts of situations as well.
You know, it sounds like the script for Utopia, and if it wasn't so tragic, the consequences of what's happened here, it'd be funny.
Well,
because to be honest,
I don't think that's fair. I mean, this government,
timing, its nature of the material, procedural fairness.
That's not fair. I participated in inquiries, as did a number of my Labor colleagues, into this issue when we were in opposition. We pursued this issue over a number of years in opposition. We established the inquiry. We are acting on the recommendations. We are running a government that runs completely differently to the former government in terms of its treatment of individuals. I understand the interest in the seals section, but I don't think anyone could fairly say that this government hasn't dealt with these issues.
But this is a long list of frankly,
I think we're getting into
a lot of points
across
there.
the table rather than questions.
Yeah, I'm just expressing my real frustration about this, which we shared out there.
For you to express your feelings. You can ask a question and then we can move on.
I'll go on with further robo-debt question. I want to go to another element of the robo-debt response. The APSC's Code of Conduct investigation of public servants referred to in the sealed section of the Royal Commission's report. That's what I'd like to go to now. In relation to the investigation, would the Privacy Act or any other legislation prevent the release of the names of those considered and the details of their infringements, noting that the names of at least 2 departmental secretaries, in fact only 2 departmental secretaries, have actually already been released? What's the barrier here? Is there any barrier in relation to the Privacy Act?
Well, Senator, I would note, of course, that is a line of work that was the responsibility of and led by the Public Service Commission. That'd be my first point. My second point would be I wouldn't comment on the application of a piece of legislation to the conduct of another entity and the way it conducted particular investigations. What I can say is there was an extensive statement released by the Commissioner on the 13th of September, and that included outlining the factors relevant to the naming of officials, in some cases the former agency heads, and not naming other officials, and if memory serves, 4 elements were outlined there. I'd also note that the Commissioner and Minister Gallagher commented on that report yesterday at estimates, and so I'd absolutely defer to their carriage of and leadership on those issues. I would note, well, maybe I'd stop there, Senator.
I was in the room when that questioning proceeded, and I was extremely frustrated, I have to say, with the lack of response and the lack of really making it clear to the Australian community, including the public sector, that there are lessons here for public servants. But I'll go to my next question. Did the Attorney-General's Department or the Solicitor-General provide any advice to the Public Service Commissioner on the disclosure of names of those investigated in the centralised Code of Conduct investigation?
I think what I would say is that the Australian Government Solicitor provided some support to the Australian Public Service Commission in its work around the Code of Conduct investigations. And I don't think we provided any policy advice from the department.
All right. Look, Senator, I think it would be best if we take that on notice. I'm not aware of that, but I do want to check the accuracy before I give you an answer.
I appreciate that. So on notice, could you...
I do need to share the call. If you've got one last question, you can put it now.
If I could finish, I've got one more question. So if you could take that on notice to provide copies of that advice, I would appreciate it.
We wouldn't provide copies of advice, Senator, but your question went to have we provided advice, and I'm happy to take that on notice, but I wouldn't provide copies of legal advice to the committee.
Okay. Well, I'll look forward to hearing whether you did that. What public interest and natural justice considerations are relevant to the withholding of the identities and details of infringements of some, not all, officials involved in the centralised Code of Conduct investigations?
Senator, they are questions for the Public Service Commission, and I would also note, to the extent that they go to legal judgments, there'd be a question then on the appropriateness of talking through those elements. But Senator, I think I would just defer to the Public Service Commission to answer those sorts of questions.
Thanks, Senator Pocock. Senator.
Thanks, Chair.
We are.
Yep.
Yep.
I'll be as quick as possible then. Could I just get a quick update on the Brett cattle settlement process?
Yep.
This is of interest, obviously, to many in Western Australia.
Senator, do you mind if we just change personnel quickly?
Absolutely, not a problem at all.
Yep. Oh, sorry, that was the question.
Oh, that was the question. Yes, a quick update on the Brett cattle.
No.
Settlement issue.
That's
it.
No, thank you.
Too easy.
I'll ask Ms Haig to handle that question, noting this, of course, is a finance lead, but we can provide an update to the extent we can.
Thank you, Senator. So by way of update, the most recent development in the matter was that between the 25th and the 26th of September, the parties attended a mediation in relation to the matter, and the matter did not resolve during the course of the mediation.
And so what's the next step from here?
Certainly. So the next step, if it's helpful, Senator, I can take you through the various steps that have been scheduled. So on the 13th of December, the applicants are required to file any expert evidence, outlines of lay evidence and any list of documents in response to the Commonwealth's evidence. Then we move into the new year, and on the 7th of March 2025, the parties are required to conclude their participation in any further mediation.
And what does that mean?
So this was a order made by the court on the 28th of October, and it's providing as I understand it, a window within which, if the parties wish to return to the mediation process, the court has asked that it occur within that period by the 7th of March.
And that's it at the moment? That's what's been programmed?
There's a few more. And so then following the 7th of March, then the court's asked that 7 days later, on the 14th of March, that the parties provide a brief written report to the court which outlines the steps that have been taken and the general progress of the matter, and that is, I understand it, to include the outcome of the mediation. And then finally, on the 14th of April, Senator, there is a hearing. What's referred to as the counterfactual exports hearing has been scheduled for 20 days. And that is the hearing in which the key issue in the dispute around the quantum will be explored before the court.
Okay. So essentially, within reason, subject to the 7th of March compliance, it's going to be back into litigation.
Well, back before the court
there's
to
no
consider
settlement.
that issue.
Yeah, there's no settlement. It was reported in the media, and I'm looking at the National Farmers Federation website, about a letter sent by the Attorney-General in July of this year to the National Farmers Federation in relation to, sent to them and provided to the media last week. Have you got a copy of that letter? Who drafted that letter?
Yes, we have it.
Oh, thank you. Are you able to table, what does the letter actually say?
I can't table mine. I only have mine on a computer.
Sorry, so is this the letter from the Attorney-General
to the National Farmers Federation?
It's publicly available.
1st of July? 1st of July, wasn't it?
So, 1st of July? Did you say 1st of July?
1st of July.
Yeah.
1st of July.
Yes.
I understand it's already publicly available, Senator.
Where's it publicly available?
We'll need to check that. And
would you
get
mind?
back to you.
Could you also table a copy for the committee so we have it on the committee's record? It was reported by the National Farmers Federation President as labelled the federal government's recent correspondence on the live cattle class action as an appalling attack on victims. In a letter the Attorney-General Mark Dreyfus sent to the NFF and provided to the media last week, the government has accused the victims of trying to line their pockets, and then the response from the President is, "This is outrageously misleading and a disgraceful attempt to bluff the public and play games with people who've already lost so much." We're talking about wrongdoing from 2011 that's still dragging on. Since that time, people have died, businesses have collapsed and families have cracked under the pressure. So again, I ask, what did the letter actually say to elicit such a strong response?
Senator, it's a 3-page letter that's quite extensive and detailed. I'm not able to comment on what the letter said in particular that would have triggered such a response. Yes.
Don't really have time for you to read it out, unfortunately.
No, it is. Yes, it's public. It's public,
but
and
it is public.
It's written in a completely appropriate and professional.
And what was the gist of the letter?
Senator, essentially the gist of the letter, Senator, was to state that the offer that had been previously put by the Commonwealth was a reasonable offer and essentially was the maximum offer that was supported by evidence.
Yep.
And that based on the evidence that was available at the time that the letter was written, that the Commonwealth could not support a higher offer.
Could you just remind me what was the offer that the Commonwealth put on the record?
That was $215 million.
$215 million. And
Senator, if I just may add to Mr Johnson's summary, I think it's also important to note that the letter stated that the government remains committed to achieving a meaningful negotiated resolution of the matter.
Which, if the government can't go past $215 million, is going to be very difficult. In terms of the $215 million, how many people would that be divided up between?
That's probably a level of detail that's best put to the Department of Finance, who has the primary responsibility in managing the matter. I understand that the full size of the class may not be fully known, but that's a level of detail that's probably beyond our involvement.
Okay. Can I just... There are 3 matters, I understand, in which a settlement offer has not been approved in this term of Parliament. Can you just tell the committee what those 3 matters were or are?
I'm sorry, Senator, I'm lost by your question.
We're moving on to a different topic. Is that correct, Senator? This is...
well, there's still... one of them, I want to pursue whether or not one of them's the Brett Cattle matter, whether or not a settlement office has an offer of settlement has been considered by the Attorney General and rejected.
What I can say in that respect, Senator, is that the $215 million offer, that was made by the Commonwealth, was approved by the Attorney General as is required. But
it's been rejected by
the other party, by the group, Senator. I'm not aware of.
Without more detail, I don't think we could answer in relation to the other 2 instances.
Yeah, the Attorney General has not rejected an offer.
Not approved.
The way the system works is
not approved.
For the Commonwealth to make an offer, it must be approved by the Attorney. And so this offer was approved by the Attorney.
So this offer was approved by the Attorney, and the ongoing issue is now. Can I just remind me what the quantum is that the applicants are asking for?
I think that's a bit of a moving feast, Senator. I can advise that the most recent public offer made by the group was $510 million plus interest and costs. So that was exclusive of interest and costs. $510 million. That was put on the 22nd of November 2023.
22nd of November 2023.
And no other public offers have been made by the group.
Right. In terms of the $215 million, who recommended that as the Commonwealth's offer?
That was an amount that... So it's probably helpful to explain, which I understand Senator, but I will explain it anyway, the way that the system works. The Department of Finance, Comcover, has responsibility for managing the matter. If they wish to put a settlement offer forward, they must put that proposal to the Attorney General through my team, and that, consistently with all of the requirements under the legal services directions, must be consistent with legal principle and practice, must be supported by legal advice. So I think that the crux of the answer is the Department of Finance. devised that based on legal advice, and then it was approved by the Attorney-General.
And the figure was the $215 million that was approved. It wasn't a higher figure put forward by the Department of Finance.
I'll have to take that on notice, Senator.
Would you be able to take that on notice? What was the figure put forward by the Department of Finance? I just want to follow up. It's from the Secretary's response back to me, and it was response number 12, settlements. The evidence in the letter that's been provided to Coalition Senators makes clear that the Attorney-General has considered 51 settlement requests and approved settlement offers in 48 matters and declined 3. And it's the 3 that I'm asking, what were they?
Are you asking what they are, or was it
what they are,
or was it Brett Cattle?
What they are.
I'll have to take that on notice, Senator.
Okay. And was one of them Brett Cattle then?
I understand it was not, but I'd like to take that on notice just to be sure.
Okay.
But I don't believe it was either one of the 3 was Brett Cattle.
Okay.
But I'll confirm that on notice.
And you'll provide me with what the other, the 3 are, or alternatively 2 plus the 1.
Oh yes, I'll take that question on notice, Senator.
Okay. Chair, in the interest of time, because I know that people want to get to the AFP and Senator Patterson in particular.
Sure. Senator Thorpe, you're still on the line. Do you have, I'm not sure how many questions you have, but we have a little bit of time before the dinner break.
We can, if you need to. Yeah.
I am still online. Thank you, Chair. I can ask one question. I'm happy to.
Yeah, thank you.
Great. Thank you. This is in relation to the ICJ complicity to genocide. So if those people could come to the table. My question is, has the department taken any actions to ensure that members of Parliament are aware that they hold individual responsibility under international law to prevent and avoid complicity in genocide as mandated by the Genocide Convention and Rome Statute of the International Criminal Court?
Senator, if it's all right, I'm sorry, I know that was a long question. Would you mind repeating the question?
Sure. So in relation to what's going on with the genocide, particularly in Palestine right now, and the International Court of Justice, my question is, has the department taken any actions to ensure that members of Parliament, particularly those Labor senators in the room, are aware that they hold individual responsibility under international law to prevent and avoid complicity in genocide as mandated by the Genocide Convention and Rome Statute of the International Criminal Court?
Senator, I'm happy to start with an answer and then I'll ask colleagues to supplement it. Your question is quite wide-ranging in parts, but also quite specific in others. There are bits of it I just will not be able to speak to, but what I can offer is our obligations under international law are very well known, and there is strong commitment and has been over successive governments to international law obligations. There are processes in place that ensure that Australian domestic legislation and policies comply with international law, including the provision of legal advice by tied legal providers. I can also attest, Senator, that we regularly provide legal advice to government on international law, including in the context of the current conflict in Gaza. I would not be, of course, able to go into the specifics of that advice. I would also note, Senator, a range of public statements, including by the Prime Minister and the Foreign Minister, that underscore the grave concern of government on a range of developments in the Middle East. And I think, maybe to round that off, Senator, it's a clear position since the commencement of the conflict that we expect all parties to adhere to international humanitarian law as well. I'll stop there, Senator, and just check with colleagues. Yep.
Thank you.
I've checked with colleagues, Senator. I think we'll stop there.
Okay, I'll just fit in one more question and then I'm happy to wait for after the break for a few more. Has any advice been provided to parliamentarians to ensure their actions in Parliament take into account the advice from the United Nations on the 20th of June 2024 that states, including so-called Australia, must halt arms and ammunition transfers to Israel, whether going directly to Israel or indirectly through other countries like the US, UK or Germany?
Senator, thank you. Thank you for the question. I think, Senator, that would be a question best put to the Department of Foreign Affairs and Trade, and all I could really offer is really the points I made a moment ago about advice and the role played by this department, the safeguards that are in place, the advice that it provides. But I think your question really is best handled by DFAT.
Okay,
Thanks.
thank you. Chair, I'm happy to put the rest after the break. Thanks.
Okay, thanks, Senator Thorpe. So the committee's about to break for dinner. We're going to come back at 6:45, continuing with Integrity and International Group. I understand Senator Thorpe has a few more questions. There's a few more questions from Senator Cox, and then we might be able to move on to the AFP. That's the plan. We understand that we won't be able to get to agencies this evening, so the committee's had a quick consultation and we think we can release the Federal Circuit Court and Family Court of Australia, Federal Court of Australia, Office of the Commonwealth Ombudsman and Commonwealth Director of Public Prosecutions. So we won't be coming to them this evening, they're released, but we will come back with Integrity and International and then hopefully move to the AFP shortly after that. So thank you, we'll see everyone just after 6:45.
Thanks.
We are continuing with questions for the Integrity International Group. And Senator Thorpe, you had the call before we went to the dinner break. Are you still there?
I am still here. Thank you, Chair.
Well, you can finish off your questions to the department now, and then we'll hand over the call. We'll rotate the call after you.
Great. Thank you. On 27th of March 2024, this Parliament passed the Defence Trade Controls Amendment Act 2024, which removed safeguards and checks for military goods through the US and UK. Has advice been provided to all government members of Parliament, including Senator Green, Senator Watt, ministers and all government members, for their potential criminal liability before the ICC arising for their support of these bills?
No, Senator.
No advice has been received or given?
I'll just ask my colleagues to respond, but I don't think accept the premise that personal liability arises.
Senator Simon Newnham, Deputy Secretary, Integrity International Group. All I could offer, Senator, would be that legislation, to the best of my knowledge, is administered by the Department of Defence. So questions pertaining to that legislation would really be matters for them. And then beyond that, Senator, all I could offer would be that, as I mentioned earlier, in the broad, I mean, your question goes to specifics I just would not have answers on, but in the broad, as I mentioned earlier, there are safeguards built into government process which go to ensuring every effort is made to comply with international law. But that's all I could offer. I'm sorry, Senator.
Thank you. So your branch, correct me if I'm wrong, your branch is responsible for our international human rights obligations. So I'm asking this department if they have provided any legal advice to parliamentarians on potential legal liability in the ICC for actions and decisions they have taken as parliamentarians or ministers. So it's basically yes or no.
Thanks, Senator. Anne Sheehan, First Assistant Secretary, International Law and Human Rights Division. Our role is to provide international legal advice to other government departments and to government, so we wouldn't be providing legal advice or advice to parliamentarians.
Okay, even though we're providing weapons to the US and UK to commit a genocide, that doesn't come into any remit of responsibility to government ministers and senators?
The advice we provide would be to government.
Okay, thank you. So parliamentarians, including the PM and Minister Wong, were referred by Birchgrove Legal to the International Criminal Court for complicity in genocide. Has internal advice been provided to these ministers on their referral?
Senator,
just give us a moment, Senator.
We're aware of the referral by Birchgrove Legal, and we have provided advice to government in relation to that.
Are the public taxpayers allowed to know what that advice is, given the the severity of the crime against humanity?
We don't disclose the content of our legal advice.
Okay. Wonderful. So overall, can you confidently assure us all here today that there is no risk that members of this Parliament and this government might be legally exposed under international law for complicity in genocide?
Senator, I think I would refer you back to the answer provided by Mr Newnham before, that of course we take our international obligations very seriously. We have processes in place to provide advice in relation to Australian government policies and activities, and the role of my division is to provide that legal advice to government.
Great. So you can't provide an assurance that there's a risk?
Well, we don't disclose the content of our advice.
So we have government ministers being sent to the International Court for crimes against humanity, and the department responsible can't provide an assurance to government ministers or senators or the public that there's no risk. So is that a matter of public interest, or do we just sweep that under the carpet?
Senator, I'll offer a couple of comments here and then pass to my colleague. And I'm apologies if I repeat myself a little bit here. I would just underscore again the grave concern held by government about a range of developments in the Middle East, and I would reference here the numerous public statements that have been made, including by the Prime Minister and the Foreign Minister, and I would underscore it too, the strong commitment to international law obligations, including international humanitarian law. It's a clear position.
Yep.
Sorry, Senator.
Yeah, sorry. I understand that. This isn't about what the minister's, media relations department says. This is about being complicit in crimes against humanity. I'm kind of speaking at another level, but that's okay. If we passed a bill that actively takes our eyes off weapons being sent to the US and UK in that bill, like we passed a bill that takes the public's eye away from the fact that we're sending weapons via US, UK to Israel, does that not make us complicit in some way in terms of the people making those decisions?
Well, Senator, I would note again, this is a piece of legislation administered by the Defence Department, and so I would refer those questions to the Defence Department. What I could add is there are, as you may be aware, Senator, defence export arrangements that remain in place, in which the Department, DFAT and others have involvement in, and that really sits then nestled inside those wider processes that I mentioned earlier about the safeguards that exist across government to ensure compliance with a range of obligations, international, domestic, etc. That's the very nature of those safeguards built into those processes.
Yep. Thank you very much. I have another question in terms of this right to defend itself argument that I hear a lot of people using, which is completely baseless. What legal basis does the Australian government rely on regarding its position on Israel's right to defend itself?
I'm not sure I'm
that's
clear
a
on that
for these officials,
question.
Senator.
Okay, if it's not the right place, I'll take it somewhere else.
It might be something that you can ask in the DFAT estimates about the broader approach to these issues and the statements that have been made by the Minister.
Okay.
Senator, I think it would also be in the realm of providing legal advice to the committee to comment on the legality or the legal basis for another country's actions that's a party to a conflict. So that's not something that we could provide commentary on.
I just don't want to be sitting here complicit in this genocide. Anyway, my next question is in relation to international law. The UN Charter's Article 51, the 4th Geneva Convention and the ICJ's advisory opinion, including the one of July 2024, these all stated that an unlawful occupying power, Israel, cannot claim a right to self-defence in Palestine. So does the Australian government accept this legally? Or am I being palmed off again?
Senator, I don't think that's how I would characterise the UN Charter, the ICJ's advisory opinion. And again, I'd have to say that we just couldn't provide legal advice to the committee on the legality of Israel's actions.
Okay, so...
Senator Thorpe, I'm going to have to wind you up in a couple of minutes as well, just to let you know.
I thought so. No worries, thanks. So can I just ask, so you are unaware of the legality of Israel's actions? Is that what I'm hearing?
I said that we couldn't provide legal advice to the committee.
So the Australian government's interpretation of international law, this is a question, is not consistent with the UN and ICJ. Is that what you're saying as well?
No.
Because can you tell me how it's consistent?
Well, Senator, as we've said, as we've sort of said a couple of times, we're not able to provide a legal opinion to the committee on consistency or otherwise of actions, whether they're in relation to the Middle East, ourselves, elsewhere. That's just not the nature of the advice we can provide to this committee.
Okay, well, I guess I have to hand it on, Chair. I do have more questions.
Okay.
Is it going around again, or is this my last chance?
We really do need to move on, Senator Thorpe. We're running quite a few hours behind. You could put some of those questions on notice to the...
Yes, I know that, but you never get the right answers. You just get bureaucratic answers. And the next one was about children in this country that are being subjected to torture. And against the international, we're not in line with international standards. We're torturing 10-year-olds, and that was my line of questioning. But if I don't have time to ask those, then it's another day in the colony, and enjoy it, and I'll see you at the end of the week. Thank you very much.
Thank you, Senator Thorpe. Senator Reynolds, we're coming to you. Obviously,
Thank
your
you.
colleagues have expressed to you
I will be
deep
very
desire
quick.
to move to the AFP as quickly as
Chair,
possible.
in deference to you all, I'll be very quick. I've got a couple of questions I just want to mention briefly, and I'm happy for them to be taken on notice. In relation to the Anti-Slavery Commissioner, wonder if you could provide an update to that process. Again, I'm happy to put that a quick update now and the rest of the details on notice, just in terms of process, time frame, starting date, etc. The second area is Divisions 270 and 271 of the Criminal Code. There was a review that was reported 18 months ago odd, and I'm just wanting an update on that. Happy to have that on notice, just in terms of what's happened with the review, any of the recommendations going to be adopted and implemented. And the last one is in relation to the Hague Convention and inter-country adoptions.
So in relation to the first two, we can definitely take them on notice and provide detail both in terms of the appointment process, which I think I can say I've chaired the selection committee and that process is well advanced and will be under consideration by government.
Does that, so that one does go to Cabinet for...
It does,
It does,
yes,
okay.
it's a statutory appointment.
And expecting it this year?
It's ultimately a matter for government in terms of timing.
Possibly. Okay, thank you. And Divisions 270 and 271.
Senator, I might ask colleagues to come to the table on that one. That's a bit more specific.
If it's easier, I'm happy for you to take that one on notice.
All right.
A bit more of a detailed response.
So we can take it on notice.
We'll take it on notice.
It's a little bit of a specialist area, so thank you. And the last one is on the Hague Convention. This is something that I will come back to later, but it specifically relates to inter-country adoptions. Now, I know that states and territories are responsible for administering it, but there has been a lot of evidence globally that inter-country adoptions has been scammed, and that there's, if out of the Republic of Korea, it's in the media at the moment, the government, the agency that Australians use and that the Republic of Korea have approved, has been doing illegal intercountry adoptions, false papers, etc. There's, even the Vatican has done some very dodgy things. So it is a growing issue now. There's also a lot of disquiet in the community about whether we still should be doing intercountry adoptions at all. There's a divergence now in states and territories in how they do this and whether they're actually even compliant with the Hague Convention. So could I just leave that one with you for an update in terms of the Commonwealth's responsibility in with the Hague Convention, how the Commonwealth oversees what the states and territories do, and whether you've got any oversight of, might be your ambassador in Geneva or in terms of foreign affairs, but what the current situation is, and whether Australia has an opinion on that, or whether it's something we need to review further.
Senator, thank you. We've listened very carefully to your outline. That, to the extent that that has an entry point for our department, that is actually an earlier group. As you've also mentioned, there's a role here for foreign affairs and trade as well, as I understand it as well. So if that's all right, Senator, I'll absolutely listen carefully and we'll take that on notice.
Thank you. I'll flag it with DFAT as well, but I just thought if we could pull it all together, because it might be that it's actually parliamentary, it requires a parliamentary inquiry into it at some point, but if we could just get your perspective on it and guidance, that'd be great.
Okay.
Yeah, Senator, we can do that, and we are responsible for the Hague Convention on intercountry adoption, so we'll look to provide you with that information.
Thank you, Chair.
Thanks, Senator. Now I'll give you the same preamble, Senator Shoebridge. We're handing the call to you. Obviously, you're aware of our time restraints.
I am, thanks,
Yeah.
Chair.
I can see you took that on board very seriously.
Oh, well, it's...
I am on board.
Yeah.
We've spoken about it before.
Yeah, we're good. We have
Excuse me, Chair.
we'll only ask 15 minutes worth of questions to the AFP and then they can go home. No, that's not
I don't think we're on board on that, but we are on board about getting to them at some point.
Getting to them as soon as possible.
Yeah.
I know Senator Reynolds has left. It's just been pointed out to me that actually it's the Department of Social Services that's responsible for the Hague Convention on intercountry adoption, not this department. But we can still respond to some degree to some of her questions, but I just wanted to correct that straight away.
Appearing in the next 2 days, so she can also ask them.
Yeah.
Yeah. Thanks.
Cool.
Senator Shoebridge.
Oh, thanks, Chair. My first set of questions are about what, if any, role the department and the attorney are having to try and resolve the mess that's happened in NAC. You recall I asked you some questions in cross-portfolio, indicated here was the point.
That's correct. So
we have a situation where the inspector has found the commissioner for the NAC, the conflict of interest was such that the commissioner should have no role in the process. We have other deputy commissioners conflicted out, and yet there's an obligation to find some eminent person, I think is the description, although it doesn't have any statutory support, to undertake a review of the Robo-debt referrals. What's the role of the AG's department, first of all, in that? Have you had advice? Has the NAC sought advice from you? Have they informed you of their process? What's the role?
I'll ask Mr Newnham to talk you through that. And we have been working to support the NAC in terms of their thinking on this issue, but I'll ask Mr Newnham to spell that out.
Thanks, Senator, for the question. You may be aware that under Section 276 of the NAC Act, it does enable the Commission to delegate power to make decisions. It is a matter for the Commission to appoint an appropriate person and establish the delegations, and we can certainly provide more detail on that. I would underscore that point that the appointment of an alternative decision maker is a matter for the Commission, and the NAC Act is carefully designed to preserve the independence of the entity and the Commissioner as well. It is the case, Senator, that we have supported both the NAC and the Inspector through this process, and the NAC has from time to time foreshadowed with the Department the sort of process they're envisaging and the possibility of certain candidates.
Well, but of course 276 permits delegation to a Deputy Commissioner. Now they're all out because of either they've had a pre-existing conflict or now their role in the process is such that they obviously would be conflicted out. We agree on that? I see you nodding.
Yes.
So, yeah. Or a staff member of the NAC, but doesn't seem to permit delegation to a contractor.
Well, actually, I will ask Ms Moran to outline it. There is a pathway to an appointment externally.
Thanks, Senator. Celeste Moran, First Assistant Secretary, Integrity Frameworks Division. Senator, I think it's worth, I'm sure you've pored over it, but looking at the Inspector's report, and in some of the attachments to that report, 3 of those are submissions from the Commission to the Inspector. Attachment D of that report outlines submissions about 2 possible mechanisms that the NAC sees are possible in terms of appointing the appropriate person to undertake the review. The first is, and I can take you to the paragraphs, but in their submission they talk, it's in paragraphs 3 and 4. They say the preferred and likely mechanism for the appointment of an appropriate independent person is as a temporary staff member at the SES level to exercise delegated decision-making power under section 41(5) pursuant to section 2761B of the Act. The appointment would be on the terms that the Commissioner did not propose to give any direction under 2766.
So that's one option.
That's one option. The second option that they canvass in their submissions, which are published, is in paragraph 5, and that is they could also consider engaging a person as a consultant under 263. They then go on to say this course of action isn't preferred, but is an alternative means by which reconsideration by an eminent independent person could be procured if delegation proves impractical.
Well, because if the 263 option is taken, the consultant, how is it that the consultant has the power to make a determination? Isn't that that seemed to me to be a ridiculous, well, that seemed to me to be a problem, a solution that had far, far more problems. You engage a consultant, and then what do you do with the consultant's report? Bring it back to a conflicted Deputy Commissioner, bring it back to a staff member who's on the direction of the Commissioner, or bring it back to the Commissioner? The consultant path seemed to me to be a dreadful non-solution to the problem.
Senator, Ms Moran may wish to add to this. I would note, of course, these are matters for the Commission, and I would also note that the Commission, to my understanding, is receiving legal advice in respect of its next steps. I'll just check if Ms Moran wants to add.
Well, I'll just, before we go to Ms Moran, I was astounded that the NAC even contemplated a consultant's approach. I'm hoping that somebody is saying to them that that's just your next mess waiting to happen. Don't do that. But Ms Moran, maybe you can give me some comfort here.
Well, I mean, I would just reiterate what Mr Newnham has said in terms of it being a matter for the NAC and that they're operating with advice. Obviously, we have responsibility for administration of the Act. And I've read to you what was in their submissions about there being a preferred option.
All right. But that then creates the difficulty of, if you find an eminent person, they have to be willing to become a temporary employee of an organisation headed by Commissioner Brereton, and also to take that status of a temporary employee. That seems to push back against the very I think many people would say that would rule out many eminent people. They wouldn't want to take that position.
Well, Senator, of course, the NAC has said it will come back on and provide details of the process and the appointment that it seeks to make. I would suggest that there is further steps to be undertaken here. I take your point, Senator, but that is the way in which the section and the options are crafted in the legislation. We do seek to support the NAC with this process, including if they were to take that option and seek to appoint that person, then ensuring those conditions are met.
We then have the further problem, and I wonder if they've sought advice from you about this, that even if they go down this process and they set up a consultant or a temporary employee, who chooses them? The Commissioner's got a conflict problem. The Deputy Commissioner's got a conflict problem. Who chooses them? Does the NAC Commissioner choose them? And so therefore is the NAC Commissioner choosing somebody who's going to be effectively marking his homework and if comes to a contrary conclusion to the NAC Commissioner on this referral point, calls into question the competence, the previous conduct of the Commissioner. I mean, there's such an obvious conflict of interest. Is that what's going to happen? We get to the point where a conflicted NAC Commissioner or Deputy Commissioners have to choose the person?
Senator, the pathway to an appointment is laid out in the legislative framework. It is a decision for the NAC Commissioner.
Yeah.
We are assisting them with that process to get to that point. We remain respectful, Senator, of the way the legislation is crafted, and we remain respectful of the independence of the Commission and the Commissioner.
Mr. Newman, I don't suggest you should be directing the Commissioner, and I'm not suggesting that. And your statements to that effect are entirely appropriate, and I don't. None of this is your making, but every road that is a potential solution leads through the NAC Commissioner, who's the one who has the conflict of interest problem and has created the whole mess. Every road leads back through the same conflicted person, doesn't it?
Yeah, Ms Moran may wish to add to this,
Well,
Senator.
Can you identify a road that doesn't go back through the NAC Commissioner?
Sorry, Senator, I missed the last bit of your...
Every road that that takes you to a potential solution to the appointment of an eminent person, every road goes at least once through the NAC Commissioner, who has a conflict of interest problem that has only been aggravated by his conduct.
Senator, I'll get Ms Moran to make sure this is correct, but if I understand it correctly, the CEO may well be the entity actually making the appointment. The second point I'd raise here is we have a very public and detailed inspector report. We also have a response from the NAC itself. We have two oversight bodies, as you're well aware, the PJC NAC and the inspector itself. So I would make the point that there is a clarity about expectation from the inspector. There is a public statement from the NAC itself about its intentions. There are provisions in the Act that contemplate this, and there is a pathway to an appointment, and there are two oversight mechanisms, not to mention, obviously, the level of public interest in this process.
Has the NAC proposed to you to use one of those oversight mechanisms, being the joint committee, to vet the potential eminent person, as would happen for a deputy commissioner or a commissioner, given effectively this person will be doing the work of a commissioner/deputy commissioner? Have they proposed going through the vetting process as though it was a deputy commissioner or a commissioner to provide some level of confidence?
They have not, Senator, but of course they are subject to the provisions of the Act, which include the information they can be requested to provide to the PJC NAC, including their attendance at their hearings. And I would reiterate, of course, whilst it may be cold comfort, this process really does go to the intended design of oversight of the NAC and the role of the inspector.
So the role of the department has been to provide this structural support, if I could describe it that way. And what about the Attorney General himself? Has he had any role to date in any of this?
Yeah, Senator, I might ask Ms Moran to run through. You may be aware of the communications from the NAC to the attorney.
Assume that I'm aware of everything up to the point of the delivery of the inspector's report.
Yes.
And the press release from the NAC. I don't need any of that repeated.
Okay. Well, then you've seen too the Attorney General's public statement. Obviously, the engagements between the NAC and the attorney can be directed to the NAC.
No, but I'm asking you, you're the department, are you aware of any communication or exchange between the NAC and the Attorney General that postdates those three public documents we spoke about? The Attorney General's statement, the NAC's statement and the Inspector's report.
I am not, Senator. I don't mean that means that there hasn't been any, but I'm not aware of any.
Has there been any? Ms Jones, are you aware of any?
I'd need to take on...
public documents.
I'll give you one example. Has the NAC floated a name past the Attorney General?
I'm not aware that that's been the case at all, Senator, but I may have misspoken because I want to just have Ms Moran correct that there has been a communication from the attorney in writing to the NAC post public statements.
There's also the correspondence prior to the report.
Yeah, the Senator's just asking about post the report.
Is today the 4th or the 5th? Senator, we're aware that the Attorney General has written to the CEO of the NAC on the 4th of November.
Can you provide the committee with a copy of that correspondence?
I'd have to take that on notice, Senator. I don't have a copy.
What was the subject matter of the 4th November correspondence?
It is in response to correspondence from the CEO of the NAC from the 30th of October in relation to some reporting requirements under the PGPA Act.
Was the 4th of November correspondence in any way in relation to matters covered by the Inspector's report?
Senator, as we
I
said...
did see you nod, I'm sorry.
I was going to add, I think broadly the correspondence from the attorney seeks information from the NAC about how it will respond broadly to the issues that have been raised in the Inspector's report, separate to the acceptance of the finding, the recommendation about appointing someone to review the decision. But in terms of some of the issues that were identified in the Inspector's report, what are the systemic responses of the NAC to that?
All right. And you'll take on notice if you'll be able to provide this committee with that?
Yes.
And when I say that correspondence, obviously that correspondence and anything it's responding to. So if there's some communication from the NAC that precedes that. Is there any other communication between the Attorney General and the NAC? Has there been any other communication? Whether it's from the Attorney General to NAC or the NAC to the Attorney General or any officer in the NAC to the Attorney General in relation to the Robo-debt matter that hasn't already been disclosed in the Inspector's report, or is this the correspondence that you've spoken about just then?
I don't believe so, but can we take
that on notice, but I don't think so.
I mean, the only thing to add, and I think we've taken it on notice, Senator, is that there's related to the same issue that we've just talked to you about. There was some earlier correspondence from the CEO of the NAC to the attorney, a response from the attorney, and then CEO of the NAC to the attorney, and then a response. So there's four pieces of correspondence.
Could you please provide all that correspondence to the committee?
We'll take that on notice.
Yes. All right. Thank you. I'd want to move quickly to the privacy review. Who's best to deal with the privacy review?
Well, I and some colleagues, Senator, so we might do a quick change.
Thanks, Mr. Newman.
Sorry, what's the question? Oh no, we don't need to change. Sorry.
There are a series of stakeholder meetings that the department had with as the privacy reforms were considered, in fact, following the release of the Privacy Act review.
Yeah.
Did you participate in those stakeholder reforms?
I personally, or the department?
You starting with you, Mr.
No, although I have had meetings from time to time where the Privacy Act review has come up, but I wouldn't say they've been designated as, devoted to the Privacy Act review, but I'll just pass to colleagues because there's certainly been a big body of work there.
I can't see your name, sorry, Ms.
Fitch.
Ms. Fitch. Ms. Fitch, were you in the consultations?
Thanks, Senator. Catherine Fitch, Assistant Secretary, Privacy Reform Task Force. I have been involved in some but not all of the stakeholder meetings since the review was released.
You see, the department has released the list of stakeholders and the dates for meetings, and I think that's worthy, and I commend you on that. But when you look at that, the most frequently consulted groups in the privacy review were the Business Council and the Chamber of Commerce and Industry, which I think each tended some 8 meetings between the department, in just barely 6 months, between November the 7th, 23 and June the 5th, 2024. Why were they given so much access and so many meetings, 8 meetings in 6 months?
Well, Senator, I'll certainly ask colleagues to come in specifically. I would just, of course, frame our answer with the fact that I'm sure what you've quoted there is right, but just to broaden out the lens for a moment, this is a body of consultation that occurred in the midst of a multi-year process with significant amounts of consultation across all fronts. So you've mentioned industry, of course, but civil society, media stakeholders, not-for-profit.
I'm not pretending they're the only. There's a bunch of other stakeholders.
Yes.
But when you review the stakeholders, these are the two that keep coming back and back and back and back.
Well, again, I will pass to Ms Fitch because I know you directed the question there. I mean, I would also note that there's a very responsive approach taken to consultation, including if particular groups seek further information, or indeed if the matters at hand have a great deal to do with their members and their interests. But why don't I ask Ms Fitch to expand on that?
Thank you, Senator. I'm not sure precisely which list you're referring to. I wouldn't say necessarily that from my close involvement in all of the meetings that the Business Council and the Australian Chamber of Commerce and Industry have been significantly consulted more than other groups. As Mr Newnham's identified, there have been a range of discussions. Some of them have focused on particular issues. So, for example, the small business exemption related proposals from the report and other matters. And, for example, ACCI was involved in that series of discussions. So I would probably like to take on notice.
Well, Ms. Fitch, why don't you take on notice what your understanding of the number of times the Business Council and the Chamber of Commerce and Industry were consulted, and then if there are any comparable, any entities with comparable numbers, please let us know.
Very happy to do that, thanks.
When was the department provided with the ACIL Allen report?
Senator, I believe that was June 2024.
All right. Was any stakeholder provided with a copy or given access to a copy of the ACIL Allen report?
No, not to my... No, I don't think so, Senator.
Will you provide the committee with a copy of the report?
Sorry, Senator, could you repeat that?
Will you table a copy of the report? Do you have one there?
No, we do not, Senator.
Will you table one? Will you table a copy of the report?
I think probably the appropriate response would be to take it on notice so that we can check whether there are any issues releasing it.
Yeah, well, thanks, Minister. To this point, the government has refused to release the ACIL Allen report, which apparently was commissioned to identify the likely costs of implementing the privacy reforms set out in the review. In the review, that was the purpose of the ACIL Allen report, wasn't it, Ms Fitch?
Yes, Senator, it was a standard impact analysis as required by standard government requirements.
So what is the rationale for not having released it to date? Why wasn't it released as part of the government's response and the first tier of response?
Senator, Ms Fitch and Ms Moran may add to this answer, but the report was developed to assist with government decision-making processes.
Mm-hmm.
We've taken it on notice. I would note too that the report may well be relevant in future to future reforms and government decision-making about future reforms as well.
Well, any report could be useful to future reforms, but this part of the process has concluded. The Tier 1, at least in terms of the deliberative process, the legislation's now been presented. Is it because it sets the cost of actually doing the privacy reforms as being quite moderate and therefore would question why the government hasn't done the full implementation of the privacy reforms? Is that why? It's sort of an embarrassingly low figure.
Senator, I'm not going to go into the substance of the report that hasn't been released by government. All I can say are the things that I've already said. It was a component of the considerations for government, but it was developed to assist with that government decision making.
We heard in the course of the inquiry from the department that the reason why the first round of privacy reforms don't provide any substantive changes to privacy settings was because there was a decision made within government to limit the first round of reforms so that they didn't impact on any regulated entity. And I think that's almost word for word. They didn't impact on any regulated entity. Was that a decision of was that a direction from the attorney? Was it a direction, did it come from you, Secretary? Where did the direction come to ensure that the first round of privacy reforms didn't impact on any regulated entity?
So it didn't impact on...
On any regulated entity?
Yeah, look, Senator, colleagues who were there at those hearings can speak to that. I'm certainly not aware of any direction as such. I would just, again, note that this first tranche of reforms is indeed a first tranche. That would be my first point. My second point would be it goes to 22 of the 25 legislative proposals that were agreed in the Privacy Act review, and that includes things such as the Children's Online Privacy Code, enforcement powers, civil penalties, information sharing and transparency around automated decision making. I'd also add that it includes a statutory tort and that it criminalises doxing. I've mentioned it's a first step. There is unfinished business, and the government has committed to making progress in coming months. And I will just pass to my colleague on your specific question.
Our hearing into the bill, Senator,
which I'm now asking because we have more senior members in the department here.
We had an entire day's hearing on this
We
topic.
did, and we didn't get an answer.
We had the same
And we
people
didn't get
here.
an answer in that as to who gave the direction to ensure that the first raft of reforms didn't actually change anyone's privacy rights. And I'm trying to get that answer now.
Senator, I'd just have to check the Hansard, but I'm not sure that what you've just characterised is the evidence that was provided by Ms Fitch and myself at the hearing. I think Mr Noonan's outlined the fact that the first tranche bill is implementing the agreed proposals from the government response, and that there is a commitment to further reforms through a second tranche of reforms, and that is to implement to the extent possible. What I would say is there's a commitment to do further consultation on the agreed in principle proposals from the Privacy Act review, and for that to be done through draft provisions, and for that to be targeted consultation. As we've canvassed already tonight, there is been significant consultation and interest in this work. I think 900 submissions, 220 consultation meetings. The bill and the committee process has got another 71 submissions. What stakeholders have said to us is that it's proved challenging to continue to engage with us on the kind of abstract policy, and what they need to see are draft provisions. And so that's what the government has committed to doing as part of the second tranche of reforms.
Is there a time frame for the second tranche of reforms?
I think we've given evidence to the committee that the work is underway.
Yeah, is there a time frame to deliver them? Because as you point out, this privacy reform process started some time ago. On one view, it started in 2014. Is there a time frame for it to end and for the second tranche of reforms to be delivered?
It's a matter for government, Senator. I would certainly note that there is a public commitment from the government to seek progress on these in coming months, and I can assure the committee we're already working on it. But I would go back to the need for further consultation using those draft provisions. We're moving it as quickly as we can.
Perhaps you can take on notice where the decision was made to limit the first round of reforms to the package that's presented. Perhaps you can provide on notice where in the department, or if it was a direction from government, from the minister, you can identify where that decision was made.
We can take that on notice in terms of how legislative packages are developed. It's an iterative process working with ministers, but we'll take on notice to see what we can provide.
All right, thank you.
The only thing I'd add, in case it's helpful, is that, and I think I did give this evidence to the committee in the other, constituted in the inquiry context, that in view of stakeholder requests and the outcomes of consultations, we did consider, because of the interlinked nature of many of the proposals, that consolidating certain ones into a second tranche would seek to minimise regulatory disruption for those stakeholders who would be, were the proposals to proceed, be required to update their business systems and processes.
Thanks, Ms Fitch. That's helpful. I'm moving on to another topic now to try and tick off these.
Is waiting online as well. She said she has 5 minutes worth of questions. The Greens have had quite a substantial amount of time with this group. Did you want to let Senator Cox ask some questions, and we can come back to you, and then we can move on?
If that's convenient to you, Chair.
Oh, I think it would be. I mean, she's been waiting a while. Senator Cox, are you there?
Can I ask some questions in relation to the Human Rights Branch? Have I got the right officials?
Yes, Senator. If you just give us a moment, we'll get them to the table.
That's great, thank you.
Go ahead, Senator. Thank you.
I had circulated an ABC article that referenced the UN committee on the elimination of race discrimination that they had written to the Attorney-General. Specifically outlines the Aboriginal cultural heritage laws. And I had asked this question last night in DQ in the Environment and Comms Committee. Is the government or the department aware of this correspondence?
Thanks, Senator. Anne Sheehan, First Assistant Secretary, International Law and Human Rights Division. The department is aware of the correspondence and is aware of your questions to DQ yesterday. What I can advise you is that this correspondence is being handled by the National Indigenous Australians Agency, so that correspondence has been sent to them. They are working on a response to that.
Can you tell me why the government, in particular the Attorney-General, failed to provide a response to the initial request in relation to ensuring that this met the human rights obligations? I think within the letter, just to quote that seeking free, prior and informed consent is consistent with the UN Declaration on the Rights of Indigenous Peoples, and that is in fact is a potential breach in relation to the International Convention on the Elimination of Racial Discrimination, and that they had asked for the government specifically to look at the mechanisms to ensure that international human rights is actually being followed and is consistent. Why didn't the Attorney-General provide a response to that? Why does it go now to NIAA when in fact it's a human rights issue? It's an obligation, it's a finding, a recommendation of the UN Declaration on the Rights of Indigenous Peoples Bill that was voted on in the Parliament in December last year. This is consistent constantly around the rights of Indigenous people. The federal government, is the Attorney-General not concerned with the breaches, the international conventions that Australia signs up to?
So correspondence dealing with human rights issues would not always be answered by the Attorney-General or by the Attorney-General's department. With respect to this particular committee and the process by which this correspondence was sent, it's the committee's what they call the early warning and urgent action procedure, and the way that framework operates within government is that the procedure rests with the department that has policy responsibility for the subject matter, not necessarily with the Attorney-General's department, because human rights issues have been raised. We might be, the relevant department might consult with the Attorney-General's department, particularly if they're seeking legal advice from us to input into a response, but it would be this particular correspondence is being dealt with by the NIAA.
Well, we know also that, I'm sorry, I can't see your name tag from where I am. The camera's not allowing me to see that, sorry. Ms. Sheehan, that with all due respect, in asking this question last night in DQ, I know that the Federal Environment Minister has oversight in relation to the drafting of the new legislation, which incorporates Aboriginal cultural heritage, and the importance of that. The consistency within a human rights framework is within the remit of the Attorney-General. Is he providing advice to the Environment Minister, but also the Minister for Indigenous Affairs, to ensure that there is consistency with human rights and that we are not breaching the racial discrimination convention that Australia is signed up to?
In relation to legislation that's developed by other departments, and there is a standard bill scrutiny process whereby legislation would be sent to the Attorney-General's department to review it, including from an international human rights law perspective. So our department would have the opportunity to review that legislation as part of that standard process. And there's also a process with bills that they would be accompanied by a statement of compatibility with our human rights obligations. So when a bill is presented to Parliament, there would be a statement that would explain how human rights obligations are engaged with in relation to that bill. So that would provide an opportunity for the Parliament to have visibility on the relevant human rights issues in relation to that particular legislation.
But we know, Ms Sheehan, that that's not foolproof, right? Like that we know that there are bills that are presented before the Parliament that still continue to not uphold the rights of Indigenous people, particularly the human rights of Indigenous people. Is the government, is the Attorney-General in particular, going to seek a conversation to ensure that the legislation being drafted around cultural heritage or taking to the Joint Standing Committee with the Attorney-Generals across jurisdictions? This letter also references the state government in Western Australia because the laws were actually wound back in December 2023. This is an urgent issue with all of the destruction of cultural heritage that is currently happening across Australia. The identity and the human rights is at risk of Indigenous people if we continue to not see this with a sense of urgency.
Senator, what I could say is that as part of our standard process, we would engage with the relevant department on the development of the legislation to ensure that international human rights law issues are taken into account as part of that process.
Thank you, Ms Sheehan. Thank you, Chair.
Thanks. Senator Shoebridge, we're coming back to you. Obviously, we need to move on.
Tone in your voice and I'll respond accordingly.
Okay, well, It doesn't seem like we're responding accordingly. I'll just ask officials if you can keep your answers as brief and direct as possible. We have quite a few interstate agencies now that we're holding this evening that we need to get to. So I'll hand the call over to you, Senator Shoebridge.
Thanks, Chair. On the 19th of August, I asked the attorney on notice whether or not it sought any legal advice on the possible legal implications for Australia for any current investments or for any holdings or companies involved in the illegal occupation of Palestine, and any legal implications for Australia following the ICJ advisory opinion that made it clear that Israel's occupation of the West Bank was illegal and that states should take a series of actions to not be complicit in the occupation. The response from the Attorney-General was that he had not sought legal advice on those matters. Why is that?
Senator, I don't have that quan in front of me, but I do recall it, and I believe that the answer was that it was a matter for Department of Finance.
Well, questions in relation to government's investment funds are a matter for the Department of Finance, but compliance with international law and the rulings of the ICJ is surely a matter for the Attorney-General's Department. If finance was traipsing off in gross breach of our international legal obligations, that would clearly be a matter for the Attorney-General's Department, which I understand does have statutory responsibility for Australia's compliance with international law. That is what your department exists for, in part. Is that right? International Law, the Human Rights Division.
We have responsibility for providing legal advice
Correct.
on international law.
Yes. So the ICJ has made a ruling that says investment in that supports the occupation and other action that supports the illegal occupation of Palestine is unlawful. As I understand the answer, the Attorney-General's Department has sought no legal advice on that question, on the implications of the ICJ's ruling. We'll start with Australia's investments. No advice sought on that?
There has not been advice on the investments question that your quan related to.
Has there been any advice in relation to the implications of the ICJ ruling?
Yes, the department has provided advice on the ICJ's decision.
When was that advice provided?
On the 15th of August.
And what matters did the advice cover?
Senator, we wouldn't go to the content of the legal advice.
Well, I'm not asking for any disclosure of what the actual legal advice was. I'm asking for what matters the attorneys sought legal advice on. What was the scope of the advice?
Senator, I think Ms Sheehan has given a description of the topic and that is generally the extent to which we describe legal advice.
Has any action been taken in response to that legal advice?
Senator, we provided advice generally on the ICJ's advisory opinion. I don't think I could say that that's our role to provide advice. I don't think I could then comment on action that's then taken.
Are you aware of has the department taken any action following that advice, in response to that advice? Have you taken any steps, for example, to be compliant with the ICJ ruling?
Well, the action that we have taken is to provide legal advice.
The department has taken no other steps to seek to be compliant with the ICJ ruling than providing advice to the attorney. Is that right?
That's correct, Senator.
Has advice on the ICJ ruling been sought by any other department or agency? And if so, has it been provided to any other department or agency?
Go ahead.
I think in terms of what advice that would be a matter for those other agencies.
Since your government has come into office, Minister, your government has entered into $30 million in fresh contracts and has continued $20 million in ongoing contracts with companies that are listed by the UN as being complicit in the occupation of Palestine. Do you have any explanation for that?
Well, as has already been pointed out, I'd encourage you to ask those questions at the Department of Finance estimates.
Well, these contracts are not investments. These are separate contracts across multiple agencies and government departments. It's not the investments. These are now $50 million worth of contracts, and that is by no means limited to finance.
No, but the point is that finance has responsibility for procurement decisions across government, and so it would be best to put those questions to finance.
No, Minister, none of these, well, I'm not aware of any of these contracts being under the purview or the direction or the oversight of finance. These are contracts with an array of government agencies, including defence.
The point I'm making is that government policy in relation to procurement decisions, the types of businesses it's possible or not possible to procure from, those policies are set by the Department of Finance and other agencies follow them.
But whether they are compliant with international law or not is a matter for this department. This department has provided no advice on the $50 million of contracts with entities that are listed on the UN as being complicit in the occupation, even following the ICJ ruling. Is that my understanding?
We provided advice on the ICJ's advisory opinion.
Well, my question is, have you provided advice on the $50 million of contracts that the Albanese government has either entered into afresh or continued, where those contracts are with entities that are listed by the UN as being complicit in the unlawful occupation of Palestine? Have you provided any advice on the lawfulness of those contracts?
I don't think it'd be appropriate for me to go into the detail of what we've advised on. I think that it's appropriate that I've framed it as the high-level advice on the advisory opinion.
All I'll probably put some other questions on notice to assist in that regard, but I have one final question on a different matter. Senator Lambie asked some questions about the circumstances in which an exhibit was removed from the Royal Commission's website. As I understand it, the department has said that that was a decision of the Secretary of the official Secretary of the Royal Commission. First of all, when does the office of Official Secretary of the Royal Commission, when did it become vacant, or has it still not become vacant? Is there still an Official Secretary of the Royal Commission, although the letters patent have concluded and the Royal Commission has concluded?
Senator, Ms Haig can assist with that, but I can confirm that position no longer exists. But
when did
Ms Haig will give you the details.
When did it cease to exist?
Thank you, Senator. The Royal Commission was decommissioned on the 18th of September. October. I beg your pardon, October.
And is that when that position of Official Secretary ceased?
Correct, Senator.
Prior to for the period after the Royal Commissioners had handed their report and they were then functus and their offices became vacant at that point. Do we agree with that? When they handed in their report?
The Royal Commissioners' positions?
Yes.
Yes, Senator.
And can you remind me what date that was?
That was the 9th of September.
All right. So that happened on the 9th of September. Then the Official Secretary communicated with the department about the removal of the exhibit. When did that happen?
Senator, that occurred on the 17th of September.
Very auspicious day, that. And then the position became vacant on the 18th of October, is that right?
That's right.
Correct.
As at the 17th of September, given the Official Secretary was no longer under the direction of the Royal Commissioners, who was providing legal direction? Who was the lawful entity providing direction and control of the Official Secretary as at the 17th of September?
Senator, that was at that stage, the Royal Commission was in a process of what we call decommissioning.
Mm-hmm.
So the Official Secretary was the person at that stage responsible for
Correct.
the management of the Royal Commission.
But they were an employee of the department.
Correct.
They were not subject to the direction of the Royal Commissioners. They, I assume, were subject to your direction, Secretary. As a matter of law, subject to your direction.
As a matter of law, they're employed by the Attorney General's Department.
Yep. And subject to your direction. Unless you think they could have just gone off on a frolic of their own without you controlling them, which is a dangerous thing for you to say, Secretary, perhaps.
No, and that's not what I said, Senator.
Senator, while you're correct that the Secretary was the accountable authority, the Secretary delegates certain responsibilities to the Official Secretary under the PGP Act and the Public Service Act to enable the Official Secretary to oversee the administrative functions of the Royal Commission.
All right. Well, could you table with the committee that delegation? I assume it was in writing. And was it in effect as at the 17th of September?
We can certainly table it and take that on notice.
Of course, the Official Secretary didn't assume the powers of the Royal Commissioners when the Royal Commissioners left. And the decision of accepting an exhibit and publishing an exhibit was always a decision of the Royal Commissioners, wasn't it? That was uniquely a decision of the Royal Commissioners, wasn't it, under the Royal Commission Act?
Senator, I don't think we could answer on behalf of the commissioners. We're not aware of the decision-making processes within the Royal Commission about the publication of exhibits.
No one here is seriously suggesting the Official Secretary had the power to accept and publish submissions under the Royal Commissions Act.
I'm not saying that, Senator. I'm just saying that we're unable to confirm.
Well, perhaps you could take on notice whether or not the official secretary ever had the power to publish submissions, and I think it's rather bizarre we're going through this process, to publish and to remove submissions, and if so, what was her legal authority, in this case to overturn a legal and lawful decision of a Royal Commissioner to publish an exhibit?
Senator,
What was her legal authority to overturn a decision of the Royal Commissioners to publish an exhibit received in evidence in the Royal Commission?
Senator, the official secretary's statement referred to the publication being inadvertent.
Yes, I saw that assertion. Given no Royal Commissioner was consulted, how was that inadvertence determined?
I'm not able to answer that, Senator.
Well, perhaps you could take that on notice. It was a rather bold assertion from somebody who spoke with no Royal Commissioner. Perhaps you could take on notice whether or not the official secretary consulted with or spoke with or communicated in any way with the Royal Commissioner before A, making the assertion that it was inadvertent, and B, making the determination to non-publish it. Could you take that on notice?
Senator, we'll do our best. We'll do our best. I would note the Commission has been decommissioned. People have left their roles. I would also note that the timing of which the report went onto the website was whilst the Royal Commissioners were in their roles.
Correct.
With the official secretary as part of that structure.
Yeah. But it was the publishing of evidence is not a matter for the official secretary. The decision to publish is a matter for Royal Commissioners.
I understand.
The official secretary never had that power, and I'm bemused as to how it is the department thinks somehow she mystically got that power after the Royal Commissioners ceased their office on the 9th of September.
Well, Senator, we've taken on notice that the questions you've posed. All I was really suggesting here was the Commissioners were in place at the time that documents were published, as was the official secretary. She has since asserted that the publishing of that document was inadvertent. She was present with the Commissioners when it was published. So, of course, I'm not in the mind of the official secretary, but I would note she would be, I would have thought, well placed to make an assertion about being inadvertent.
It's my strong understanding that her assertions are not matched by a belief in the Royal Commission in the Royal Commissioners. But perhaps if you don't ask and you don't make those inquiries, you don't know. Did the official secretary make any inquiries of the Royal Commissioner? Have there been any representations to the department since that decision by any former Royal Commissioner about the decision?
No, Senator.
Shipridge, it's 8 p.m.
I do, I see it.
5 agencies waiting that you have called.
Yeah, Senator Shipridge, are you realistically going to get to the remaining agencies? We had 3 or 4 agencies that were kept here at the end last night that we didn't hear from. I think it would be courteous to let people know if they're not going to be required tonight.
Thanks,
Chair,
Minister.
that concludes the questions of the department.
Thank you. That is all the questions we have for the department. Thank you. I now call officers from the AFP. We'll suspend shortly to allow that to happen seamlessly. Sorry.
You're of the same view?
I think they've already been
They've been released.
It's about whether we get to the others.
We're not.
Oh, okay. Oh, sorry.
There are currently 7. There are currently 7 senators who have questions for the AFP.
Yeah.
Can we suspend? Thank Thank you. Broadcast, just for the information of senators and those following at home, we've just agreed to, given the time and it's just not possible to get through the rest of the agencies this evening, we're going to release the Australian Human Rights Commission with a caveat about possibly bringing them back for a spillover maybe, to be discussed. So I'm really sorry, Mr. De Cresta, I know it's your first spillover, your first estimates hearing, but we'll see a lot more of you over the next couple of, I'm sure he's following along, but yeah, we'll see a lot more of you over the next couple of years. And thank you to those commissioners who were planning on joining us via video conference and those that have attended. We're sorry for bringing you to Canberra today, but hopefully you got something out of it. We've got the AFP in front of us now, so we'll go to questions shortly, but we'll still keep the OAIC and the AAT and the NAC. And try to get through all of those before 10:30 tonight. We'll keep the blocks of questions pretty short, and Acting Commissioner, you'll keep your questions as brief as possible. Answers. I won't slow Commissioner Kershaw about the length of his answers, but I'm sure that you'll be able to maintain some brief brevity, and we can get through this as quick as possible. Thank you for sticking with us and being patient this evening. Acting Commissioner, do you have an opening statement before we go to those questions?
Yeah, Chair, just a very short one.
Thank you.
So listen, good evening. I'm Deputy Commissioner Ian McCartney. I am performing the duties of Commissioner, whilst Commissioner Kershaw holds offshore bilateral meetings integral to our operational planning, including for the next federal election. This is our fifth appearance at Senate Estimates this year, and we appreciate the opportunity to update you on how we protect Australians and Australians' interests. Tonight I'll provide you with information on two investigations. The first one is Op Alicia, which centres on the allegations, the alleged disclosure of confidential information by a former partner of PwC Australia. And secondly, Operation Advana, which is an investigation into prohibited symbols. State and Territory Police have already used new Commonwealth laws to disrupt or charge individuals publicly displaying prohibited symbols. However, Victoria Police has reported several matters to the AFP. The AFP established Operation Advana under the Counter-Terrorism and Special Investigations Command to principally investigate reports of crime against 14 individuals for allegedly displaying prohibited terrorist organisation symbols at a Melbourne protest in December of this year. About 1,100 hours have been spent investigating this matter, including reviewing 90 hours of CCTV evidence and police body-worn camera footage, and progressing the analysis of information collected during a recent week of action. As of tonight, I can confirm the following. 14 individuals are under investigation for display of a prohibited terrorist organisation symbol in a public place. 3 search warrants have been executed against 3 individuals, while a further 3 people have been spoken to by investigators. And a number of mobile telephones have been seized, as well as an item of clothing depicting a prohibited terrorist organisation symbol. If relevant thresholds are met, the AFP will provide briefs of evidence to the Commonwealth Director of Public Prosecutions to determine if charges will be laid. I've provided a comprehensive update tonight on this issue, but to protect the operation, I will be limited in providing further information. I can also reveal we are investigating whether some discourse relating to deceased terrorists or events in the Middle East has reached the threshold of urging violence against groups or advocating terrorism. I want to reassure the community that the AFP has not diverted resources from terrorist investigations. This year, 10 counter-terrorism operations have led to 15 individuals being charged. 11 of those individuals were aged 17 years or younger, and many of those young people were radicalised online. In relation to Operation Alicia, the AFP has made significant advancements despite this being a complex investigation, which has been made more complicated by the historic nature of the alleged offending, the existence of derivative use immunity connected to other investigations and legal privilege. In August, the AFP executed 2 search warrants at residences in Sandringham and Sorrento, Victoria. And additionally, the AFP began yesterday executing further search warrants on PwC Australia. I am proud of what the AFP is achieving. We are proud of what the AFP is achieving, and we're happy to take your questions. Thank you.
Thank you very much, Acting Commissioner. Appreciate it. Senator Scarr, we'll start with you. Or, I don't know if there's that you're the one.
I'm the one at the moment.
You are the one.
But it will be fleeting. I've got some questions in relation to matters which have been referred to the AFP in relation to the CFMEU. So have you got everyone at the table you need for that?
We do.
Okay. I've got some documents here. I probably don't need to table them, but I'll refer to quotes from them, and if people want me to table, I can table, but I know I want to get through this as quickly as possible given the time limitations. Acting Commissioner, on 17 July 2024, in response to the Fairfax 9 Building Bad investigation into alleged corrupt and criminal behaviour of the CFMEU, I understand that the then Minister for Employment and Workplace Relations, the Honourable Tony Burke MP, announced that he'd written to you to request the AFP investigate the allegations and prosecute any criminal breaches. Could you confirm that the Minister made that referral?
He did, Senator.
Thank you. What was the date the referral was made?
I'll find that information out, Senator, to get back to you before the end of our hearing.
Okay, if you could. Were any individual members of the CFMEU named in that referral?
I'll take that one on notice, Senator.
Okay, and if you could also take on notice how many individuals were identified?
I will.
If any. Could you table the referral letter?
I'd have to take that one on notice, Senator, I think.
Okay. Acting Commissioner, have you accepted the referral and initiated an investigation?
I'll briefly outline our response to this issue, Senator. The AFP has established Operation RYE.
Operation?
RYE, R-Y-E.
R-Y-E.
To assess that letter from the Minister, to assess a range of information we've been provided against allegations related to the CFMEU. We've been proactive in setting up the coordination arrangements, of course, relevant Commonwealth, state and territory law enforcement agencies, because there's been some referrals received by the AFP, but also referrals or matters that have been sent to state and territory police. So that coordination aspect's really important. These are complex in nature, given the allegations. And in terms of our engagement, we've engaged closely with the CFMEU Administrator and his office on numerous occasions in terms of working closely with that office. There's a range of voluminous material that we're working through at present in terms of triaging the information. We have one priority investigation that's underway in relation to allegations against the CFMEU. But I think it's important to note the previous investigations that were undertaken under the Trade Union Task Force, Senator. And there's been a range of successful prosecutions in relation to that. And there's one ongoing matter before the courts in New South Wales.
Okay, I just want to work through a few of the comments you made there. So you referred to a prior investigation. That was before the referral from the Minister. And that prior investigation is still underway?
It is, Senator.
Okay. And can you give us, and obviously I don't want to take you on areas you can't go to, can you give us any indication in relation to the nature of that investigation, the nature of the conduct that's being investigated?
Yeah, Senator, 2 people were arrested and charged with corruption-related offences on the 17th of September 2021. Mr Darren Greenfield and a Mr Michael Greenfield. They were charged with 4 counts of receive a corrupting benefit contrary to section 536D, brackets 2 of the Fair Work Act, and 1 count of make false declaration contrary to section 25 of the Oaths Act, New South Wales, and 2 counts of receiving a corrupt benefit contrary to section 536D, brackets 2 of the Fair Work Act 2009. I'm happy to say that, but these matters are before court, Senator, and there's not too much more information I can provide.
Sure. Can I just confirm the date they were charged?
The 17th of September 2021.
2021?
Yep.
Okay. Can you tell us when that investigation, even approximately, was commenced? How far ago? 2000.
I'll just, as a matter of completeness in terms of the exact date, Senator, I'll take that one on
Had it been undergoing for a number of years?
I wouldn't say a number of years. It's been going for a relatively long time, and that was under the construct of the Trade Union Task Force, Senator.
Okay. When was the Trade Union Task Force established? Approximately. Happy for you to take on notice to provide more detail.
2016, Senator.
2016.
2016, 2017.
Okay. All right. So you said, as I understood your evidence, there's a number of investigations that are taking place under Operation Rye.
There's one active investigation that we've initiated since the recent, I suppose, the commentary in the media and referrals to the AFP. There is one matter before the court, and then there's another historical investigation that's ongoing.
Oh, okay. So when you say there's one investigation underway, does that mean you're talking about an umbrella, using that term as an umbrella term with a number of individuals being the subject to investigations? How do you, what does one investigation mean?
Yeah, listen, I think the best way to characterise it is the Operation Rye is the umbrella, and I think it's important to note there's considerable material that has been provided, material that is both current but also material that is historical in nature, so there's been a significant triage process to work through. So that's the overarching, I suppose, operation. There is one priority investigation that sits within that operation, and there's a number of individuals that have been investigated.
So, okay. So when you refer to the one prior investigation that sits under that umbrella, you're not talking about the investigation where the two gentlemen were charged?
No, that's separate.
That's separate. Yeah. Is that the historical investigation you refer to?
Yeah.
Okay. All right. So just to make it, just so we're clear, there's three investigations we've spoken about. There's the umbrella investigation under the Operation Rye.
Yep.
There's the historical investigation
that's before the court.
That is before the court, and then there's the prior investigation still underway, but which predates the referral, which is also now under Operation Rye.
Correct.
Is that correct?
Correct.
In relation to that third investigation, when did that commence?
Oh, 2018, Senator.
2019?
Sorry, 2018. 18. That was a joint investigation with Victoria Police.
Okay. And can you give us any insight into the nature of the offences that are being investigated?
Offences against Section 536D of the Fair Work Act, Senator.
And just remind me, that's receipt of corrupt benefits?
Correct.
Okay. All right, thank you.
And just to note, the correspondence from the Minister was dated the 16th of July 2024.
Okay, thank you. And you've taken on notice whether or not you can table it.
For sure.
Can I ask you, there's a quote, and the relevant minister wearing a different hat is at the table, so I'm sure he'll... and indeed I invite him to correct me if this is inaccurate reporting. There's a quote from what Minister Watt said at the National Construction Industry Forum meeting on 16 October. He was reported as having said, "We actually do have a number of joint federal police state task forces already operating. It's no surprise they don't go around advertising what they're doing because they do have matters under investigation." So the minister made this reference to special federal state police task forces. and Acting Commissioner, I note that you also made that reference. How do you coordinate that? Is there a task force for each state around Australia, or which states do you have a task force?
So slightly conflating issues. I think the Trade Union Task Force was a separate, discrete task force formed with New South Wales Police and Victoria Police, with the AFP. Existing at present, there's joint organised crime task forces around Australia, with Victoria, with Queensland, with South Australia and soon to be in Western Australia. And there's a joint standing organised crime task force that has a structure. And again, I suppose from a focus perspective, very much focused on organised crime.
Okay. And which...
Scarra, I'm going to wrap you up in a minute.
Sure.
Oh, okay. I'll try and find a way to conveniently. Have you been awarded any? Has the AFP been given any additional resources to conduct these investigations? You've referred to the massive information you've received. You're obviously going through a triage process. Have any additional resources been allocated to the AFP to undertake this extensive work?
No additional funding, Senator, but obviously we can flexibly move around resources within the AFP directed at the priorities of the day, and we've allocated resources to investigate this matter.
Okay, thank you. Thank you, Chair.
Thanks, Senator Scarr. Senator Polley?
Yes, thank you, and thank you for coming before us again. I have some questions that I'm going to put to you on behalf of Senator Deb O'Neill, who's been chairing a parliamentary inquiry into ethics and accountability in the audit, assurance and consulting sector. This inquiry has included investigations of the misconduct of the PwC, and on Friday the committee released a number of responses to questions on notice from the PwC. These include supervised remediation correspondence, which detailed the way in which PwC International took control of PwC Australia, and in the aftermath of the tax leak scandal becoming public in May 2023. I'm tabling these documents for the benefit of the committee and witnesses. So my first question is, as it's been widely reported, and you referred to it in your statement, yesterday the AFP commenced a search of the PwC Sydney headquarters as part of their ongoing investigation into the wake of the tax leak scandal. Are you able to provide the committee with an update on your investigation into the PwC?
Thank you, Senator. I might pass to Deputy Commissioner Barrett on this issue.
Thank you, Senator Chrissy Barrett, Deputy Commissioner, National Security. So thank you for your question, and I do understand that there's obviously a high level of ongoing interest in this matter. As the Acting Commissioner referred to in the opening statement, and as you referred to, we did commence search warrants yesterday at PwC in Sydney and have executed 2 other search warrants prior to that. Unfortunately, other than that, there's really not a lot of extra detail I can give you other than by evidenced by the search warrants. There's obviously ongoing progress in terms of the investigation.
Were you previously aware of the supervised remediation correspondence between PwC International and the PwC Australia prior to me tabling it here tonight?
Senator, I'm quite reluctant to answer questions around this matter, given the sensitivities, given the very high legal complexity related to it, given that we've got a number of lines of inquiry that are still very active. So in order to protect the investigation, I'm really limited in what I can share with you tonight. I'm sorry.
Item 8 of this correspondence on page 8 states that the firm, PwC Australia, shall not provide to any regulator or other governmental or legal authority any formal, significant or substantive submissions or responses, where oral or written, regarding any of the topics until the network representatives and I, Global General Counsel Diana Beers, has reviewed and approved the materials. Does this give you concern about whether PwC International may encourage PwC Australia to withhold information from you throughout the course of this inquiry?
Senator, again, I'm sorry. What I'm going to say to that is I've got to be very careful how I talk about this matter. And for that reason, I can't answer your questions. I'm sorry.
Is it appropriate for PwC Global to demand approval for any PwC Australia information, including verbal witness statements, which may be provided to the AFP as a legal authority?
Again, I'm not in a position to answer that question, Senator.
But that isn't the normal course of action, is it?
I'm not going to provide comment. Again, as I said, this is a very active investigation. We're at a very important part of the investigation. We've obviously provided the information tonight in relation to some of those overt activities that we've commenced, but that's all I'm limited to saying.
I do respect the position you're in, but I will put the question. The remediation letter threatened expulsion of PwC Australia from the global firm if the terms of the remediation were not complied with. That means that if PwC Australia were to provide any evidence to the AFP without the approval of PwC International, they would be subjected to expulsion from the global firm, which is an incredibly significant consequence. Do you see this as an attempt by PwC International to intimidate witnesses who may be relevant to your ongoing investigation?
Thank you for your question, and I understand the purpose of your question, but again, I'm just not prepared to comment any further.
Are you investigating PwC International for potential obstruction of justice on the basis of these remuneration documents and their threat of consequences if the PwC Australia personnel cooperate freely with the investigation?
So what I would say to that is that this is a very active investigation. There are a number of lines of inquiry that are still ongoing. If there is new offending that comes in front of us as part of this investigation, then we will look at that. But I won't confirm what those lines of inquiry are ongoing to protect the investigation.
Can I ask then, is that a possibility under different company, different circumstances? Would the AFP undertake investigation into the international company?
So I won't speak specifically to this matter. I could say generally or broadly, we would have to determine if there was a jurisdiction for us and whether there was relevant offences that we could investigate and indeed take to a prosecution. So that's just generally, not specific to this matter.
So in any other circumstances, interference in threatening a witness is unacceptable and illegal, is it not?
So, Senator, again, as I've said a number of times, I'm in a really difficult position here because I can't tell you the aspects of the investigation. I'm sorry. And I know I said from the outset, I absolutely understand there's a very high level of interest. All I can assure is that there's very active investigations and activities that are ongoing.
Thank you very much. Thank you, Chair.
Thanks, Senator Polly. I'm sure Senator Polly doesn't want to put at risk that investigation. We just want to find a little bit more about it, but we'll see how we go. Senator Shoebridge, you have the call.
Well, thanks very much, Chair. Nice to see you all again. I have some questions relating to we'll call it the Carrick matter, which is the young boy who was 13 years old with quite significant autism, who was investigated by the Australian Federal Police and then charged with terrorism offences. You remember the matter? Has to be verbal, sorry, Deputy Commissioner? You do. And you remember it was thrown out in a quite brutal judgment by a local court magistrate who basically issued a permanent stay as an abusive process. Do you remember that?
Yes, I do, Senator.
Yes. And last time I was asking you questions about this, you indicated that there was a point in the investigation, and when I say you, I mean the AFP, I think it was actually now Acting Commissioner McCartney, who answered many of the questions, you indicated there was a point that when the AFP were first involved, there was a joint counter-terrorism operation, which was the AFP and Victorian Police, and the original decision was to have some countering violent extremism, some counselling and outreach. Do you remember that?
I do, Senator.
And if I recall correctly, you said there was a point after a few months of that where it was determined to move from that counselling process and a CVE process to, I think it was a major controlled operation. Do you remember that?
I do.
And I've just double-checked on the judgment. The major controlled operation commenced on the 11th of August 2021. Does that date seem right?
That seems right.
Yep. And of course, once the CVE guidelines say once a major controlled operation and a criminal investigation is on foot, the CVE needs to end. You can't be doing both at the same time because the CVE, the Countering Violence Extremism, obviously conflicts with the role of a police investigation.
Sorry, could you just repeat that statement, Senator? I didn't catch the first bit.
The Countering Violence Extremism guidelines say, quite rightly, that you can't be doing CVE at the same time as you're doing a live, hot criminal investigation, gathering evidence with the intent to obtain a prosecution, because they're utterly in conflict.
Listen, Senator, we've spoken about this issue obviously a number of times. It was a complex matter. I think the focus initially was on the CVE approach, but then we came to the decision, a joint decision with Victoria Police and ASIO, that process was not working and the threat had escalated.
Yeah. And then the countering violence, the CVE process was ended and the criminal prosecution began. He turned 14, I think on the 17th of September 2021, and then only a matter of, bit over a fortnight afterwards, he was charged with the terrorism offences.
Correct.
It's time frame. And of course the AFP had obtained the family's trust, hadn't they, in the course of this? That was part of the role, the CVE role. You regularly had police officers attend, you sought to obtain the family's trust. Is that right?
I think the CVE focus was from Victoria Police, Senator. I might just take that one on notice, but the family were engaged, correct.
Mm-hmm. But by the time he'd turned 14, the AFP had formed the view, as had the joint countering terrorism body, had formed the view that he was going to be prosecuted. The CVE had ended and he was going to be prosecuted.
We formed the view that the threat had escalated to an unacceptable level and the community was at risk, Senator, and we took appropriate action.
I'm going to show you a photograph. I have a few copies. Do you agree that retaining trust with the community is essential for the AFP's operations, and being seen to be genuine is essential for the AFP's operations? The community thinking their engagement with police will be genuine and a relationship of trust. Do you accept that that's important?
It's an important aspect, of course.
Yep. I've just given you a photograph. It's a photograph of a birthday cake that the police gave to Thomas on his birthday when he turned 14 on the 17th of September, at which point police had already formed the view that they were going to charge him. Police had already formed the view that the CVE would end, and I won't read out his name, but it has in prominent writing on the top of a cake with blue flowers on it, "We love you, X." What on earth were the police doing, giving a 14-year-old boy a birthday cake with blue flowers, blue police-coloured flowers on it, saying, "We love you," when you had already made the decision to charge him and prosecute him and put him in jail for terrorism offences? What is wrong? What is wrong with your officers who made that decision? How could it ever have happened?
Senator, this is the first time I've seen this photograph. I'm not aware of the circumstances.
Do you agree it's an obscene breach of trust, an obscene breach to give a 14-year-old boy with autism, who you've made a decision to charge, a birthday cake from the police with "We love you" on it? So how could any 14-year-old boy deal with getting a birthday cake from the police one day and then those same police trying to put him in jail and charge him a matter of weeks later? How could you do that to a child?
So, Senator, I understand your question. I'm unaware of the circumstances. I'm unaware of the context. I think from a CVE perspective, Victoria Police had the lead in relation to that aspect. I'm happy to take it on notice and come back to you.
Do you accept on the face of it, it is an obscene breach of faith and trust and just basic human decency to do that to a 14-year-old boy with an intellectual impairment and significant autism, to give him that on his birthday from the police and then charge him with terrorism offences weeks later, knowing you were going to do that when you gave him the cake?
So, as I said, I'm unaware of the circumstances, unaware of the context in relation to this photograph. I'll take it on notice, Senator.
I have been appalled, for the record, by police conduct, and not just police, the CDPP and others who are engaged in it, the inhumane approach to this family and this boy. But this, giving the boy a cake in police colours with "We love you" on it, when you'd already decided to charge him and put him in jail for terrorism, this is a degree of institutional bastardry that I couldn't have believed would happen.
Senator, I note your comments. I'll take it on notice.
Since the case has been thrown out, and can I stress, this family came to police. They came to you looking for help for their boy. Since the case has been thrown out, the family have tried to get their life back together again, and they wanted to take their kids on a trip to Singapore and Malaysia recently. And they went through the process of getting their passport, getting their boy's passport back. And they asked the passport officials if there was any impediment on the travel. They said no. Now, I'm assuming that given the responses I've had to date from the AFP, that you continue to keep this family under observation. I think that's a safe assumption. I see you nodding.
Well, no, I'm just nodding. I'm not agreeing with you, Senator.
Well, anyhow, I'm assuming that's the case. They made plans to travel, and I'll note for the record that you haven't either agreed or disagreed with that. That's your position.
I'm waiting for your question, Senator.
They plan to travel to Singapore, and when they arrive in Singapore, there's clearly information given to the Singaporean authorities. They are detained, they are held in immigration, the boys, the children are further traumatised. They are taken from the airport, held in detention, and then marched back onto the plane, surrounded by armed, they say they're armed police, there may have been some other armed officials, sat down, their passports are confiscated and only returned when they get back to Sydney. Did the AFP provide information to Singaporean authorities or to Interpol that would have caused this to happen?
Senator, I can say that the AFP provided no information to Singaporean authorities in relation to
Did
this.
the AFP provide information to a database such as Interpol?
No, the AFP did not.
Senator, I need to wind you up in a moment, but I know want to give both of you an opportunity to clear up the record.
Was the AFP aware, thank you, Chair, was the AFP aware that the family was travelling to Singapore?
As far as I'm aware, we did not know that the family was travelling to Singapore.
Were any steps taken by the AFP at any point to notify the family of concerns they may face if they travel?
Well, Senator, we weren't aware of their travel as far as I'm aware, so the answer to that is no.
Was any inquiries made of the Singaporean authorities, either directly or indirectly to the AFP, while this family was held in detention in Singapore?
So, Senator, I'll restate my answer. We've provided no information to the Singaporean authorities that would have impacted the family's ability to travel, and the decisions made by the Singaporean authorities, quite appropriately, are decisions for the Singaporeans to make.
Senator Shubridge, we'll have to rotate the call. Obviously, that's just for the purposes of discussing with the witnesses. We're not seeking to table that document given the the privacy concerns.
Correct.
Yeah, thank you. Just wanted to confirm that. Senator Van, thank you.
Thank you very much, Chair, and Commissioner McCartney, good to see you again. You'll remember in previous estimates we've had some discussions and I've asked some questions about some previous undercover operatives. I'm going to return to that subject again. In previous estimates, previous hearings we've had, you've told this committee that the operatives in question had no threats to their safety. Is that a fair way to sum up your testimony?
I'd have to go back and look at the testimony, Senator. I think that was categorised as we had identified no direct threats.
Okay, thank you. I have an email here from you to one of those undercover operatives dated 7 March 23. Would you like me to table it, or can I just read the relevant part? It's very brief.
Well, if you're going to ask me questions on it, Senator, I'd like to have a look at it.
Sure.
You don't need to table it, but you can provide a copy.
Happily.
Yeah.
And just to assist you, the relevant part is the bottom of the second page as printed.
I've got the email.
Thank you. Clearly a question has been put to you about are there any locations that would be unsafe for the operative and his family? And you say in response, to answer your question, there are locations that would be unsafe for you and your family to attend as a result of your work. As per Assistant Commissioner Koendering's email, you should avoid locations, private or public, that you visited as part of your deployments and you know are frequented by persons of interest and their associates.
So whereabouts is that in the email, Senator? You can just direct
As I said, bottom of the second page, under the heading, are there any locations that would be unsafe for you and your family? Would you like me to read it out again?
No, I've got that, Senator.
Sorry?
I've got that.
Good. So you've clearly agreed, given that these operatives operated very widely and across Australia and in many, many cities, you're effectively saying that if he leaves his house, he's unsafe. Is that a fair place to leave previous serving officers?
So listen, what I will say, and we've I think we've been on the record that we're not going to get into the finer details of these cases in terms of these undercover officers. I think we provide advice to all of our undercover officers in terms of locations they may or may not travel to, given the nature of their work. And this is a general protocol in terms of how we deal with these matters, Senator.
And so then let's take it out of the specific and into the abstract. you're saying it's okay for your officers, once they've finished work, to be unsafe anywhere they might travel to? Because that's the effect of what you're saying.
No, it's not. It depends on the circumstances of the deployment, Senator.
Commissioner, your words are, there are locations that would be unsafe for you and your family to attend as a result of your work. That's allowing a live threat to, if not impact dramatically, affect the life of your serving members.
I think the best way to describe it is, Senator, we identified no direct threat, but as an abundance of precaution, like we do to all our officers that are on the Undercover program. We provide guidance in terms of their work when they're in the program and also when they're out of the program. And I think in terms of just some further context, I might pass to Deputy Commissioner Barrett.
Yeah, Senator, can I please just go back to our previous hearing before this committee where I did raise some concerns that there is ongoing professional standards investigations in relation to these matters, some of which have come from complaints from the members that you're talking about. So we just need to be very careful that we're not impacting or prejudicing any of those investigations. It's very important, including to the members that have made the complaints, that we have the time and space to conduct those investigations properly and thoroughly.
And as you should, Ms Barrett, and I completely respect that. However, it's quite clear here that the AFP is aware of matters that could affect members' safety, and you have an obligation to protect their safety. Do you not?
So, Senator, perhaps Deputy Commissioner Gale, who sits over the top of our undercover area, could talk more broadly about how we manage our undercover operatives broadly.
Given the limited time, can I just ask that it be, if you address the point of knowing that there's unsafe places for them that they may come across, and how you address that particular point?
Lisa Gale, Deputy Commissioner. Thank you for the question, Senator Van. What I would say, and I would just firstly reinforce the comments of my colleagues, both the Acting Commissioner and Deputy Commissioner, just in terms of that there is significant risk in discussing anything related to the security arrangements for our undercover program officers in a public forum such as this, and it may jeopardise and place our members, not just the ones that you're referencing but other members, at greater risk, plus also compromise methodology. So that is why we won't talk to specifics in relation to our officers in relation to the undercover program.
Ms Gale, I've already conceded that. My point is, there is conduct that's quite evident from very senior levels of AFP that are aware of unsafe circumstances presented to previous members. And over the years of raising questions about this, I've not heard one single thing that says it's being addressed and their safety is being looked after.
Senator, I would say that we consider the safety of all of our members.
Yes, I've heard that before, but no actions. It's easy to sit here and say that, but what are you doing?
Not have undercover, like, police? Like, I don't. Sorry. You're asking the same questions.
Commissioner?
And giving the same answers because.
Senator, what I can say to you is that we do regularly undertake risk assessment processes to consider potential threats to our officers, and I can give you every assurance that that is an ongoing process and one that has been occurring within the context of the officers you're referring to.
Not according to the evidence, but thank you, Chair.
Thanks, Senator Van. Senator Rennick, you've got a...
Hi guys, how you going? Look, I just want to refer you to ASIO's annual threat assessment as presented by the head of ASIO, Mr Mike Burgess, in February this year. Mr Burgess announced that a former Australian MP had betrayed Australia to a foreign intelligence agency. Are you aware of that?
Senator, I'm aware of the speech that the Director General gave, yes.
Okay, so you received earlier this year a criminal complaint from a Brisbane barrister on the 5th of July 2024, where it was alleged that the MP had breached section 142(2) of the Commonwealth Criminal Code, and I have tabled that. I'm not sure if you've got a copy there or not.
I do not. No.
But effectively, it says that a public official commits an offence if the official engages in conduct with the intention of obtaining a benefit for himself or herself. Now, I'm in touch with this barrister and he says that after 4 months you've